ಕೊಡಿ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಡಿ, ಅಡ್ಮಿಷನ್ಸ್ಗೆಲ್ಲ ಕೊಡಿ. 21. ನೋಡಿ ಮೇಡಮ್, ಅದು ಯಾಕೆ ಪುಟಪ್ ನೋಡಿ, ನೋಡಿ ಮೊದ್ಲು ಮೆಮೋ ಕೊಟ್ಟಿದಾರ ಅಂತ ನೋಡಿ ಮಾಡಿಸಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ. ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು ಆಮೇಲೆ ಮೆರಿಟ್ ಮೇಲೆ. ಈಗ ಮೆಮೋ ತಗೊಳ್ಳಿ, ಪೋಸ್ಟ್ ಮಾಡಿಸಿ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಕ್ ಹೇಳೋಣ ಅವರಿಗೆ. ಏನು ವೆಕೇಟಿಂಗ್ ಹಾಕಿದ್ದೀರಾ ಅಥವಾ ಕೊಡಿ ಮೆಮೋ ಕೊಡಿ. ಟ್ವೆಂಟಿ ಮ್ಯಾಟ್ರ್ ಇದುವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಮೂವ್ ಮಾಡಿದೆ 23ರಿಂದ 25ರವರೆಗೆ. ಈಗ ಅರ್ಜೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡೋರಿಗೆ ಕಾಯ್ತಾ ಇದ್ದು ಈಗ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ನೋ ಅರ್ಜೆನ್ಸಿ. ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಬರಲಿ, ಪೋಸ್ಟ್ ಮಾಡಿಸಿ. ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಬರಲಿ. ಕೊಡಿ. serial number 48. ಹೇಳಿ ಏನಮ್ಮ? MSA of 24, no adjournment. ತೊಗೊಳ್ಳಿ. ಯಾಕೆಂದ್ರೆ ಆರ್ಡರ್ 6 ರೂಲ್ 17 ಅಲೋ ಮಾಡಿ ಇನ್ಕ್ಲೂಡ್ ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ರಿಮೈಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಯಾರಾಗ್ಲಿ ನೀವು ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ. ಐ ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್, ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್, ದಟ್ಸ್ ಆಲ್. MSA ಎಲ್ಲ ಏನ್ರಿ? MSA ನಲ್ಲಿ ರಿಮೈಂಡ್ ಆರ್ಡರ್ ಮಾಡಿರ್ತಾರೆ. ಆರ್ಡರ್ 6 ರೂಲ್ 17 ಹಾಕಿದ್ದಾರೆ, ಅದನ್ನ ಅಲೋ ಮಾಡಿದ್ದಾರೆ, ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಫೈಲ್ ಇಲ್ದವ್ರು ನಾನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆ ಕೋರ್ಟ್ ಫೈಲ್ ಕೊಡ್ತೀವಿ, ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಕೋರ್ಟ್ ಫೈಲ್ ಅನ್ನು. ಅಸಿಸ್ಟ್ ಮಾಡಿ. ಐ ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್, ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್, ಡೋಂಟ್ ಸೀಕ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಏನ್ ಚೇಂಜ್ ಆಗಿದೆ? ಅಲ್ಲ ರೀ, ನಾವು ಓದ್ಕೊ ಬಂದಿರ್ತೀವಿ, ನೀವ್ ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತೀರಿ ಅಡ್ವೊಕೇಟ್ಸ್? ಹೌ ಮೆನಿ ಟೈಮ್ಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ರೀಡ್ ದಿ ಪೇಪರ್ಸ್? ನಮ್ ಕೋರ್ಟ್ ಫೈಲ್ ಕೊಡ್ತೀವಿ, ಓದಿ. ಮಧ್ಯಾಹ್ನ ತಗೋತೀನಿ 2:30ಗೆ, ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್. ಮಧ್ಯಾಹ್ನ ಕೊಡ್ರಿ, ಲಂಚ್ ಬ್ರೇಕ್ ಅಲ್ಲಿ ಅವರಿಗೆ ಫೈಲ್ ಕೊಡಿ, ಕೋರ್ಟ್ ಫೈಲ್ ಕೊಡಿ. ರಿಮೈಂಡ್ ಆರ್ಡರ್ ಏನ್ ಇರ್ತದ್ರಿ? ವೆದರ್ ರಿಮೈಂಡ್ ಆರ್ಡರ್ ಇಸ್ ಕರೆಕ್ಟ್ ಆರ್ ನಾಟ್ ಅಷ್ಟೇ ನೋಡ್ಬೇಕಷ್ಟೇ. RSA ಆಗಿದ್ದು ಅಥವಾ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದಿದ್ದು, ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡಾಗಿದ್ದು, ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡೋದಾದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಒಂದು ರಿಮೈಂಡ್ ಆರ್ಡರ್ಗೆ ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡಕ್ಕಲ್ಲ ಅಂದ್ರೆ ಏನು? ಕೊಟ್ಟಿದ್ದೆ ಮಧ್ಯಾಹ್ನ 1:15 ಫೈಲ್ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ, ಮಾಡ್ಲಿ 2:30. ನಿಮ್ ಮ್ಯಾಟರ್ ಮಧ್ಯಾಹ್ನ 2:30 ತಗೊಳ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ 59 ಹೇಳಿ ಏನು? ವೈ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಟೈಮ್ ಕೌನ್ಸಿಲ್? ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ರೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬರಬೇಕು. ನೋ ಡೇಟ್ ಕೌನ್ಸಿಲ್. Judgment is confirmed. Owner of the A scheduled property, possession to the extent of 30 guntas. Ordered hand over the possession within 2 months. That is the order. No adjournment, counsel. No adjournment. Don't insist the court to grant adjournment. That's all. ನಿಮ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಟೈಮ್ ಇಲ್ಲ ಅಂದ್ರೆ ಓದಕ್ ಬ್ರೀಫ್ ತಗೋಬಾರ್ದು. Tell him. No counsel. Only inconvenience in the health ground, and also if any death in the family. Delhi, let him be there in Delhi. You argue, assist the court. That's all. No counsel, no adjournment. ಏನಾಗಿದ್ದಾರೆ ಇದರಲ್ಲಿ? ಕಾಪಿ ಏನು ಇಲ್ಲ, ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಹಾಕಿದ್ದಾರೆ. ಏನು ಅಂತ ಹೇಳ್ರಿ ನೀವು.
serial number 1 please my lord.
ನಿಮ್ದಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾಟರ್.
Yes my lord, first my lord. My lord, ಇದರಲ್ಲಿ operative portion of the order please my lord. Operative portion of the orderly. Consequently, the appellant is directed to pay a fine of rupees 12 lakhs, and out of the complainant is entitled for an amount of 11,70,000 ಅಂತಿದೆ. My lord, ಇದರಲ್ಲಿ appeal was filed by the complainant. ಅದರಲ್ಲಿ acquittal ಆಗಿದ್ದರಿಂದ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ಇದರಲ್ಲಿ ಕಾನ್ಸಿಕ್ವೆಂಟ್ appellant ಅನ್ನೋ ವರ್ಡ್ ಬದಲಾಗಿ accused ಅನ್ನೋದಾಗಬೇಕು my lord, because it is the accused who has to pay the fine amount of 12 lakhs. ಅದು ಫಸ್ಟ್ ಆಪರೇಟಿಂಗ್ ಪೋರ್ಷನ್ 19ನೇ ಪೇಜ್ ಅಲ್ಲಿ
ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಇದೆಯಲ್ರಿ? 19ನೇ ಪೇಜ್ ಅಲ್ಲಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಮಿಸ್ಟೇಕ್?
ಆಮೇಲೆ ಸೆಕೆಂಡ್ ರೋಮನ್ ನಂಬರ್ 2
ಆಗಿದೆಯಾ?
ಅಪಲೆಂಟ್ ಹೋಗಿ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಹಾಕ್ಬೇಕು. ಅದೊಂದು ಅಪಲೆಂಟ್ ಅಂತ ಅನ್ನೋದು ಅಕ್ಯೂಸ್ಡ್ ಆಗ್ಬೇಕು. ಅದೇ ಸ್ವಲ್ಪ ಕೆಳಗಡೆ ಇನ್ನೊಂದು 4 ಲೈನ್ ಕೆಳಗಡೆ ಬಂದ್ರೆ ಮೈ ಲಾರ್ಡ್, ಕಂಪ್ಲೇಂಟ್ is entitled for an amount of rupees 11,70,000 and remaining amount of 30,000 shall be deferred in favor of the state if the appellant fails ಅಂತ ಇದೆ. ಅದು ಅಪಲೆಂಟ್ ಹೋಗಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಹಾಕ್ಬೇಕು ಅಷ್ಟೇ.
ಎರಡು ಕಡೆ ಅಪಲೆಂಟ್ ಅಂತ ಇದೆ.
ಹೌದೌದು, ಎರಡು ಕಡೆ ಅಪಲೆಂಟ್ ಇದೆ. ಒಂದ್ ಕಡೆ ಅಪಲೆಂಟ್ ಹೋಗಿ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಹಾಕ್ಬೇಕು ಅಥವಾ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಎರಡು ಕಡೆಯಲ್ಲೂ ಅಕ್ಯೂಸ್ಡ್ ಆಗ್ಬೇಕಷ್ಟೇ.
ಹೌದು ಮೈ ಲಾರ್ಡ್, ಅಷ್ಟೇ.
How do the appellant counsel and also the counsel appearing for the respondent and counsel appearing for the appellant brought to notice of this court that an error is crept in mentioning instead of accused, and the same is mentioned as appellant in the fourth line of operative portion, and so also in the fourth line of from the bottom, instead of accused, mentioned as appellant, and hence the same is corrected as accused instead of appellant, which has been referred in the operative portion of the judgment, and hence registry is directed to correct the same. ಮೆಮೊ ಮೂವ್ ಮಾಡಕ್ ಟೈಮ್ ಇದೆ, ಫಸ್ಟ್ ಬಂದ ತಕ್ಷಣ ಮೂವ್ ಮಾಡಬೇಕು. ನಾಳೆ ಕೊಡಿ, ನಾಳೆ ಬನ್ನಿ. ಅರ್ಜೆನ್ಸಿ ಏನು? ನಿಮ್ಮ ಅಪೀಲ್ ಯಾವ ವರ್ಷದ್ದು ಹೇಳಿ? ಈ ವರ್ಷದ್ದು. ಅದನ್ನೇ ಹೇಳ್ತಾರೆ, ಈಗಿನ್ನು ಬರ್ಬೇಕಾ? ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿಲ್ಲ. ಆಯ್ತು, ತಗೊಳ್ಳಿ, ನಾಡಿದ್ದು ಹಾಕ್ಸಿ. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪ್ರೂಫ್ ರಿಗಾರ್ಡಿಂಗ್ ಪೇಮೆಂಟ್ ಆಫ್ ಅಪ್ ಟು ಡೇಟ್ ರೆಂಟ್ ಆಸ್ ಪರ್ ದಿ HRC. ಹೇಳ್ರಿ. But court has already determined that there is a jural relationship. You deposit the amount, then we'll consider it. If you succeed in the revision, then you are entitled for refund, or otherwise you are bound to pay the arrears of rent. Last time ನಿಮಗೆ ಹೇಳಿದ್ದೆ ನಾನು, ಮತ್ತೂ ನೀವು ಅದೇ ಏನೋ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಅಂತ ಬಂದಿತ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್. ಇದು ಇನ್ನೊಂದು ಬೇರೆದು, ಅದನ್ನು ಡೆಪಾಸಿಟ್ ಆಫ್ ರೆಂಟ್ಗೆನೆ ನಿಮ್ದೇನೆ ಮ್ಯಾಟ್ರು, ಒಂದ್ ಯಾವ್ದ್ರಲ್ಲೂ ಬಂದಿತ್ತು. I remember, don't test the memory of this court. But ಇದರಲ್ಲಿ ನೀವು ರೆಂಟ್ ಕಟ್ಟಲೇಬೇಕು. ಒಂದ್ಸರಿ court determines that there is a jural relationship between the parties and arrears of rent, you deposit the rent in HRRP, that's all. If you succeed, definitely you are entitled for refund of the amount. Revision petitioner counsel seeks 2 weeks time to deposit the rent amount. This matter on date kodi 24/7. ಹೇಳ್ರಿ, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ 1 to 4 ಎಲ್ಲದಕ್ಕೂ ಸಬ್ಮಿಷನ್ ಏನದು ಹೇಳಿ? Prayer to be stated correctly, details of trial court to be stated at prayer, and agreed para related points to be checked later. Challenging MA and LAC number to be ಹೇಳ್ರಿ ಏನು? Prayer to be stated correctly ಅಂತಿದೆ. ಅದಕ್ಕೇನು ನಿಮ್ಮ ಪ್ರೇಯರ್, ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ ಏನು ಹೇಳಿ? But the delay was condoned by this court. Was there any condition by this court that you are not entitled for? Nothing. But delay was not condoned by the appellate court, but it was condoned by this court only. ಆಯ್ತು, ಅದಕ್ಕೆ ನಿಮ್ ಪ್ರೇಯರ್ ಏನ್ ಕೇಳಿದ್ರಿ? ಪ್ರೇಯರ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಕರೆಕ್ಟ್ಲಿ ಅಂತಿದೆ, ನೀವೇನ್ ಪ್ರೇಯರ್ ಕೇಳಿದ್ರಿ? Set aside the judgment and award passed by the district and session judge Chitradurga in MA number. Allow the appeal by the appellants in MA. ನೀವು ಟೋಟಲ್ ಎಂಟೈರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ, ಅದನ್ನ ನೀವು ಪ್ರೇಯರ್ ಹೇಳ್ಬೇಕು ಅಂತ ಅವ್ರು ಕೇಳಿರೋದು ಆಫೀಸ್ನವರು. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಬರಲ್ಲ, ನಿಮ್ ಪ್ರೇಯರ್ ಮಸ್ಟ್ ಬಿ ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ನೀವು ಪ್ರೇಯರ್ ಏನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳ್ತಾ ಇದ್ರೆ ಅದನ್ನೇ ಹೇಳ್ಬೇಕು ನಿಮ್ ಪ್ರೇಯರ್ಲಿ. ನೀವು ಎಂಟೈರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಅವಾರ್ಡ್ ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದಿರಿ. It goes against you. That's the only office objection as raised. So the counsel submission in respect of the prayer is concerned is not accepted. ಬೇರೆದೆಲ್ಲ ಏನು ಹೇಳಿ ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡ್ರಿ ಯಾಕೆ ಸುಮ್ಮನೆ ಟೈಮ್ ಇರೋದೆಲ್ಲ ಏನಿದೆ ಕರೆಕ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬಿಡಿ ಅಷ್ಟೇ. ಎಷ್ಟು ಸಭೆ ಕೇಳಿ. 2 weeks time granted to comply with office objection number 1 to 4. Nim prayer must be specific. List this matter date kodi madam. 24/7. Joseph Anil Kumar. ನೋಡ್ರಿ ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿದೆ ನೋಡ್ರಿ, ನೋಟಿಸ್ ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿದೆ ನೋಡಿ. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಹಾಕಿದಾರ ಮಾಡಿದಿರಾ? Counsel submits that counsel's filed memo. Appellant counsel filed memo stating that this court has issued hand summons to respond number 1 and the same has been served and the copy of the acknowledgement is also furnished along with the memo. Elide signature? Thumb impression. Ida illi right side. And the same was served on 5/7/25. The court in the hogid notice ಏನಾಗಿದೆ ಮೇಡಮ್? And the same is taken on record. 5/7 ಇವತ್ತಿನ್ನು 3 ದಿವಸ ಆಗಿದೆ ಅಷ್ಟೇನೆ. 3/7 ಅಲ್ಲಿ ಹೋಗಿದೆ. ಬಟ್ ಈಗ ಸರ್ವಿಸ್ ಆಗಿದೆ ನೋಡೋಣ. ಒಂದು 10 days time given to the respondent. ಎಷ್ಟು R1 R1 either to appear in person or engage the counsel. List this matter on 2 ವಾರನೇ ಕೊಟ್ಬಿಡಿ 24/7. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಲ್ರೆಡಿ ಹಾಕಿದಾರ? ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ? ಇದೇನು ಓನ್ಲಿ ರಿಮ್ಯಾಂಡ್? ಇದು ರಿಮ್ಯಾಂಡ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ? ಮತ್ತೆ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಎನಾನ್ಸ್ಮೆಂಟ್ಗೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಏನಾರು ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಯಾವಾಗಿದೆ ಡೇಟ್? ಬಟ್ ಮಂಡೇ ಆದ್ರೆ ಅವ್ರು ಬರ್ಬೇಕಲ್ರಿ. ಅವ್ರು ಜಾರಿ ಆಗಿರೋದು 5ನೇ ತಾರೀಕು, ಇವತ್ತಿನ್ನು 9ನೇ ತಾರೀಕು. ಕೌನ್ಸಿಲ್ಗೂ ಮಾಡಿದಿರಾ? ಆಯ್ತು. And also counsel submit that he has already served the counsel on record and hence list this matter next Monday Tuesday ಕೊಡಿ 15/7. Memo reporting death of R5. 2 weeks time granted to bring the LRs of R5. Memo filed for dispensation of notice to R13 is allowed and notice is dispensed at the risk of the appellant. Next. ಏನಂತ ಮೆಮೋದಲ್ಲಿ ಏನೋ ಈ ಮೆಮೋ ರಿಪೋರ್ಟಿಂಗ್ ಡೆತ್ ಅಲ್ಲಿ ಏನಾರು ಹೇಳಿದಾರ? ಯಾರು ಆಲ್ರೆಡಿ LRs ಇದಾರೆ ಅಂತ ಕೊಡಿ ಹೋಗಿ. Counsel appearing for the appellant filed memo stating that R5 is no more and her legal representatives are already on record as respond number 6 and 7 and memo is accepted and appellant counsel is directed to amend the cast title and file amended cast title in terms of the memo. ಅಷ್ಟೇ. and notice dispensed ಅದಿರ್ಲಿ ಆರ್ಡರ್. list the matter on 24/7. ಅಡ್ಮಿಷನ್ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಲಿ. ಏನು ನೆಕ್ಸ್ಟ್? ಚಂದ್ರಕಾಂತ್ ಆರ್ ಪಟೇಲ್. Needful is done. Counsel submits that needful is done and hence issue notice against the respondent. Non taking of steps in respect of deceased sole respondent. ಏನು ಗೌರ್ಮೆಂಟ್ ಹೇಳ್ರಿ? ಟೇಕನ್ನ ಯಾವಾಗ? 21st October 21 ಸತ್ತೋಗಿದ್ದಾರೆ ಮೇಡಮ್ ಸೋಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅವ್ರದ್ದು ವಾಪಸ್ ಬಂದಿದೆ. ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು. ಹಿಂದಿನ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಎಲ್ಲಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ? ಮತ್ತೆ ಸ್ಟೆಪ್ಸ್ ಟೇಕನ್ ಅಂದ್ರೆ ಅಟ್ ರಿಕ್ವೆಸ್ಟ್ 2 weeks time is granted to do the needful in the matter. ಏನ್ ರಿಕ್ವೆಸ್ಟ್ ಏನಕ್ಕೆ ಮೇಡಮ್ ಇದು? ಆಗ್ಲೇ ಸತ್ತೋಗಿರೋದು ರಿಪೋರ್ಟ್ ಆಗಿದೆಯಾ? ಇಶ್ಯೂ ಟು ದಿ ಸೋಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ ಸರ್ವ್ಡ್ ರಿಟರ್ನ್ ವಿತ್ ಪಾರ್ಟಿ ಡೆತ್ ಅಂತ. ನಿಮ್ದು ಫೈಲ್ ಡೆತ್ ಈಗ 21 ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿರೋದು. ಟಿಲ್ ಡೇಟ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್ ಎನಿ ಸ್ಟೆಪ್ಸ್. ಅವಾಗ 2 weeks ಟೈಮ್ ಕೇಳಿದಿರಿ. For a period of 4 years, you have not taken any steps. Third, in spite of this court granted time to bring the LRs of sole respondent since the death was reported on 21/10/21 and on 15/11/21 granted 2 weeks time but not taken steps, and hence appeal is dismissed as abated. ಯಾವಾಗ ಹಾಕಿದಿರಿ ಮೇಡಮ್? ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಹಾಕಿದಿರಾ? ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಅಷ್ಟೇ, ಮುಗೀತು. 4 ವರ್ಷ ಹಾಕದೆ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ? ಇರೋ ಕೇಸ್ ಡಿಸೈಡ್ ಮಾಡಕ್ಕೆ ಟೈಮ್ ಇಲ್ಲ. ಇದ್ರಲ್ಲೇನು perusal of intimation delivered, the notice issued against R2 was returned with an endorsement not claimed, and on perusal of the postal shara, intimation is delivered and not claimed, and hence held sufficient against R2. What about R4? Already taken. Council submit that PF paid issue notice against R4, and hence issue notice against R4. Returnable by date kodi 11/8. Murli BS non filing of paper book. ನೋಡಿ, ಏನಾರು ಮೊದಲೇನಾರು ಟೈಮ್ ಕೊಟ್ಟಿದೆಯಾ ನೋಡಿ. ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ ಬಂದೇ ಇಲ್ವಾ? ಬಂದಿಲ್ಲ. ತಗೊಳ್ಳಿ. While admitting the appeal, 8 weeks time granted to file paper book, until date not filed paper book. However, in the ends of justice, another 4 weeks time finally granted to file paper book. List the matter on 11/8. Counsel is absent antaki. K.R. Lingaraju.
Lord, I appeared, my lord.
ಹೇಳಿ.
Previous matter, lord, I'm sorry.
Previous ಆಗೋಯ್ತು. 4 weeks.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಆಯ್ತು.
4
Sorry,
weeks.
there's some please, my lord.
ಅದರಲ್ಲಿ
Absence ಅಂತ ಆಗಿತ್ತು.
ಕೌನ್ಸಿಲ್
Absence ಅಂತ ಆಯ್ತು.
ಅಬ್ಸೆಂಟ್ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, ಇದು ಮ್ಯೂಟ್ ಆಗೋಗಿತ್ತು ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ ಸಾರಿ.
ಅಬ್ಸೆಂಟ್ ಅನ್ನೋದು ತೆಗೆದ್ಬಿಡಿ ಅಷ್ಟೇ. ಹೇಳ್ರಿ.
Oblige, my lord. Sorry.
PF ಕೊಟ್ಟಿದ್ದೀರಾ? 1 week time granted to pay PF. If PF paid within 1 week, issue notice against R2, R6, R9. If PF not paid within 1 week, list this matter for dismissal against R1, R2, R6 and R9. R9 ಇದ್ದಾರೆ. R1 ಗ ಹಂಗಾರೆ R1 ಗೆ ನೀವು PF ಕೊಡೋದು ಬೇಡ ಮೇಡಮ್, ತೆಗೆದ್ಬಿಡಿ. ಕೌನ್ಸಿಲ್ ಶ್ರೀ ನಾರಾಯಣ್ Mayer undertakes to file wakalat for R1, and hence appellant counsel is directed to serve the copy of the appeal memo on the counsel forthwith. If PF paid against R2, R6, R9, issue notice. If not paid within 1 week, list the matter for dismissal. Date kodi. R3 deceased irli first ನಾನು ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಆಗ್ಬೇಕಾ? Shara has deceased in R3. ಅದಕ್ಕೆ 2 weeks time granted to bring the LRs of R3. Apparent counsel is directed to verify whether Nalina is an adult member of the family of R7 and submit. ಒಂದು ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ, PF ಕೊಡಿ, ಹೋಗ್ಬೇಕಲ್ಲ ನೋಟಿಸ್. ಮತ್ತೆ ಇನ್ನೇ ಅದಕ್ಕೆ ಆಯ್ತು. PF paid ಅದನ್ನ ಹಾಕ್ಬಿಡಿ 2 weeks LR ಅಪ್ಲಿಕೇಶನ್. ಈಗ ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ R2, R6, R9 ಗೆ ರಿಟರ್ನಬಲ್ ಬೈ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನಾಗಬೇಕು? ಅದು ಸೇಮ್ ಅಲ್ವಾ? ಅದ್ರಲ್ಲಿ ಯಾರು? ಅಬೂಬಕರ್ ಶಫಿ. ಹೇಳಿ ಮೇಡಮ್, ಹೇಳಿ. R3 ನೀವು 2 weeks ಅವರಿಗೆ 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ, ನಿಮಗೂ ಅಷ್ಟೇ 2 weeks time granted to bring the LRs of R3. R4 refused, hence held sufficient. Appellant counsel is directed to pay PF to issue notice against R2 and R9 in RSA number 168 of 22. If PF paid, issue notice. ಯಾವುದು? ಬಟ್ ಇದು ಪ್ರೋಸೆಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಬರಲಿ. ಈಗೇನ್ ಮಾಡಕ್ಕಲ್ಲ. ಏನ್ ನಾನ್ ಫೈಲಿಂಗ್ ಇದೆ? ಪೇಪರ್ ಬುಕ್ ಹಾಕಿಲ್ಲ ನೀವು. 4 weeks time granted to file paper book finally. ಹೇಗಿರು ಸರ್ವಿಸ್ ಆಗಬೇಕು 4 weeks. PF ಕೊಡ್ರಿ. ನೀವು ಮಲಗದವ್ರನ್ನ ಎಚ್ಚರಿಸ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇನೆ. ಯಾಕೆ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ನೀವು 1 week ಇಲ್ಲಿ ಟೈಮ್ ತಗೊಂಡು ಹೋಗ್ತೀರಿ, ಮತ್ತೆ PF ಕೊಡಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ ಡಿಸ್ಮಿಸಲ್ಗೆ ಅಂತ ಇಟ್ಟಾರು PF ಕೊಡ್ತೀರಿ ಅಂತ ಆ ಒಂದು ಉದ್ದೇಶದಿಂದ ಮಾಡ್ತೀನಿ ನಾನು ಅಷ್ಟೇ. ನೀವು PF ಕೊಟ್ರೆ ಮುಗಿದೋಯ್ತು. ನೀವು ನೋಡ್ತಾ ಇದ್ರಿ ದಿನ ನನಗೆ ಬೆಳಗ್ಗೆ 1.5 ಗಂಟೆ ಪ್ರೀಸಿಯಸ್ ಟೈಮ್ ಹೋಗ್ತಾ ಇದೆ ಬರೀ ಈ ಕೆಲ್ಸಕ್ಕೆ. ನಾನು ಅಟ್ಲೀಸ್ಟ್ ಫೈಲ್ಸ್ ಗಳು ಕೋರ್ಟ್ ಮುಖಾನಾರು ನೋಡ್ಲಿ ನಮ್ಮ ರೋಸ್ಟರ್ಲಾದ್ರು ಅಂತೇಳಿ ನಾನು ಎಲ್ಲಾನು ಹಾಕ್ಸ್ಕೊಂಡ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನಮ್ಗೆ 1.5 ನೋಡಿ ಈಗ ಆಗ್ಲೇ ಅರ್ಧ ಗಂಟೆ ಆಯ್ತು, ಇನ್ನು 1 ಗಂಟೆ ಬೇಕು ಈ ಬರೀ ಮಿಸ್ಲೇನಿಯಸ್ಗೆ. ಹೇಳಿ ಮೇಡಮ್. 2 weeks time granted to bring the LRs of R2 and R6. List this matter. Date ಕೊಡಿ ಮೇಡಮ್, ಇಲ್ಲ ಬರಲ್ಲ ಇದು ಎಲ್ಲ 21 matters. 24/7. List this matter on 24/7. Non-furnishing of PF to issue emergent notice to respondent. ಹೇಳಿ.
Back the papers from me, my lord, from the office. In fact,
acknowledgement ಹಾಕಿದೀರಾ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ, ಅದಕ್ಕೆ ಮೆಮೊ. Lordship may kindly grant me a week's time. I have also informed him over phone.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರೋದು 28/7
ಅದಾದ್ಮೇಲೆ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ರು ಅವರು.
ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು?
1 year ಆಗಿದೆ. I have also informed him.
ಇದಾಗಲೇ 2 years ಆಯ್ತು.
ಅದೇ ಆಮೇಲೆ ಬಂದು ತಗೊಂಡು ಹೋದ್ರು ಫೈಲ್ಸ್.
ಕೊಡಿ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ ಸರ್. I will file it.
Council is directed to place on record the acknowledgement for having party has taken back the brief.
Please.
And list this matter on ಯಾವತ್ತು? 24/7.
Please.
2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
Please. Most.
Needful done.
ಚಿದಂಬರ.
Needful done, madam. I have
Council
read
submits that needful is done and hence issue notice against the respondents.
Needful is done in this, my lord, sir.
14 also needful done na?
My lord.
Council submits that needful is done and hence issue notice against R2 to 5, R7 to 9. Mohan Kumar G. 5 to 7. PF ಕೊಡ್ಬೇಕು ಹೇಳ್ರಿ.
Lord's PS party 5 to 7 are not formal
R4
parties.
refused and held sufficient. Party?
They are not formal parties, my lords. This appeal is filed against item number 3 of the scheduled property, which is the Sweden
Council
property.
PF ಬೇಕೋ ಬೇಡವೋ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿಸ್ಕೊಳ್ತೀರಾ ಹೇಳಿ.
We'll file necessary
ಮಾಡಿ,
application
memo
to
ಕೊಡಿ.
dispense. Please,
Pass over.
please. Great.
16. Complaints of office objection raised on IA 1 of 25. Weeks time granted. Recalling ಏನೇ complaints ಇದೆ ಮೇಡಮ್. To comply with office objections on IA number 1 of 25. Next. Office objections comply ಮಾಡ್ಬೇಕು ಅದ್ರ and also to comply with office objections on main. ಕೊಡಿ, ಒಂದು ವಾರ ಅಂದ್ರಲ್ಲ. 17/7. 17 ಸಂಪತ್ತಿ ಹೇಳಿ.
My lords, I request a week's time.
7th time ಏನ್ರಿ ಇದು?
ಅದು we are discussing for a settlement.
Possession already taken.
My lords, now
Then it becomes infructuous.
my lords, we have been discussing for a settlement for last 2 years. If my learned friend says
Possession ತಗೊಂಡ್ಮೇಲೆ ಯಾರಿಗೆ ಬರ್ತಾರೆ settlement ಗೆ?
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, the society has formed a layout and sold the proper sites, my lords, to various persons. Therefore, my lords, I requested the respondent council to
Sir,
settle.
ಈಗ already decree is enforced.
My lords,
What is there?
it decrease. My lords, if my learned friend says
ಬಟ್ ಅವ್ರ ಪ್ರಕಾರ ಮಾಜರ್ ಇದೆಯಂತ ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. ಅಲ್ಲ, ಡೆಲಿವರಿ ಆದ್ಮೇಲೆ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ?
ಅಲ್ಲ, ಅವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ
let the court decide on the objector's application. That's all in execution. Why we have to keep this second appeal? I3, if you succeeds in the objector's application, you take back the possession. That's all.
my lords, in fact,
If possession already been delivered, nothing is there to decide. Yen accepted.
Possession was taken on 29/2024. A bill was filed
was pending. This appeal was pending. Pendency of this appeal, already possession was taken.
Suit is of the year 1980.
1980.
1980.
Hmm.
My lord, the appellant is the purchaser from the person who had no title. In the year 2006, he purchases.
Hmm.
In the year 2014, he forms the layout.
Hmm.
And these applicants now file an application for including in this appeal. And they file an application before the trial court in execution proceedings. I had reported that the possession is taken and that court has passed this has taken this R2 of record.
Possession taken ಆದ್ಮೇಲೆ ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅವರು?
Because they say, my lord, these applicants, they have stated before the court that
Executing court.
executing court.
Whether they were already party in execution petition, after taking up the possession only, they filed an application
They don't have independent right. They claim that right
through the appellant, that's all.
Then Article 2197 also is not the application.
Hmm.
My lord, any observation made by this honorable court, that the court will decide all this, also have an impact on this. My lord, 1980, I filed a petition and as an individual person, permission was granted. My lord, the suit was finally disposed of in the year 2018 because
2018.
2018 because the form number 7 that was pending before the land tribunal order was set aside in the year 2011 in a writ petition. After that, after the disposal of the writ petition, the appellant who was not a party to the writ petition files a writ petition. That writ petition was heard and it came to be dismissed in 2022. Now 2022 this appeal is filed. And during the pendency of it, they have not seen this article court. And the execution petition was filed. They were served in the execution petition. And the position is taken, delivery is ordered, position is taken. Now they again say that they need to be heard.
My lords, may I just,
They have sold the property. 625, they responded on 5 and 6, and they have sold the property.
my lords,
3625. After taking the possession, they have already sold the property. You can pursue the remedy if, I don't know whether you have been impleaded or not in the execution petition, but as on the date of issuance of delivery warrant, you are not the party.
Before Maja, we have already objection of the petition.
Hmm.
Thereafter, the father was not appointed. There is a-
My lord, the objection was filed.
First of all, you have no locus to appear before the, in execution court. Because you stepped into the shoes of only the appellant. Appellant has already suffered an order. And now it is executed also, enforced.
Position is concerned that 220 people are
According to them, they are in possession of the property. If they are having any grievance with regard to the possession through the court execution, they have already taken possession. That's all.
my lords,
This second appeal become infructuous in view of enforcing of. You pursue there, that's all. You pursue there. ನೀವೇನು ಹಾಕಿದಿರ ಡೆಲಿವರಿ ಆಫ್ ಪೊಸಿಷನ್
Allow me just-
ಡಾಕ್ಯುಮೆಂಟ್
can I just make one submission? my lord?
ಹೇಳಿ.
My lords, can I just make one submission? My lords, until yesterday, my lords, learned friend was saying we will settle the matter. Today, my lords is making vociferous argument. Allah, I'm sorry, I just need to,
Also know that the property is of
ನೀವು ಸೆಟ್ಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರ ಅವ್ರಿಗೆ?
my lords, they have been meeting, the directors,
settle
Allah,
ಮಾಡ್ತೀವಿ?
directors,
I am not.
ಹಾ.
His representative was in discussion with the owner.
Owner. Ah.
They had said no.
my lords, that is
They were
absolutely,
insisting
Ah.
after the possession was taken. Kindly see.
my lords, may I just make one submission, my lords? My lords, against the order passed in the writ appeal,
ಆಯ್ತು, ರಿಟ್ ಅಪೀಲ್ ಅಗೇನೆಸ್ಟ್ ಆರ್ಡರ್ ಏನಾಯ್ತು?
my lords, SLP ಹಾಕಿದೀವಿ.
ಏನಾಯ್ತು?
My
SLP
lords, it's
ನಲ್ಲಿ
getting
ಏನಾದ್ರು
listed,
ಇದೆಯಾ?
my lords, it's getting listed after 14.
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
Because of
ಯಾವಾಗ
the
ಅದು 22 ನಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್
24 ಅಲ್ಲಿ ಹಾಕಿದೀವಿ.
22 ನಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್
24 ಅಲ್ಲಿ ಹಾಕಿದೀವಿ. My
22
lords,
order ನ
my lords,
24
only
join
submission is, my
ಮಾಡಿದ್ದೀರಾ?
lords, now, my lords, my only submission.
In possession of his property, they find SLP.
Hmm.
It is still in their diary, it's only diary number which is available. That was filed in 2024.
Hmm.
Not taking possession of the.
Let's, I'm only requesting for a week's time. Let's, after a week,
ಮತ್ತೆ ನೀವು ಪೊಸಿಷನ್ ತಗೊಂಡಿರೋದ್ ಬಗ್ಗೆ ದಾಖಲೆ ಹಾಕಿರೋದು ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಹಾಕಿದಿರಿ?
It is dated 4/11/2024.
4/11/24.
24. Counter affidavit of objection.
11/11 ಎಲ್ಲ 11/11 ಇದೆ. ಎಲ್ಲ 11/11.
I have a copy of it. Now, put the after serving copy to the other side.
4/11.
Yes.
ಹಾ.
Now, today
Counter affidavit filed by way of objection to A number 1.
yes. When they see connection R2. Page 25.
Page 25. ಹಾ.
ಸ್ವಾಧೀನ ಮಾಸಪಟ್ಟಿ execution number so and so.
ಹ್ಮ್.
Is ಸನ್ 2024 ಇಸ್ವಿ ಅಕ್ಟೋಬರ್ 1ರಂದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದ್ದು. All this is said and possession was page 26. Page 26.
ಹ್ಮ್.
ಅಲ್ಲಿ ಬಾಟಮಿನ 5-6 ಲೈನ್ ಇದೆ. ಸರ್ವೆ ನಂಬರ್ 156ರಲ್ಲಿ 5 ಎಕರೆ ವಿಸ್ತೀರ್ಣದ 151ರಲ್ಲಿ 4 ಎಕರೆ 38 ಗುಂಟೆ ಒಟ್ಟು 9 ಎಕರೆ 38 ಜಮೀನನ್ನು ಸದರಿ JDR ನಂಬರ್ 3 ಮೆಸರ್ಸ್ ಟೆಲಿಕಾಂ ಎಂಪ್ಲಾಯೀಸ್ ಕೋಆಪರೇಟಿವ್ ಹೌಸಿಂಗ್ ಸೊಸೈಟಿ ಲಿಮಿಟೆಡ್ ಸದರಿ ಜಮೀನು ಸೈಟ್ಗಳು ಮೌಲಿಕರು ರಸ್ತೆಗಳು ರಸ್ತೆಗಳಾಗಿ ವಿಂಗಡಿಸಿದ್ದು ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಸದರಿ ಯಾವುದೇ ಮನೆಗಳು ಇರುವುದಿಲ್ಲ. ಸದರಿ ಜಮೀನನ್ನು ವಾದಿ ಗುರುತಿಸಿದ್ದು ನಂತರ ಇದೇ ಜಮೀನು ಎಂದು ವಾದಿಗಳು ಪಂಚಾಯತ್ ಅಜಮಾಯಿಸಿ ನೋಡಲಾಗಿ ನಮೂದಿಸಲಾಗಿರುವ ಸ್ಥಿರ ಸ್ವತ್ತು ಜಮೀನು ಸರಿಯಾಗಿ ಕಾಲ ಇದ್ದು ಇಲ್ಲಿ ಉಳ್ಳ ಸ್ಥಿರ ಸ್ವತ್ತು ಜಮೀನನ್ನು ವಾದಿಯವರಿಗೆ ಸ್ವಾಧೀನಪಡಿಸಲು ಜಮೀನಿನಲ್ಲಿ ಸಂಜೆ 4 ಗಂಟೆಯವರೆಗೂ ಜಮೀನಲ್ಲಿ ಕಾದು ಕುಳಿತು ನೋಡಲಾಗಿ ಅಕ್ಕಪಕ್ಕದ ಜಮೀನಿನ ಬಗ್ಗೆ ಉಳಿದವರಿಗೆ ತಿಳಿಸಿದ್ದು JDR ಅಥವಾ ಅವರ ಪರವಾಗಿ ಯಾರು ಬಾರದ ಕಾರಣ ಗೈರು ಹಾಜರು ಇರುವುದರಿಂದ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ THR ಕಾಪಿಗೆ ಸದಸ್ಯರು THR ವಾದಿಯವರಿಗೆ ಸ್ವಾಧೀನಪಡಿಸಲಾಯಿತು ಎಂಬುದಾಗಿ ಬರೆಯಲ್ಪಟ್ಟು ಸ್ಥಿರ ಸ್ವತ್ತಿನ ಮಾಸರ್. With the police protection this was taken. Now next is the receipt.
Hmm.
Page 29.
ಹ್ಮ್.
We declare order as given the receipt. This is also on 1/10/2022. On 2022 ಅಕ್ಟೋಬರ್ 1ರಂದು ಬೆಂಗಳೂರು ನಗರಸಭೆ ಎಸ್ ಶ್ರೀಶೈಲನಾದ ವಾದಿಯಾದ ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ತೆಗೆದುಕೊಂಡ ಸ್ಥಿರ ಸ್ವತ್ತಿನ ಜಮೀನಿಗೆ ಸರ್ವೆ ನಂಬರ್ 153 ಜಮೀನು ಸ್ವಾಧೀನ ಪಡೆದಿರುವ ಕ್ರಮವೇನೆಂದರೆ ಈ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 25 ಸ್ವಾಧೀನ ಅಂದರೆ
ಹ್ಮ್.
ವಾರಂಟ್ ಹುಡುಗರಿಗೆ ಈ ದಿವಸ 1/10/24ರಂದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮಾಸರ್ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಬೇರೆ ಸ್ವಯಂ ವಾದ ನಮ್ಮ ಸ್ವಾಧೀನಕ್ಕೆ
ಹ್ಮ್.
with police protection.
Hmm.
They have taken, they have put, and his applicant before my law have filed an application. The allottees have filed a consumer dispute.
Hmm.
That is pending, that is a separate issue. They have filed against the appellant.
ಹ್ಮ್.
And his appellant Out of this 938, if these people have any period, they have to go in and there are sites even now. I am not concerned. I am concerned with my property, for which I am filing for 45 of years.
Lords, I just request 10 days time, Lords. The matter is likely to
ಏನಕ್ಕೆ ಹೇಳ್ರಿ?
Lords, the matter is likely to be listed before the Honorable Supreme Court. Lords, writ appeal,
ನೀವು
Lords.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋವರೆಗೂ ನಾವು ಇಲ್ಲಿ ಕಾಯ್ತಾ
Lords, we were
ಕೂತ್ಕೊಳ್ಳೋಕ್ಕಾಗಲ್ಲ.
discussing.
According to you, it
Lords,
was
it's
filed in
unfortunate. It
2024
is unfortunate, my Lords, he makes a submission. It's not, my Lords, my client has met him last week also. If he, my Lords, makes a submission that he has not met, I'm sorry, my Lords, I cannot produce
He
proof.
says he's come.
My Lords, I have spoken to him hundreds of times in the corridor whenever I met. To Mr.
Counsel.
How though?
Ah.
My Lords, I have been speaking. No, if he says he is not. I have spoken to him.
Continuously talks were going on, but they never agreed to give his property.
My Lords, we agreed to give 8 crores, my Lords, to them. We agreed to give 8 crores. They, my Lords, went on saying that sisters have to consent. My Lords, that is why, my Lords, the matter was not moved. My Lords, this submission, my Lords, I'm making is not dehotes my learned friend's knowledge. Every day when I meet him in the corridors, I say, Ariga sir, 200 jana site ತಗೊಂಡಿದ್ದಾರೆ. ಅವರು ಕಾಪಾಡಿ ನಮಗಲ್ಲ.
Just ಒಂದು 10 days ಕೊಡೋಣ, ಏನಾದ್ರು ಮಾತಾಡೋಣ.
What happened? Nothing would happen.
220 sites is not correct, 98 sites.
In your property, in 9 acres ಅಲ್ಲಿ 9 acres and odd.
And it is my property, 45 years of hot topics.
So appellant counsel submits that parties are negotiating for settlement and seeks 10 days time. And counsel for the respondent, one submits that 1 and 2 alla 1 to 5, 1 to 5. ಬರೀ 1 ಮಾತ್ರ ತೋರಿಸಿದಾರಲ್ರಿ? 1 and 2 ಮಾತ್ರ ನೀವು ಕೇವೇಟ್ ಹಾಕಿದಿರಿ. ಯಾರ ನಂದೀಶ CB ಅವರು ಕೇವೇಟ್ ಅಂತಾರೆ ಇದ್ದಾರೆ. But 1 and 2 ಮಾತ್ರ ಇದೆ ನಿಮ್ದು. 1 and 2 submits that there is no any such settlement, and counsel submits that already possession was handed over in the execution petition, and also counsel submits that fought for 45 years to take the possession, and suit was filed in the year 1980, and earlier also there were writ petitions and also the writ appeal, and the appellants were unsuccessful in all the matters, and question of granting any time doesn't arise. Counsel for the proposed impleading, ಇನ್ನು ನೀವು ಇಂಪ್ಲೀಡ್ ಆಗಿಲ್ವಾ? ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ನೀವೇ ಹಾಕೊಂಡಿದ್ದೀರಾ? ನೀವು ಹಾಕೊಂಡಿದ್ದೀರಿ. Impleading counsel also submits that they are the subsequent purchasers and they are necessary parties, and once the possession ಅದನ್ನ ಆಮೇಲೆ ನೋಡೋಣ, and hence list this matter on 10 ದಿವಸ ಬಿಟ್ ಟೈಮ್ ಕೊಡಿ ನೋಡೋಣ ಮೇಡಮ್. List this matter on if any settlement, no adjournment in the next date of hearing. 21/7. This is matter on 21/7.
23rd, my Lords. 23rd. ಅದು ಮಂಡೇ ಅಡ್ಮಿಷನ್ ಡೇ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಂಡೇ.
You want to
we'll try
an
that.
order not for settlement?
No, my Lords.
The very purpose.
No, my Lords.
Very purpose.
If my learned counts want to say, has been, my Lords, since till yesterday he was saying settlement. Today he comes and makes so much of vociferous arguments. I'm so surprised.
He is disputing your
My
submission.
Lords, correct. Therefore, my Lords, I do not have any words to say. It is most unprofessional. That's what I can say.
And these people who have proceeded against FLA, now they are catching me.
List this matter on 18th.
Allah, I'm sorry, my Lords.
ನೀವು 10 ದಿವಸ ಕೇಳಿದ್ರೆ 10 ದಿವಸ ಕೊಟ್ಟಿದ್ದೀನಿ, that's all.
Can it be on 22nd?
counsel.
Try ಮಾಡ್ತೀನಿ.
10
Next
days
time ನಾನು
ಕೊಟ್ಟಿದ್ದೀನಿ.
argument ಮಾಡಲ್ಲ ಸ್ವಾಮಿ.
You can move the
I will
matter
not
next
argue.
week.
I will not argue on merits.
Supreme Court reopen ಆಗುತ್ತೆ ನಾಡಿದ್ದು ಮಂಡೇ.
I will not argue. My Lords, I will not argue on merits. I will not argue on merits. Kindly have it on 22nd.
18th.
Paper.
Serial number 18.
A paper appellant, my lord. Kindly grant 2 weeks time, my lord.
Why counsel non-compliance?
ಅಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಕ್ಸ್ಪೈರ್ಡ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ 15/9/2023. I have filed 29/1/2024.
IAC non-compliance 24.
ಎಲ್ಲ LR's ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ.
ಆಯ್ತ್ರಿ 24ರಲ್ಲಿ ಹಾಕಿರೋದು. ವಿ ಆರ್ ಇನ್ 25, ಆಲ್ಮೋಸ್ಟ್ 25 ಅರ್ಧ ವರ್ಷ ಆಗೋಯ್ತು.
Kindly grant 1 week time.
Time ನೋಡಿ. Council 2 weeks time and the application was filed in 24 and hence the office objections and there are 4 office objections and hence 1 week time granted. List this matter on date kodi madam 17/8 17/7. Manmohan PN memo dated 3/4/25 for reporting death of R5 R6 R7 ಅದ್ರಲ್ಲಿ ಏನಾರು ಹಾಕಿದಾರ ನೋಡಿ ಮೇಡಮ್, ಯಾರು ಎಲ್ಲಾರ್ಸ್ ಇದಾರೆ ಅಂತ ಏನಾರು
We
ಹಾಕಿದಾರ?
have not received the memo.
ಮೆಮೊ ಹಾಕಿರೋದ ನೀವಾ? ಹಾ R5 R6 R7 ಎಲ್ಲಾರು ಸತ್ತೋಗೋರು. ಸತ್ತೋಗಿರೋದು ಯಾರ್ಯಾರು ಹೇಳ್ರಿ? 6, 7, 8. ವಾಟ್ ಅಬೌಟ್ 5? 5 ಕೂಡ 5 ಇದೆ ನೋಡಿ ನಿಮ್ ಮೆಮೋದಲ್ಲಿ. ರಿಪೋರ್ಟ್ ಕೊಡ್ರಿ, ಮೆಮೋನಾರ್ ಕೊಡ್ರಿ ಹೋಗ್ಲಿ. R5 ಇದೆಯಾ? R5 ಸತ್ತೋಗಿದಾರಾ? ಹಾ 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 ಹ್ಮ್ ಹ್ಮ್ ಹಾ ಅಲ್ಲಿಗ 3 ಜನ ಸತ್ತೋಗೋರೆ. ಅದನ್ನೇ ಅವ್ರು ರಿಪೋರ್ಟ್ ಮಾಡ್ರದು. ಈಗೇನು ಮತ್ತಿಂದ ನಮ್ ಬೇರೆ ಹೇಳ್ತಾರ ಅವ್ರು. ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್
My lordships, we have not received the copy.
R1 ಫೈಲ್ಸ್ ಮೆಮೊ ಕಾಪಿ ಕೊಡ್ರಿ ಒಂದವರಿಗೆ. ರಿಪೋರ್ಟಿಂಗ್ ಡೆತ್ ಮೆಮೊ ಹಾಕಿರೋದಾರ ನೀವೇನಾ? ಯಾರು ನೋಡ್ರಿ, ಕೌನ್ಸಿಲ್ ಯಾರು ನೋಡ್ರಿ. ಆಯ್ತು. R1 ಕೌನ್ಸಿಲ್ has filed memo reporting the death of R5 R6 R7 along with the death certificate. ನೀವು ವೆರಿಫೈ ಮಾಡಿ ಹಾಕೊಳ್ರಿ. ಇನ್ನೇನ್ ಬರೀ ರಿಪೋರ್ಟ್ ಮಾಡಿದಾರ ಅಷ್ಟೇನೆ. ನೆಕ್ಸ್ಟ್ ಏನು LRs ಏನು ಬರ್ದಿಲ್ಲ. And hence appellant counsel is given 2 weeks time to bring the LRs of R5 R6 R7. ಅದು ನೀವು ಮೆಮೋದಲ್ಲಿ ಹೇಳಿಲ್ರಿ? ಹೇಳಿದಿರಾ? ಮತ್ತೆ ನೀವು ಮೆಮೊ ಹೆಂಗ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಅವ್ರು ಲೆಟ್ ದೆಮ್ ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ ಮೆಮೊ. ನೆಕ್ಸ್ಟ್ ಏನು? ಪೆರುಸಲ್ ಆಫ್ ಅನ್ಸರ್ವ್ಡ್ ಕವರ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R5 ಅದೇನ್ ಮೇಡಮ್? ಅನ್ಸರ್ವ್ಡ್ ಡಿಸೀಸ್ಡ್. ಆಮೇಲೆ ಅಷ್ಟೇನಾ? 23/11 ಯಾವ ತೋರ್ಸಿಲ್ವಲ್ಲ. ಕೌನ್ಸಿಲ್ ಫಾರ್ R1 submits that he has filed an application for modification of the earlier order on 23/11/2024 and hence registry is directed to put up the application.
It was dismissed.
List this matter on 24/7. Steps ತಗೊಳಕ್ಕೆ 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. Filing of paper book also. Paper book finally 4 weeks time granted.
Obliged, madam.
ಏನ್ರಿ ಇದು ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಸ್ಟೆಪ್ಸ್ ಹಾಕಿದೀರಾ ಮೇಡಮ್? ಇವತ್ತು ಹಾಕ್ತೀರಾ? AGA submits that going to file application for bringing LRs of deceased R4 in the office. If such applications are filed, put up the same. Next ಇನ್ನೇನು ಮತ್ತೆ? ಹಾ ಹೇಳಿ. ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಸತ್ತಿರೋದು ಯಾವಾಗ ಅವರು? ಒಕ್ಕಲತ್ತ ಅದ್ರಲ್ಲೇ ಮಾಡ್ರಿ. ಈಗ ಒಂದೇ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಎಲ್ಲಾನು ಹೇಳ್ಬೋದು. ಡಿಲೇ, ಸೆಟ್ಟಿಂಗ್ ಅಸೈಡ್ ಅಂಡ್ ಆಲ್ಸೋ ಪರ್ಮಿಷನ್. ಅದ್ರಲ್ಲೇ ಹೋಗಿ ಕರೆಕ್ಷನ್ ಮಾಡಿ ಅಷ್ಟೇ ಹೋಗಿ. ಇಫ್ ಎನಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಹಾ ಹಾ ಈಗ ಅದನ್ನ ಸಿಂಪ್ಲಿಫೈ ಮಾಡಿದೆ. 3 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದ್ ಬೇಡ ಅಂತ. ಅದನ್ನ ಮಾಡಿ ಅಷ್ಟೇ ದಟ್ಸ್ ಆಲ್. ಪುಟ್ ಅಪ್ ದಟ್ ಅಪ್ಲಿಕೇಶನ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. 1 ವಾರ ಬಿಟ್ಟು ಕೊಡಿ. ಇನ್ನೊಂದೇನು? MS ಹರೀಶ್ ಕುಮಾರ್ ಯಾರ್ರಿ?
My lord, I appear for the proposal.
ನಿಮ್ದೇನೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೋಡ್ರಿ.
ಅಲ್ಲ ಅದ್ರೊಳಗೆ IA ಹಾಕ್ಲೇ ಇಲ್ಲ. ಅವರು ಲಾಸ್ಟ್ ಅಕೇಶನ್ IA ಹಾಕ್ತೀವಿ ಅಂತಂದ್ರು. ಅದು ವಕಾಲತ್ತು ತಂದು ಕೊಟ್ರು, ನಾನು ಹಾಕ್ಬಿಟ್ಟೆ. ಅಂಡರ್ ದ ಇಂಪ್ರೆಷನ್ ದಟ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದ ಅಪ್ಲಿಕೇಶನ್.
ಹಂಗಾರೆ ನೋಟಿಸ್ ಹೋಗೋದ್ ಬೇಕಾಗಿಲ್ಲ ಅಲ್ವಾ?
ನೋಟಿಸ್ ಏನ್ ಬೇಡ. IAನೇ ಹಾಕಿಲ್ಲ ಅವರು. ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
ಈಗ ಹಾಕಿದಾರ, ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದಾರ.
ಅದೇ ಅವ್ರು ಹಾಕಿದ್ಮೇಲೆ that can be taken.
AGA is directed to serve the copy of IA on the counsel Sri ಯಾರೋ ಹರೀಶ್ ಕುಮಾರ್ MS for R4 A to C who already filed ವಕಾಲತ್ on behalf of the LRs. ಅದು ಬರ್ಲಿ, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಅಲೋ ಮಾಡೋಣ ಅವತ್ತು. ಲಿಸ್ಟ್ 1 ವಾರ ಟೈಮ್ ಕೊಡಿ. ಅಷ್ಟೊಳಗೆ ಕರೆಕ್ಷನ್ ಮಾಡಿ ಮೇಡಮ್. ಡೇಟ್ 17/7.
For the appellant, my lord. in the
ನಾನ್
last-
ಫೈಲಿಂಗ್ ಆಫ್ ಕಾಸ್ಟ್ ಪೇಡ್ ರೆಸಿಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಪೇಡ್ ದಿ ಕಾಸ್ಟ್ ಹೇಳ್ರಿ.
ಇದರಲ್ಲಿ ರೀಸೆಂಟ್ಲಿ ಐ ಆಮ್ ಫೈಲಿಂಗ್ NOC ವಕಾಲತ್ ಅದರಲ್ಲಿ
ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಾ?
ಪೇ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ರೆಸಿಪ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ಕೊಡಿ ರೆಸಿಟ್.
ರೆಸಿಪ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
ನಾವೇನ್
8/7/2024 ಗೆ ಇನ್ ರೆಸಿಪ್ಟ್ ನಂಬರ್ 1736487 ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ.
8/7/24 ಗೆ
8/7/2024 my lord. ಇನ್ ರೆಸಿಪ್ಟ್ ನಂಬರ್ 1736487.
ಇದೆಯಾ ರೆಸಿಟ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಮತ್ತೆ
ಮೆಮೋ.
ಮೆಮೋನ
ಅಲ್ಲ, ನಾನ್ ಮೆಮೋ ಮಾಡಿದ್ದೆ.
ಮೆಮೋ ಹಾಕಿದಾರ ಮೇಡಮ್?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನ್ ಮೆಮೋ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ.
ಮೆಮೋ ರೆಡಿ ಮಾಡಿದಿರಿ?
ಹೌದು.
ತೊಗೊಳ್ಳಿ, ಕೊಡಿ ಆ ಮೆಮೋ ತೊಗೊಳ್ಳಿ. ಅದಕ್ಕೇನ್ ಪ್ರೆಸೆಂಟೇಶನ್ ಫಾರಮ್ ಏನು ಇಲ್ವಾ?
ಅಲ್ಲಲ್ಲ, ಅರ್ಲಿಯರ್ ಈಗ ರೀಸೆಂಟ್ ಆಗಿ NOC ಹಾಕಿದೆ ಸ್ವಾಮಿ, ವೆರಿಫೈ ಮಾಡಿದೆ.
ರೆಸಿಟ್ ಇಲ್ಲ,
ಅರ್ಲಿಯರ್ ಅಡ್ವೊಕೇಟ್
ವೆರಿಫೈ ಮಾಡ್ಬೇಕಲ್ಲ. ರೆಸಿಟ್ ನಂಬರ್ ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ, ರೆಸಿಪ್ಟ್ ನಂಬರ್ ಇದೆ.
ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪೆಲೆಂಟ್ ಫೈಲ್ಸ್ ಮೆಮೋ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ಕಾಸ್ಟ್ ಆಫ್ rupees 500 imposed on 25/6/24 was paid on 8/7/24 and given the receipt, and hence office is directed to verify regarding payment of cost. ಬೇರೆ ಏನಿದೆ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈಂಟ್?
ಅದೆಲ್ಲ ಕಂಪ್ಲೈಂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ನೋಟಿಸ್ ಹೋಗಿತ್ತು ಸ್ವಾಮಿ.
ಇನ್ನೇನಿಲ್ಲ, ಬೇರೆ ಏನು ತೋರಿಸಿಲ್ಲ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್.
ಅದರಲ್ಲಿ ಸ್ಟೇ ಅಯ್ಯೇ ಇದೆ ಸ್ವಾಮಿ.
on 24/7 ಅಡ್ಮಿಷನ್ ಬರ್ಲಿ, ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. 22
ನೋಟಿಸ್ ಹೋಗಿತ್ತು ಸ್ವಾಮಿ ಉಳಿದವ್ರಿಗೆ.
ಅದೆಲ್ಲ ಆಗಿದೆ ರೀ, ಸರ್ವ್ ಆಗಿದೆ. ನೋಡ್ಬೇಕ್ರಿ ಕಾಸ್ ಲಿಸ್ಟ್ ನ.
ಆಗ್ಬೋದು.
ಎಲ್ಲಾನು ನಮ್ಮನೆ ಕೇಳ್ತಿರಲ್ಲ ಬಂದು. ಕಲ್ಯಾಣ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಂಬರ್ 1 for 4th time.
The parties have settled the
ಏನು?
my lord, we will be reporting settlement. A date may kindly be. Elru ಒಬ್ಬರು party respond, one of the respondent is absent. Therefore, a date may kindly be.
ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್.
Reporting settlement.
Both counsel submit that matter has been settled and going to report the settlement. List this matter on 11/7. ಯಾವ ಎಷ್ಟು ದಿವಸ ಬೇಕು? 21. ಆಯ್ತು, 21/7.
Please, much of.
Non compliance of office objection 3rd time. Total memo moved.
1 week time.
On cost of rupees 500. ಎಷ್ಟು ಒಂದು ವಾರನ 2 ವಾರನ?
1 ವಾರ.
1 week time granted to comply with office objection. List this matter on 18/7. Non filing of any CC.
My lordships,
Proof
I have
of
filed the
appellant court for
valuation
having
slip of
paid
the trial
court fee.
court. Madam, my lordships, I have filed the valuation slip of the trial court, my lordships. That
ಯಾವಾಗ?
same court, with the appeal itself, I have filed, my lordships. It's at page number 39. So the same court fees I have paid, my lordships. They are asking for the any document regarding RA copy, they have asked, my lordships.
RA ನಲ್ಲಿ ಏನ್ ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿದ್ದೀರಾ ಅದನ್ನ
RA
ನೋಡ್ಬೇಕಲ್ಲ.
ದಲ್ಲಿ ಏನು
ಅದರದ್ದು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಹಾಕ್ಬೇಕಲ್ಲ.
RA ದಲ್ಲಿ ಅವ್ರ
ಅಪೆಲೇಟ್
valuation
ಕೋರ್ಟ್ ಅವ್ರು
slip,
ಕೇಳ್ತಾ ಇರೋದು ನಿಮಗೆ.
they have not filed the valuation slip before the RA court, my
ಅಟ್
lordships.
ಲೀಸ್ಟ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಅಪೀಲ್ ಮೆಮೊ ಅದನ್ನೇ ಹಾಕಿ. ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅಪೀಲ್ ಅಲ್ಲಿ ವ್ಯಾಲ್ಯೂ ಮಾಡಿರ್ತಾರೆ ನೋಡಿ.
Yes, my lordships.
Sorry, counsel, instead of complying the office objections, moved the memo before the court and hence on cost of rupees 500. ಒಂದು ವಾರನ 2 ವಾರ ಬೇಕಾ?
2 weeks make.
2 weeks time granted. List this matter on 24/7. Comply ಅಂತ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. Next, non compliance of office objection 3rd time.
My lord, will comply course of the day. Application is proper schedule, it's ready. Will comply within the course of the day.
ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
ಇವತ್ತೇ.
Counsel submit that going to comply with during the course of the day. If complied, list this matter for admission on 24/7. B.S. Mahendra, dismissal of appeal for non-furnishing.
paid, my lord.
Paid, counsel submit that PF paid. Issue notice against the respondents with order dated 1/7/25. 11/8, 11/8. Non-compliance of office objection 1st time.
Appearing for the appellant, my lord.
Non-arraying of defendant number 1.
Defendant number 1 is no more. Defendant number 2 is his son.
ಅವ್ನ ಸಣ್ಣನ್ ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ?
Yes, my lord.
ನೋಟ್ ಹಾಕಿದೀರಾ?
Yes, my lord.
Counsel submission regarding non-arraying of defendant number 1 is that defendant number 1 is no more and defendant number 2 who is the son of the defendant number 1 and hence he has not been made as party and hence counsel submission is accepted. ಅದೊಂದೇನಾ ಮೇಡಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
We have done the needful, my lord. We have done the same, my lord.
Madam, still office objection ಇದೆ. 1 week time granted to comply with office objections. First time, madam. ಆಯ್ತು. 2 weeks time granted. This matter on 24/7. Maintainability appeal in view of section 100.
I may kindly permitted converted to MSA.
Appellant counsel seeks permission of this court by oral submission
To convert,
converted as MSA.
MSA.
Hence permitted to convert the same as MSA for the statistical purpose RSA is disposed of. Next, hearing on IA. Paper publication.
ಸಂಯುಕ್ತ ಕನ್ನಡ ಸುಮ್ಮನೆ.
3 times ಹೋಗ್ ಬಂದಿದ್ಯಾ?
ಇಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಸ್ವಾಮಿ.
3 ಸರಿ ಹೋಗಿ ಬಂದಿದೀಯಾ ಅಂತ ಕೇಳಿದೆ.
ಹೋಗಿ ಬಂದಿವಿ ಅದಕ್ಕೆ ತಾನೆ.
Hold on, A number 1 of 25 and council submitted that earlier 3 times steps was taken and the same was not served and hence filed an application for publication in the publication and the same has to be published in Samyukta Karnataka edition. Bangalore edition. Bangalore edition and for the reasons stated in the accompanying application of affidavit, IA is allowed to permitting to take paper publication against R4 on or before 24/7 returnable by and for the date is fixed for appearance on 28/8.
Appear for appellant.
Production of additional documents.
My lord, I filed my lord IA and also my lord I filed and my lord another IA seeking my lord.
Why today it is listed?
My lord, last occasion my lord I
Paper book.
in fact there is an urgency my lord, therefore my lord I filed 2 IAs on the ground that my lord I am the defendant appeal.
Other side copy suru madidira?
ಮಾಡಿದ್ದೀನಿ file ಮಾಡಿ.
ಯಾವಾಗ?
Long back my lord I said my lord on 26
ನೀವು ಯಾವ IA ಮೇಲೆ ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದೀರಾ ಆರ್ಡರ್ ನ?
my lord IA number 2 my lord IA number 25 39 out of 39 1 and
2 of 25 ಏನ್ರಿ?
Please my lord.
ಕಾಪಿ ಸರು ಮಾಡಿದ ಕೇಳಿದೆ.
I have said my
ಕಾಪಿ ರಿಸೀವ್ಡ್ ಆನ್ 26/25.
Please.
ಮೊನ್ನೆ ರೀಸೆಂಟ್ ಆಗಿ.
Please. Lord ಇದರಲ್ಲಿ since my lord
ಶೆಡ್ಯೂಲ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ?
ಇಲ್ಲ schedule that's why my lord I am making submission.
ಈ ಶೆಡ್ಯೂಲ್ OS ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತಲ್ಲ?
ಇಲ್ಲ the reason is this my lord. Lord I will make my submission. Lord in this case there is my lord 2 properties involved. Lord I am the defendant appeal. My lord plaintiff filed a suit before the trial court my lord is the survey number 138 my lord the extent of 80 acres. But he claimed my lord based on the SC/ST grant my lord to an extent of 1 acre 14 gundas. I am claiming my lord as an adverse position. The land was granted in my favor in 2003. Lord the schedule is different and survey number is different. Survey number is 1 and the schedule is different. He is claiming 1 acre 14 guntas. I am claiming 1 acre 20 guntas. The trial court my lord he filed a suit for declaration before the trial court contending that I am the owner of the property. My lord he is not seek for possession. Trial court will reject the my lord his suit on the ground that my lord he is not in possession of the property as on date of filing the suit. Then he filed my lord appeal. Appeal my lord in an appeal the declaration was granted in the favor of the plaintiff and possession was granted in favor of the defendant. On that government I filed my lord appeal.
Now only appeal is in respect of declaration issue. ಹೌದಾ?
Please no my lord in fact there is a admission made by the plaintiff that my lord the plaintiff property is different, my property is different. That's why my lord I produced my lord the one document. So based on my lord his representation
appellant filed IA.
ಏನಾಗಿದೆ ತಹಶೀಲ್ದಾರ್ ಲೆಟರ್ ಕೊಟ್ಟು ನಮ್ಮನ್ನ ಖಾಲಿ ಮಾಡ್ಸಕ್ಕೆ ಅರ್ಜಿ ಹಾಕಿದ್ದಾರೆ.
Copy served on 26/25. Until that office objections not filed to the IA. However, 1 week time granted to file objections. If not filed any objections to IA 2 of 25, matter will be considered in the absence of objections of the respondent. List this matter on 18.
May make one submission. May make one submission. Lord, there is a letter my lord issued by the Tahshildar to the inspector to my lord evict me from the property. ಅದರಲ್ಲಿ 13/5/2025 ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದು ನಾನು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೆ RSA ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿ. 13/5/2025 ನಾನು ಖಾಲಿ ಮಾಡ್ಸಕ್ಕೆ ಆದೇಶ ಮಾಡಿದ್ದಾರೆ. Tahshildar gave a letter to the my lord in fact I produced the document page number 29. In fact my lord if it is evict me my lord I have no case.
ಆಯ್ತ್ರಿ ತಹಸೀಲ್ದಾರ್ ಹೆಂಗ್ರಿ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ?
He is seeking eviction of the order based on my lord grant in his favor. Grant
based on the grant.
Till today in fact during the proceeding no RTC was standing in his name. After the succeed in an appeal the RTC entered in his name and based on the RTC
ಹಾಕಿದಿರಿ ಅವ್ರಿಗೆ objections ಹಾಕಕ್ಕೆ ಕೊಡಬೇಕು.
Till then they should not precipitate the issue.
ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ 18/7 ಬರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ
ತಹಸೀಲ್ದಾರ್ ಮುಂದೆ ಯಾವಾಗಿದೆ ಮ್ಯಾಟರ್?
ಅಲ್ಲ 13/5 ಕೊಟ್ಟಿದ್ರು 13/5 ಸ್ವಾಧೀನ ತಗೊಂಡಿಲ್ಲ.
5ರಿಂದ ಮತ್ತೇನಾಯ್ತ್ರಿ?
ಇಲ್ಲ ಮತ್ತೆ ನಮ್ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿಲ್ಲ ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಲೆಟರ್ ಬರ್ತಾ ಇಲ್ಲ ಅವ್ರಿಗಷ್ಟೇ ಲೆಟರ್ ಹೋಗ್ತದೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅದಕ್ಕೋಸ್ಕರ. ಯಾಕಂದ್ರೆ since he has the letter is not forwarded to me till then they should not precipitate the issue. ಯಾಕಂದ್ರೆ ಒಂದು ಸ್ವಾಧೀನ ತಗೋಬಿಟ್ರೆ then I have no other resource.
ತಗೊಳ್ಳಿ. Heard on IA number 2 of 25 and council submits that the respondent has approached the Tahsildar seeking the relief of handing over the possession, even though he was unsuccessful before both the courts in trial court as well as appellate court, and no relief was granted for possession, and possession was also not sought.
Please my lord, there is no possession.
And the Tahsildar has issued notice, and hence the appellant went and objected the notice issued by the Tahsildar, and Tahsildar also not yet taken any decision on the objection filed by the appellant, and this court And also copy of IA number 2 of 25 was served on the other side on 26/20/25. Until then, not till that not filed any objections. And hence the IA number 2 of 25 is considered in view of submission of the appellant counsel and directed not to disposes. ನೀವು ಕೇಳಿರೋದು not to disposes.
Not to dispose,
Not to disposes him till the next date of hearing. And counsel for the respondent also given another 1 week time to file objections and list this matter on 18/7.
Please.
Varadarajan MS filing LR application notice ಹೋಗಿದೆ ನೋಡಿ ಮೇಡಮ್. ಇಲ್ಲ ಅದರಲ್ಲ ಹಿಂದಿಂದ್ರಲ್ಲ ಮೆಮೋ ಹಿಂದಿನ ಕೌನ್ಸಿಲ್ ಎಲ್ರಿ ಅವರು ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಮೋಸ್ಟ್ಲಿ ಏನು ಅಥ್ಲೆಟಿಕಲ್ ಏನಾರು ಇದಾರ ಅವರು ಬಾರಿ ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟವ್ರು. ಆಯ್ತು ಮೆಮೋ ಏನದು ಪ್ರಿಪರೇಷನ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಅದ್ರಲ್ಲೇನು ಫೀಸ್ ಕಟ್ಬೇಕಷ್ಟೇ. ಮೆಮೋ ಇಸ್ accepted and directed to pay the necessary fee to prepare the paper book. Next ಹೇಳಿ 31 notice ಹೋಗಿದೆಯಾ?
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. LRs of R10.
Notice against the LRs of R10. That is R10 A to C on A number 1 of 25, 2 of 25, 3 of 25. List this matter on 11/8. 32 Venkata Chalapati.
Office objection has been complied.
Even recalling.
Office objection has been complied.
Comply ಆಯ್ತ್ರಿ, ನೀವು ರೀಸನ್ಸ್ ಕೊಡ್ರಿ. ಈಗ ಕಂಪ್ಲೇಂಟ್ಸ್ ಗಿಲ್ಲ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಹೇಳಿ ಯಾಕೆ ಡಿಲೇ ಯಾಕೆ ಡಿಸ್ಮಿಸಲ್ ಅಂತ.
My lord, another connected matter 1595 of 2021 it has been pending for admission. The judgment and decree arising out of same judgment.
ಇದ್ರಲ್ಲಿ ಯಾಕೆ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಲ್ಲ ಹೇಳ್ರಿ ಅಂದ್ರೆ ಬೇರೆ ಸ್ಟೋರಿ ಹೇಳ್ತೀರಲ್ರಿ.
ಇದು
ರೀಸನ್ಸ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಹೇಳಿ.
Judgment copy ಒಂದು produce
16/12/22 ಕೊಡಿ.
Certificate copy of judgment ಒಂದು produce ಮಾಡಬೇಕು.
ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಫಸ್ಟ್ ಟೈಮ್ ಹೋಗಿದೆ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ. ಸೆಕೆಂಡ್ ಟೈಮ್ ಆಸ್ ಸಚ್ ಅಪಿಲೆಂಟ್ ಸ್ಟ್ಯಾಂಡ್ ಡಿಸ್ಮಿಸ್ಡ್ ಇನ್ ವ್ಯೂ ಆಫ್ 14 ರೂಲ್ 2 ಎರಡಾಯ್ತು. ಮತ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆನೂ ಬಂದಿದೆ. ಇವೊಂದು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಆರ್ ಫೈಲ್ಡ್ ಟು ಕಂಡೋನ್ ದಿ ಡಿಲೇ ಇನ್ ಫೈಲಿಂಗ್ ರಿಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಟು ರಿಕಾಲ್ ದಿ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್. Counsel for the appellant is not pursuing the matter diligently. However, in the ends of justice, one more opportunity is given to the appellants. ನಾನೇ ಮತ್ತೆ ನಿಮ್ಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ನೀವು ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ. ಮತ್ತೆ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಮತ್ತೆ ಬೇರೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ವೀಕ್ಸ್ ಟೈಮ್ is granted to
last occasion.
Third, counsel submits that when the matter listed before the registrar second time itself the same was dismissed, and thereafter matter listed before this court 26/25 and this court has given time, and subsequently on 27/6/25 having taken note of the same pending consideration directed to comply with office objection, and now office objections are complied, and having taken note of the setback into consideration, IA number 1 of 23 delay of 239 days is condoned, and IA number 2 of 23 for recalling the order dated 16/12/22 also recalled, and appeal is restored. List this matter along with admission with RSA number 1595 of 21 on 24/7.
Great.
Srihari filing the appeal delay na, and list this matter on 24/7 for admission along with IA. 34 Bimbadara filing the appeal, list this matter on 24/7 along with IA. That is also same order. That is also same order. In filing the LR application, notice ಹೋಗಿದೆಯಾ? ಹೋಗ್ಬೇಕಾ? Issue notice against the LRs of R1, that is R1 A to C on IA number 1 of 24, IA number 2 of 24, IA number 3 of 24. And also appellant counsel is directed to
take steps to respondent.
Pay PF within 1 week, and if PF paid within 1 week, issue notice to R3 and R4. If PF not paid against R3 and R4, appeal will be dismissed in the next date of hearing.
Much of
ಇನ್ನೊಂದೇನು ಅದು ಫೈಲಿಂಗ್ ಅಪೀಲ್ ಅಲ್ಲ, ಆಯ್ತು. ರಿಟರ್ನ್ ನಮ್ಮಲ್ ಬೈ 11/8.
much of
ಪ್ರಕಾಶ KA filing of LR application. ಯಾರು ಸತ್ತೋಗಿರೋದ್ರಿ? R4 issue notice against the LRs of R4 on IA number 1 of 25, 2 of 25, 3 of 25, and also directed to pay PF to issue notice against R3, R5, R6, R8, R9, R10 and R12 within 1 week. If the PF not paid within 1 week, appeal will be dismissed against them. Returnable by 11/8. 38, Sachin BS. Filing appeal, is this matter for admission along with IA on
If I may make a submission.
24/7, ಹೇಳಿ ಏನು?
My lords, this matter, my lords, sister's appeal, my lords, is allowed by my lords in the previous roster. Change of name, my lords, of the plaintiff. Lords, the sister's appeal, my lords, is allowed. Lords, in that view of my lords, there is some urgency. That is why we have moved the court.
ಆಯ್ತು 24 ಹೇಳು.
But some
ಅಲ್ಲ ರೀ ಫೈಲ್ ಮಾಡಿರೋದು 23ರಲ್ಲಿ ಇದುವರೆಗೂ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. ಈಗ 2 ವಾರಕ್ಕೆ ಮಾತ್ರ ಅರ್ಜೆನ್ಸಿನಾ?
ಇಲ್ಲ my lords. Thereafter, my lords,
ನೀವು ಅದು ಹಾಕಿ
valuation slip.
ಅದೇನು ಅಲೋ ಆಗಿದೆ ಅದ್ರ ಕಾಪಿ ಹಾಕಿ. I will go through and I will pass orders next time. List this matter on 24/7.
Please.
Please. Bring the appellant.
Appellant?
Appellant has died, sole appellant.
ಹಾಕೊಂಡಿದ್ದಾರೆ. ಅದರ್ ಸೈಡ್ ಯಾರು? ಸ್ವಾತಿ ಪಾಂಡುರಂಗ. Any objections, madam? IS heard on IA number 1 of 25 for bringing LRs of deceased sole appellant as appellant number 1A to E. And copy is also served on the other side, on the other side not objects. And hence IA 1 of 25 is allowed, permitting the LRs to come on record. But ಇನ್ನೊಂದೇನೋ emergent, and appellant counsel is directed to amend the cast title and file cast list, amended cast list, amended cast title within 2 weeks. If the counsel also directed to pay PF to issue emergent notice to R3B, and if paid within 1 week, issue notice against R3B also. ಆಮೇಲೆ paper book, ಆಯ್ತು 4 weeks time granted to file paper book, returnable by 11/8. ಗಂಗಾಧರಪ್ಪ AV. ಹೇಳಿ, bringing LRs of R4.
Notice has to be ordered to
issue notice against LRs of R4 on IA number 1 of 25.
And appointment of guardian.
Appointment of guardian ಯಾರು ಕೇಳ್ತಾರೆ?
Mother. R4 has died and his wife is one of the respondents.
ಈಗ ನೀವು IA 2 for 25 for appointment of guardian for deceased R4 LRs ka?
Yes.
LRs ke?
Yes.
And also issue notice against the ಯಾರಿಗ ಹೋಗ್ಬೇಕತ್ ನೋಟಿಸ್? ಮೈನರ್ ಮದರ್. ಅದೇ ಮದರ್ ಯಾರು ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ?
ಮಾಡಿದೀವಿ.
14A, that is 14A on IA number 2 of 25.
Yes, in the connected matter.
ಯಾರಿಗೆ? ಯಾವ್ದ್ರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ? ಫಸ್ಟ್ ಅಲ್ಲ, ಫಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಯಾರಿಗ ಹಾಕಿದಿರಿ? 2 to 5. ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ಹೆಸರು ತೋರಿಸಿದ್ರಲ್ಲ.
ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4
ಚಂದ್ರಶೇಖರ್ ಪಾಟೀಲ್, ಅಡ್ವೊಕೇಟ್ ಫಾರ್ R2 to R5 ಅಂತ ಇದೆಯಲ್ರಿ. ಮತ್ತೆ ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ, R4 ಸತ್ತೋಗಿದ್ದಾರೆ. R4 ನೋಟಿಸ್ ಆದೇಶ ಮಾಡಿದಿರಿ.
R2 to 5 ಅಂತ ಹಾಕಿದ್ರಿ, ಮತ್ತೆ 4 ಇಲ್ಲ ಬದುಕಿಲ್ಲ ಅಂತಲ್ರಿ ಅವ್ರ ಪ್ರಕಾರ. ಯಾರಿಗ ವಕಾಲತ್ ಹಾಕಿದ್ರಿ? ಮೋಸ್ಟ್ಲಿ ವಕಾಲತ್ ಹಾಕಿದ್ಮೇಲೆ ಏನಾರು ತೀರ್ಕೊಂಡಿದಾರೇನ ನೋಡ್ರಿ. ಅದೇನದು? ತೀರ್ಕೊಂಡಿರೋದು ಯಾರು ಏನಾರು ಇದೆಯಾ? ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಇರುತ್ತೆ ನೋಡಿ. ಆಯ್ತು, ಏನೇ ಹೋಗಿ ಬರ್ಲಿ ಬಿಡಿ. ನೋಟಿಸ್ ಅವ್ರು ಆಲ್ರೆಡಿ ಹಾಕಿದಾರೆ.
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ
ಆಯ್ತು, ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಹೇಳಿ.
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ನೋಟಿಸ್
ಫರ್ನಿಶಿಂಗ್ R1C
ಗೆ ನೋಟಿಸ್ ಹೋಗೋದಕ್ಕೆ 1 week ಟೈಮ್ ಕೇಳ್ತಾ ಇದೀನಿ.
ಆಯ್ತು, ಕೌನ್ಸಿಲ್ is given 1 week time to pay fresh PF. If fresh PF is paid, issue notice against R1C.
Then R2C to E
unclaimed ಏನಾಗಿದೆ ನೋಡಿ.
unclaimed ಅಂತ ಬಂದಿದೆ.
ಐಡಿ ಇದೆಯಾ? On perusal of the notice issued to the R2C and E, intimation was delivered and not claimed and hence held sufficient against R2C and E.
Then the other is 2D ಗೆ I have to file the application.
2D ಇನ್ನು ಸತ್ತೋಗೋನೆ. Appellant counsel is given 2 weeks time to bring the LRs of R2D.
Then IA 1 of 24 continuation of delay, ಅದು ನೋಟಿಸ್ ಆದೇಶ ಆಗಿದೆ.
ಅದು ಆಲ್ರೆಡಿ ಆಗಿದೆ, ನೋಟಿಸ್
ಆಗಿದೆ. ಬಟ್ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿಲ್ಲ. ದಟ್ ಅಪ್ಲಿಕೇಶನ್
ಕನ್ಸಿಡರೇಷನ್ ಈಗ ಪೆಂಡಿಂಗ್. ಆಯ್ತು, ರಿಟರ್ನಬಲ್ ಬೈ 11/8. appeal, in filing the appeal alla, list this matter on 24/7 along with IA for admission. ಇದು ಅಷ್ಟೇ 173 days delay. List this matter for admission along with IA on 24/7.
Notice
ಯಾರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು? ಇದು ಯಾರು ತೀರ್ಕೊಂಡಿದಾರ?
ಅಬೇಟ್ಮೆಂಟ್
ಅದ್ ನೋಡೋಣ, ಫಸ್ಟ್ ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ನೋಡೋಣ. ಗ್ರೌಂಡ್ ಇದ್ರೆ ಮಾತ್ರ ನೋಟಿಸ್, ಇಲ್ದವ್ರು ಇಲ್ಲ. ಯಾರು?
41 42.
ಅದು ಹೋಗ್ ಬರ್ಲಿ ಮೇಡಮ್, ಲಿಸ್ಟ್ ಆಗ್ಲಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಅವತ್ತು 24/7 ತಂದ್ರು ಅದು ಹೋಗ್ಬೇಕಲ್ಲ, ಡಿಲೇ ಇದೆ. ಅವ್ರ ನಾಳೆ ಬಂದು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ನಾವೆಲ್ಲ ಎಲ್ಲಾರ್ಸು ಅಂತ ಈಗ ಹೆಂಗ್ ಅಲೋ ಮಾಡೋದು? ನೆಕ್ಸ್ಟ್ 43, 11 days in filing the appeal. 14/7 ಅಲ್ಲ 24/7 ಯಾರು ಯಾರಿಗೆ ಹಾಕಿದಾರೆ? ಅವಾಯ್ಡ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಇದೆಯಲ್ಲ ಅದ್ರಲ್ಲ. ಅದು ತೋರ್ಸಿಲ್ವಾ? ಆಯ್ತು. ರಿಜಿಸ್ಟ್ರಿ is directed to show the name of the Prithviraj BN for R2. ಆಯ್ತು. ಹಾಕಿದಾರಲ್ಲ ಅವ್ರು ಆಲ್ರೆಡಿ ತೋರಿಸಿದಾರಲ್ಲ. ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್, ಅದು ವಕಾಲತ್ ಹಾಕಿದಾರ. The counsel Lakshmi Narayana for R3 has filed ವಕಾಲತ್ and the same is taken on record. ಹಿಂದಿಂದ್ರಲ್ಲೂ ಅಷ್ಟೇನೆ, ವಕಾಲತ್ filed by Prithviraj for R2 is taken on record ಅಷ್ಟೇ. ಹೆಸರೆಲ್ಲ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ ಅಷ್ಟೇ ಅಲ್ಲ. List this matter on my await notice of R6 to 8, 10 and 11. List this matter on 11/8. CD of 1 day is filing the appeal. List this matter for admission along with IA on 24/7.
Appellant.
In filing the appeal, same order 24/7.
45 delay tendon ಆಗ್ಬೇಕು, ಸ್ಟೇ ಆಗ್ಬೇಕು.
46 also 24/7. Divyatej.
It's a delay of 1 day.
For 24/7 along with IA. Next 48.
46, 47.
ಎಲ್ಲ 24/7. ಅದೇನ ಮಧ್ಯಾಹ್ನ 2:30 ಅಂತ ಆಯ್ತಲ್ಲ.
ಅಲ್ಲ
2:30.
tomorrow.
ಫೈಲ್ ಕೊಡ್ತೀವಿ, ನೀವು ಓದ್ಕೊಳ್ಳಿ ತಗೊಳ್ಳಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಮೇಡಮ್ 24/7. ಕೇಶವ ಅಗ್ನಿಹೋತ್ರಿ ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಿದ್ದೀವಿ, ಕೊಡಿ ನೋಡೋಣ. ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಂತ 321 is absent if the appellant counsel doesn't appear on the next date of hearing. So appellant counsel is absent, and in the previous occasion on 24/6/25 also was absent. And this court, however, in the ends of justice, one more opportunity was given and made it clear that if counsel doesn't appear on the next date of hearing, appeal will be dismissed for non-prosecution. And in spite of the said order, none appears, and hence appeal is dismissed for non-prosecution. Yes, counsel.
Kindly pass over, my lord.
Pass over, ಯಾಕೆ?
Senior held up ಆಗಿದ್ದಾರೆ ಮೇಡಮ್.
Pass over, ಆಯ್ತು. ಸೌರಿ HR ಸರ್ವೈವರ್ ಏನ FDP ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ ನೋಡಿ. ಮತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು, ತಗೊಳ್ಳಿ ಕೊಡಿ. FDP ನು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. FDP ಆರ್ಡರ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊ ಬಂದಿದ್ದಾರೆ. The counsel for the appellants in the previous occasion made the submission that FDP was disposed of in the year 2015 itself, and RA is disposed of in the year 2019, and he wants to check whether RSA survives for consideration or not. And in spite of time was taken, none present, and in view of FDP already disposed of in the year 2015 itself, the RSA doesn't survive for consideration, and hence same is dismissed as not survived.
My lords, in this matter, appellant number 5 is dead, my lords. I filed LR application in this matter.
Who died?
Appellant number 5, my lords.
Appellant number 5. ಯಾವಾಗ ಹಾಕಿದ್ರೆ ಅಪ್ಲಿಕೇಶನ್?
ನಿನ್ನೆ ಹಾಕಿನ್, my lords.
Counsel submits that he has filed an application to bring the LRs of appellant number 5 on record.
Yes.
On ನಿನ್ನೆ ಡೇಟ್ ಹೇಳಿ ಮೇಡಮ್, 8 ಅಲ್ಲ 8/7/25, and hence registry is directed to put up the same and list this matter on 17/7.
Obliged.
Spurti Hegde 391 days in filing the appeal along with appeal.
For the appellant, my lords.
ಹೇಳ್ರಿ ಏನು? Declaration and injunction was dismissed.
Lord, it's a concurrent finding.
What is the ground now?
Sorry, my lord. Concurrent finding, my lord.
ಹೌದು.
My lord, I have purchased one of a survey number 216 property, my lord. 216 survey number.
Survey number 216.
Yes, my lord. Thereby, the defendants was granted with the land by the municipality. Where it is, where it comes, its location doesn't, they have mentioned in which survey number or such. They issued a Kata number. Two Kata numbers are there.
You only sought for the relief of declaration
Yes,
and
ma'am.
injunction.
I sought for.
Nim cross examination hogi, page 13. In the cross examination, PW1 clearly admits that there is no situation of the social property. Same is read thus. ನನ್ನ ದಾವಾದಲ್ಲಿ ಸೂಚಿರುವ ನನ್ನ ವಿಳಾಸದಲ್ಲಿ ಮನೆಯ ಸಂಖ್ಯೆ ಅಥವಾ ನಿವೇಶನ ಸಂಖ್ಯೆ ಇಲ್ಲ ಅಂದರೆ ಸರಿ. ದಾವಾ ಸ್ವತ್ತಿನ ಖಾತೆ ನಂಬರ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿಗೆ ಚೆಕ್ ಬಂದಿ ಪೂರ್ವಕ್ಕೆ ತಿಪ್ಪಯ್ಯನ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಗಂಗಾಪನ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ದಕ್ಷಿಣ ಇರುತ್ತದೆ. ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಯಾವಾಗ ಬಂದಿರುತ್ತದೆ ಎಂದು ಹೇಳಲು ನನಗೆ ಆಗುವುದಿಲ್ಲ. ನಾವು ಜಮೀನನ್ನು ಖರೀದಿಸಿದ್ದಾಗಿ ಹೇಳಿದ್ದು ಅದನ್ನು ವ್ಯವಸಾಯೇತರ ಚಟುವಟಿಕೆಗೆಂದು ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿಕೊಂಡಿಲ್ಲ. ಯಾವುದೇ ವ್ಯವಸಾಯದ ಜಮೀನನ್ನು ವ್ಯವಸಾಯೇತರ ಬಳಸುವಾಗ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿ ಹೆಸರವರ ಆದೇಶದ ಮೇರೆಗೆ ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಶುಲ್ಕ ಪಾವತಿ ಪುರಸಭೆಯಿಂದ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಬೇಕಾಗುತ್ತದೆ ಅಂದರೆ ಹೌದು. ದಾವೆಯಲ್ಲಿ ನೋಡಿದಂತೆ ಈ ಸ್ವತ್ತಿನ ಖಾತೆ ನಂಬರ್ ಸೋನ್ಸ್ ಎಂದು ನಮೂದಿಸಿರುವ ರೂಪದಲ್ಲಿ ವ್ಯವಸಾಯೇತರ ಭೂ ಪರಿವರ್ತನೆಗೊಂಡ ಬಗ್ಗೆ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿಲ್ಲ. ಮತ್ತೇನ್ ನಿಮಗೆ ರಿಲೀಫ್ ಕೊಡ್ಬೇಕ್ರಿ? ಯಾವ ಸಾಲಿನಲ್ಲಿ ಭೂ ಪರಿವರ್ತನೆ ಆಗಿದೆ ಎಂದು ಹೇಳಲು ಬರುವುದಿಲ್ಲ.
It is not converted, but it is our land where we have.
ನಿಮ್ ಲ್ಯಾಂಡ್ ಬಟ್ ಏನು ಇರ್ಬೇಕಲ್ಲ.
Thereafter,
ಫರ್ದರ್ ಹೋಗ್ರಿ, ಇನ್ನು ಹೋದ್ರಿ ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
I really admit that portion, my lord, but thereafter the trial court also shows that there is a dispute of identity. Identity of the property which is granted by the municipality and which is there in the. So I made an application after the dismissal of the after the dismissal of the original suit. I made an application before the RA court to identify the property, which is at page number 71 of my petition, my lord. That two Kata numbers were issued. That application for order 26 rule 9 application was made. That application was not considered, and thereafter at page number 29 of the RA judgment in page 17. By looking into the oral documentary evidence, it is clear that the identity of the property of the petitioners claimed and the suit schedule property declared to be the owner of the same. When the identity is not clear, shown by the plaintiffs, it is the identity. If the property is situated in survey number 216 of the property, which is my property, my lord, the municipality doesn't get any right in the suit in a survey number where the owners are there. It is true that I have not made the owners as existing RTC owners which are as a party before the trial court, but I have made an application to identify the property at as IA number 5 along with the RA filed, my lord. There that IA was not considered by the lower appellate court. So if that IA is considered,
ಹಾಕಿದ್ರಿ ನೀವು ಅಪ್ಲೇಟ್
IA ಹಾಕಿದೀವಿ.
IA ಮೇಲೆ ಏನಾದ್ರು ಆರ್ಡರ್ ಇದೆಯಾ?
IA ಮೇಲ್ಗಡೆ ಆರ್ಡರ್ ಇಲ್ಲ.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ ಅಥವಾ
ಆರ್ಡರ್ ಶೀಟ್ ನಮ್ಮ ಹತ್ರ ಆರ್ಯದ ಆರ್ಡರ್ ಶೀಟ್
ನೀವು ಸಪರೇಟ್ ಆಗಿ ಪ್ರೆಸ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ?
IA ನ ಸಪರೇಟ್ ಆಗಿ ಪ್ರೆಸ್ ಮಾಡಿದೀವಿ. 26 IA was 25/4/2019 itself, my lord, at page number 71, my lord. 71 I have produced, my lord, before in the page number 71.
ಏನು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಅವರೇನು ಹೋಗಿ ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾರೆ ಕಮಿಷನರ್?
My lord, there are two
evidence is very clear.
My evidence is very clear in respect of survey number 216, my lord. 216, it is very clear that I have purchased a property in the survey number 216. In survey number 216,
sale deed
ಹಾಕಿದ್ದೀನಿ. Sale deed I have produced, my lord. That is not dispute.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಹಾಕಿದ್ದೀನಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. And my name.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ತಾಂಡಿಲ್ಲ ಸ್ವಾಮಿ.
ತಗೋಬೇಕಲ್ಲ. ನಿಮ್ ಪ್ರಕಾರ IA ಹಾಕಿದ್ರಿ 25/4/2019.
Yes, my lord. 19 itself I have produced.
This court has to examine whether any order has been passed on 26 rule 9 application or not ಅಂತ. Produce ಮಾಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿ.
Order sheet. Meanwhile, my lord, I will take notice, my lord. A date may be fixed for.
Appellant counsel is directed to serve the notice, directed to get the certified copy, produce the certified copy.
RA order sheet.
Of the RA order sheet. List this matter on 24/7 ಆಗುತ್ತೆ 2 ವಾರದಲ್ಲಿ. ಜಾಸ್ತಿ ದಿವಸ ಬೇಕಾ?
Might be on 31, my lord.
31/7.
Much obliged.
Varun Gowda, owner, confirmed.
My lord, I am seeking a passover. My lord, senior is reaching there physically. I am seeking a passover.
Passover, right?
Please, my grateful.
Move structure 55 dismissed, confirmed. There are non-compliance of office objections are IA number 2 of 25 and 3 of 25 for TIA. Schedule tally ಆಗ್ತಿಲ್ಲ ಅಂತ. ಆಯ್ತು ಅದಾದ್ಮೇಲೆ ನೋಡೋಣ ಈಗ ಫಸ್ಟ್ ಏನಿದೆ ನೋಡೋಣ ಗ್ರೌಂಡ್ಸ್ ಇದೆಯಾ concurrent finding.
The brief facts of the case are this, my lord. The suit, my lord, was filed by one Nanjappa. He, my lord, was the
Absolute owner.
absolute owner of
Lawful possession. He has
Oh,
purchased the social property under registered sale deed
Please,
dated
please. He had
18/3/1968.
purchased the social property, my lord, under a registered sale deed dated 16/8/1965. The previous history of the case is this, my lord, that Chikka Bhairappa was the proprietor of the family. He, my lord, had three sons, Bairanna, Nanjappa and Channappa. The plaintiff earlier before, my lord, the trial court was Nanjappa, who was the son of Bairanna. Now there was a family partition amongst the
ಚಿಕ್ಕಬೈರಪ್ಪನ್ಗೆ ಮೂರು ಮಕ್ಕಳು.
Chikbairappange ಮೂರು ಮಕ್ಕಳು.
ಬೈರಣ್ಣ ಒಬ್ಬ.
They are Bairanna, Nanjappa and Channappa.
ಚನ್ನಪ್ಪ.
ಆಯ್ತು. Now, my lord, the plaintiff Nanjappa is the son of Bairanna.
ಅಂದ್ರೆ ಫಸ್ಟ್ ಸನ್ ಮಗ.
First son ಮಗ.
Plaintiff.
Now, my lord, there was a partition between the sons of the propositors Chikka Bhairappa.
Already there was a
partition, my lord. These facts are admitted. Now, my lord, Channappa, my lord, after the partition, the suit schedule property, my lord, fell into the share of Channappa. Now, Channappa in turn executed, my lord, a gift deed in favor of his daughter, which, my lord, is a conditional gift deed. The gift deed, my lord, was executed 26/10/1964. 64. It was a conditional gift deed. On 18/6/1965, the gift deed came to be cancelled or revoked.
Cancelled or revoked?
Revoked. As per, my lord, 126 of the TP Act. Now, after the revocation of the gift deed, Nanjappa, my lord, purchases the property, certain items of the suit schedule property, my lord, on 18/8/1965 from Channappa.
Who purchased?
Nanjappa, the plaintiff.
Nanjappa,
the plaintiff.
Who is the son of Bairanna?
The son of Bairanna.
He had purchased the property.
He purchases
from the uncle.
From the uncle, that is.
ಅದೇ ಚೆನ್ನಪ್ಪನ ಕಡೆಯಿಂದ ಅಂದ್ರೆ ಅಂಕಲ್ ಕಡೆಯಿಂದ.
Uncle ಕಡೆಯಿಂದ. Nanjappa's uncle, my lord, is Channappa. On 18/8/1965. 65.
After the cancellation.
After the cancellation. Now, my lord, so far as the first defendant is concerned, who is Muniappa, he, my lord, purchases the property on 18/3/1968 from the daughter of Channappa, who is Huchamma. The question now, my lord, is whether Huchamma, on the date of the execution of the sale deed, had a right over the property because of the revocation, as I had submitted. Now, these, my lords, are the facts of the case. Now, insofar as the order passed by the trial court is concerned, the trial court, my lord, has held that the revocation, my lord, is not proper, or, my lord, the trial court has gone on to hold that under 126 of the Transfer of Property Act, there cannot be any revocation because the gift deed, which has been, my lord, produced as Exhibit P1, is not a conditional gift deed. This is a question, my lord, that has to be answered. Now, my lord, may kindly look into the gift deed itself at Exhibit P1.
Records ಬಂದಿದೆ ಮೇಡಮ್? ಇಲ್ಲ. First time, registry is directed to get the records of the trial court and appellate court and list this matter on. Date ಕೊಡಿ ಮೇಡಮ್. ಯಾವ ಊರಿಂದ ಬರಬೇಕು?
ನೆಲಮಂಗಲ.
ಹತ್ರ ಕೊಡಿ, ಒಂದ್ 2-3 ವಾರ ಕೊಡಿ.
ಅಲ್ಲ 24 ಬೇಡ.
ಬೇಡವಾ?
24, 31 ಎರಡು ದಿನ ಬಿಟ್ಟು.
ಬೇಡ, ಹಂಗಾರೆ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಆಗಸ್ಟ್ ಕೊಡಿ.
ಅಲ್ಲ 7%.
48. 56.
I appear for.
ಇದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್. ಇದು ಬೇಡ, ವೇಸ್ಟ್ ಆಗುತ್ತೆ.
The plaintiff files a suit for injunction
Permanent injunction.
Obtains an injunction and temporary injunction, he encroaches the property. Now the encroachment is stated to be the possession and decree is granted. We have produced the sketch before the court. D6 is not looked into. One, may I pass on the sketch where the encroachment is shown now survey conducted by the parties. 220 illi nodi. It's good.
This market document.
Market document. The present survey is conducted. We have filed the suit for land grabbing. The series of encroachment. Now kindly see, so far as market document is concerned, P6 is the plan produced by them. P6 only they say site number 3 and 4, the plaintiff says I have purchased it. Now 3 again, northerly there is acquired property. There is no road. In the sale deed, it is shown as a road. Taking advantage of that, they stretch the building up to National Highway. Now trial court, what the trial court says is, in para 10, the factual mistake committed by the trial court is, kindly see exhibit P6, produced with themselves demonstrate that the 7 sites which are formed in survey number, same survey number, part of 15 guntas is acquired. So acquired land is shown. Trial court says that there is no land acquired by the side of these people. That is the factual mistake. Therefore, last time I submitted, let the records be summoned.
Records bandilla. But actually, what is the total extent of this land in terms of exhibit?
Survey, ಅದೇನಾಯ್ತಂದ್ರೆ ಒಂದು ಪ್ಲಾನ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ. See, first
survey number 42/7 alva.
No. See, large extent.
Property survey number ಏನು?
A tract of land is acquired. ಒಂದು ನಿಮಿಷ ಏನಾಯ್ತಂದ್ರೆ, kindly take that color sketch I have given. See, it was a check post earlier. ಆ ಚೆಕ್ ಪೋಸ್ಟ್ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ಒಂದು ಜಾಗ ಇದೆ. ಆಮೇಲೆ ಆ ಚೆಕ್ ಪೋಸ್ಟ್ ಉದ್ದಕ್ಕೂ ಪಕ್ಕದಲ್ಲಿ ಸ್ಟ್ರಿಪ್ ಆಫ್ ಲ್ಯಾಂಡ್ ವಾಸ್ ಅಕ್ವೈರ್ಡ್ ಫಾರ್ ಪಾರ್ಕಿಂಗ್ ಪರ್ಪಸ್. ಸೊ ದಿಸ್ ಲ್ಯಾಂಡ್ ವಾಸ್ ಅಕ್ವೈರ್ಡ್ ಫಾರ್ ಪಾರ್ಕಿಂಗ್ ಪರ್ಪಸ್ ಆಫ್ ದಿ ಲಾರೀಸ್. ಚೆಕ್ ಪೋಸ್ಟ್ ವಾಸ್ ಶಿಫ್ಟೆಡ್ ನಿಯರ್ ನೆಲಮಂಗಲ. This land was transferred to us by way of the transfer by the government. We have paid 2 crore 40 lakhs to the government. Now taking advantage of the fact that check post is shifted, these people started encroaching. And the trial court, kindly see para 10 of the trial court. Let the commissioner be appointed. If there is an encroachment, we'll see. That is the mistake. ಅದನ್ನು ಓದಿ. ಹಂಗೆ ಮುಂದಕ್ಕೆ ಹೋಗಿ ಹಾಗೇನೆ ಅಲ್ಲ, ಪ್ಲೀಸ್ read it. It is pertinent to note.
ಆಯ್ತು, ಅದು ನೋಡ್ಬಿಡೋಣ. It is pertinent to note here that
survey number 20 totally measures 1 acre 20 guntas land. Out of 15 guntas was acquired by the government, and later the same was obtained by the defendant by awaiting the consideration of the government. It is contention of defendant that the plaintiff has encroached approximately 100 feet of defendant's property in survey number 20/C. Did the plaintiff really encroach the property of the defendant as per the allegation of the defendant? It has to consider that the plaintiff property should be adjacent to the defendant property. It is adjacent to different property only. Alala, it is adjacent, no, according to their own P6, according to their own P6, adjoining the property. See, in a case like this, a commissioner should have been appointed. I will make an application for appointment commissioner.
He is directed to get the records of the trial court and appellate court and discuss this matter on 4/8. ಕೊಡಿ ಅವರಿಗೆ. Decreed confirmed.
84 days delay is there. Meantime, your lordship.
ಡಿಲೇ ಆಮೇಲೆ ನೋಡೋಣ ಕೇಸಲ್ಲಿ ಏನಾದ್ರು ಸತ್ವ ಇದ್ರೆ ಮಾತ್ರ ಡಿಲೇ.
ಆಯ್ತು. Suit is for specific performance. Wherein your lordship can see the agreement is executed on 9/11/2009. Time is the essence of contract. Under the agreement, 6,10,000 total sale consideration. Advance paid is 2 lakhs. Then within 2 months, agreed to execute the registered sale deed and they agreed to purchase the same. Then thereafter, your lordship can see within 1 month, that is on 13/12/2009, one more agreement is entered into between the parties. That on that day 50,000 is paid. Then the rest of the conditions is in the first agreement. That 2 months is service. Then thereafter, your lordship will see, my point is, my lord, only exhibit P14. Exhibit P14 is the notice issued by the vendor calling upon these purchaser to come and get the registered sale deed by paying the balance sale consideration within a week. That is specifically as mentioned. Then exhibit P15 on 17/3/2010. Then he replied that give me a date, they will come and get the registered sale deed. That is the answer. Then thereafter, your lordship will see it did not turn up. Then your lordship will be, in the first notice itself, we have said that if you are not come within the 1 week, then we will forward the advance and we will cancel the agreement. Then your lordship can see, then he has sold the property in favor of this appellant on 18/6/2010.
18/6/2010.
Then after that, your lordship.
Date of agreement ಯಾವಾಗ?
Date of agreement is 9/11/2009, first agreement. The second agreement is 13/12/2009. Then 18/6, the notice issued on 2/3/2010. Reply is 17/3/2010. Then thereafter he sold the property in favor of this appellant on 18/6/2010. Then thereafter on 3/12/2010, one more notice is issued by this purchaser calling upon them to execute the registered sale deed. Then thereafter, your lordship will see at that time execution.
Agreement copy ಇದೆಯಾ?
Agreement copy.
ಕೊಡಿ. Is there any forfeiture clause in case of any default?
ಇದೆ.
Forfeiture clause ಏನಾರು ಇದೆಯಾ?
ಇದೆ. ಅಲ್ಲ ಅದನ್ನ ಫೋರ್ಫಿಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಡ್ವಾನ್ಸ್ ಅದು ಇದು.
ನೀವು ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ನೋಟಿಸ್ ಕೊಟ್ರಲ್ಲ?
ನಾವು ಕೊಟ್ಟಿರೋದು. ಫಸ್ಟ್ ನಾವು ಕೊಟ್ಟಿದ್ದು.
ನೀವು ಕೊಟ್ರ?
ಅಂದ್ರೆ
ಯು ಆರ್ ದಿ ಪರ್ಚೇಸರ್ ಅಲ್ವಾ?
No. The vendor has issued a notice.
Vendor issue.
ಹೌದು, vendor issued a notice.
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದ.
Vendor notice ಅವರು ಕೊಟ್ಟು ಇಮಿಡಿಯೇಟ್ಲಿ ವಿದಿನ್ ವೀಕಲ್ ಬಂದು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ.
ಅದಕ್ಕೆ ರಿಪ್ಲೈ ಕೊಟ್ರಲ್ಲ ಅವರು?
ರಿಪ್ಲೈ ಅವ್ರು ಕೊಟ್ರು. ರಿಪ್ಲೈ ನಲ್ಲಿ ಏನ್ ಕೊಟ್ರು? ನೀವು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂದ್ರು. Then thereafter they have not come forward. Then subsequently
ನೀವು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಡಾಕ್ಯುಮೆಂಟ್ ಬಂದು ಸೈನ್ ಮಾಡಿ ಅಂತ ಆಮೇಲೆ ಡೇಟ್ ಕೊಟ್ರ ಅವರಿಗೆ ರಿಪ್ಲೈ ಕೊಟ್ಮೇಲೆ?
ಹೌದು, ಅಲ್ಲ ಮತ್ತೆ ರಿಪ್ಲೈ ಕೊಟ್ಟಿಲ್ಲ. 1 ವಾರದಲ್ಲಿ ಬಂದು ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಬಟ್ ನಿಮ್ಮವ್ರಿಗೆ ನೀವೇ ನೋಟಿಸ್ ಕೊಟ್ರಿ ಹೌದಲ್ಲ? ಅದಕ್ಕೆ ಅವ್ರು ರೆಡಿ ಇದೀವಿ, ನೀವು ಆ ದಿವಸ ಬಂದು
ರೆಡಿ ಇದೀವಿ ಅಂತ ಏನು ಹೇಳಿಲ್ಲ. ಮತ್ತೆ ಡೇಟ್ ಕೊಡಿ ನಾವು ಬರ್ತೀವಿ ಅಂತ. ಬಟ್ ಇವ್ರ ಲಾರ್ಡ್ಶಿಪ್ ಸಿ ದೇ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ದಿ ಪಾಸ್ ಬುಕ್ಸ್. Does not disclose the amount which is in the pass box. That only during the pendency of this suit, that is in the year 2016, they have deposited 4 lakhs amount in their account, that to husband's account. Ashtu bitre enu illa. Because only 2 points, my lord, that is ready and willingness, time is the essence of contract. Agreement ಬೇಕಾ?
ಅಗ್ರಿಮೆಂಟ್ ಕಾಪಿ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. ವೆದರ್ ದಿಸ್ ಕ್ಲಾಸ್ ಕಂಪ್ಲೈಡ್ ನೀವೇ ಬರ್ಕೊಂಡಿದಿರಲ್ಲ, ಇಂಪಾರ್ಟೆಂಟ್ ಅಂತ ಹಾಕೊಂಡಿದಿರಲ್ಲ, ಇದು ಕಂಪ್ಲೈ ಮಾಡಿದಿರಾ?
ಯಾವ್ದು ಇಂಪಾರ್ಟೆಂಟ್?
ಇಲ್ಲಿದೆ ನೋಡಿ ಮುಂದೆ, ಸ್ವಾಧೀನ ಕೊಡ್ಲಿಲ್ಲ, ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿಯೇ ಉಳಿಸಿಕೊಂಡಿರುತ್ತೇನೆ. ಈ ಕ್ರಯದ ಕರಾರು ಸ್ವತ್ತನ್ನು ಕ್ರಮವಾದ ಕ್ರಯ ನೋಂದಣಿಯ ವೇಳೆ ನಿಮ್ಮ ಸ್ವಾಧೀನಪಡಿಸಲು ನಾನು ಬದ್ಧನಾಗಿರುತ್ತೇನೆ. ಕ್ರಮವಾದ ಕ್ರಯ ನೋಂದಣಿಯ ಒಳಗಾಗಿ ಈ ಸ್ವತ್ತಿನ ಬಾಬ್ತು ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶದ ಪ್ರತಿಯನ್ನು ಪಡೆದು ಸೈಟ್ ಪ್ಲಾನ್ ಮಾಡಿಸಿ ಟೌನ್ ಪ್ಲಾನಿಂಗ್ ಮತ್ತು ನಗರಸಭೆ ಕಾರ್ಯಾಲಯದಿಂದ ಅನುಮೋದನೆ ಪಡೆದು ಖಾತೆಯನ್ನು ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ತೆರೆಯಿಸಿ ಪ್ರಸಕ್ತ ಸಾಲಿನ ಖಾತೆ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್, ಪ್ರಸಕ್ತ ಸಾಲಿನವರೆಗೂ ಬೇಬಾಕಿ ಮಾಡಿರುವ ಕಂದಾಯ ರಸೀದಿಗಳು, ಪರಬಾರೆ ರಾಹಿತ್ಯ ಪ್ರಪತ್ರ, ಭೂ ಪರಿವರ್ತನೆ ನಿರ್ಣಯ ಪತ್ರಿಕೆ,
ಭೂ ಪರಿವರ್ತನೆ
ಭೂ ಅಭಿವೃದ್ಧಿ ಶುಲ್ಕ ರಸೀದಿ ವಗೈರೆ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಗೂ ಮೂಲ ಪ್ರತಿಗಳನ್ನು ನಾನು ನನ್ನ ಸ್ವಂತ ಖರ್ಚು ವೆಚ್ಚಗಳಿಂದ ಸರಿಪಡಿಸಿಕೊಂಡು ನಿಮ್ಮ ವಶಕ್ಕೆ ಕೊಡಲು ನಾನು ಬದ್ಧನಾಗಿರುತ್ತೇನೆ. ಇಷ್ಟೆಲ್ಲ ನೀವು ಮಾಡ್ಬೇಕಾಗಿದ್ದು.
ಅಲ್ಲ, ಭೂ ಪರಿವರ್ತನೆ ಅದು ಯಾವಾಗ ಆಗಿದೆ, ಭೂ ಪರಿವರ್ತನೆ ಆದ್ಮೇಲೆ ಸೈಟ್ ಇವ್ರು ಪರಿಶೋಧನೆ ಮಾಡಿರೋದು. ದೆನ್ ದೇರ್ ಆಫ್ಟರ್ ಓನ್ಲಿ ದಿ ಸೈಟ್ ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಇಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸೈಟ್ ಓನ್ಲಿ, ನಾಟ್ ಲ್ಯಾಂಡ್. ಈವನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್
ಆಫರ್ಡ್ ಆಲ್ ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಅಲ್ಲ, ಅವೆಲ್ಲ ರೆಡಿ ಇದ್ದು ಇವ್ರು ಮಾಡ್ಕೊಟ್ಟಿರೋದು ಬೇರೆ
ಇತ್ತು. ಪ್ರಶ್ನೆ ಅಲ್ಲ, ನೀವು ಅವರಿಗೆ ಆಫರ್ ಮಾಡಿದಿರಾ ಎಲ್ಲ ರೆಡಿ ಇದೆ ಬನ್ನಿ ಅಂತ?
ಅಲ್ಲ, ನೋಟಿಸ್ ಎಲ್ಲ ಇದೆ.
10 ದಿನಗಳ ಮುಂಚೆ ನಿಮಗಾಗಿ
ಅಲ್ಲ, ಎಕ್ಸಿಬಿಟ್ P14
ಮೌಖಿಕವಾಗಿ ತಿಳಿಸುತ್ತೇನೆ.
ಲಾರ್ಡ್ಶಿಪ್ ಇದೆ ಎಕ್ಸಿಬಿಟ್ P14. ಎಕ್ಸಿಬಿಟ್ P14 ನೋಟಿಸ್ ಅಲ್ಲೇ ಇದೆ ನೋಡಿ, 2/3/2010. ಅದ್ರಲ್ಲಿ ಹೇಳಿದಾರೆ ಎಲ್ಲ ರೆಡಿ ಇದೆ, ಬಂದು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳಿ ವಿತಿನ್ 1 month ಅಲ್ಲಿ ಅಂತ.
P14
ಎಕ್ಸಿಬಿಟ್ P14 D14.
ಏನ್ರಿ ನಿಮ್ ರಿಪ್ಲೈ ಏನ್ರಿ? ಅದಕ್ಕೆ ಏನಂತ ರಿಪ್ಲೈ ಏನ್ ಕೊಟ್ರಿ?
ಎಕ್ಸಿಬಿಟ್ P15.
ಆಯ್ತು, ರಿಪ್ಲೈ ಕೊಟ್ರಿ. ಯಾವಾಗ? Why you have not collected the documents from him? ಕೊಡಲ್ಲ ನೀವು. ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ ಹೇಳಿ? ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ ನೀವು?
16
11. ಅವ್ರಿಗೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರೆಡಿ ಇದೆ ಅಂತ ಅಂದಾಗ ಸರಿ ರೀ, ನೀವು ರಿಪ್ಲೈ ಕೊಟ್ರಲ್ಲ, ರಿಪ್ಲೈ ಕೊಟ್ಟ ತಕ್ಷಣ ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ. ಸರಿ, ಆಮೇಲೆ ಏನಾದ್ರು ಕರೆಸ್ಪಾಂಡೆನ್ಸ್ ಇದೆಯಾ? ಸೇಲ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚಿಂದ ಹೇಳ್ರಿ, ಇನ್ ಬಿಟ್ವೀನ್
ಇಲ್ಲ. ಓನ್ಲಿ ಅಪ್ ಟು 3/12/2010 there is no correspondence. And one more
ನೀವು ರಿಪ್ಲೈ ಕೊಟ್ರಿ. In this legal notice he categorically stated that all documents are ready, you come and have the sale deed. ಆಯ್ತ್ರಿ, ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರ ಅಂತ ಕೇಳ್ದ, ಅವ್ರು ರೆಡಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ
ಆಯ್ತು. ದುಡ್ಡು ಅಲ್ಲ, ದುಡ್ಡು ಆದ ಡೇಟ್ ದುಡ್ಡಿದ್ದಕ್ಕೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ?
ಯಾವಾಗಿಂದ ರೆಡಿ ಆಯ್ತಿರೋದು?
ಇಲ್ಲ ನೋಡಿ, ಪಾಸ್ಬುಕ್ ನೋಡಿ, ಇವ್ರ ಲಾರ್ಡ್ಶಿಪ್
ದುಡ್ಡು
ಓನ್ಲಿ
ಯಾವ ವರ್ಷದಲ್ಲಿ ಇರೋದ್ರಿ? ದುಡ್ಡು ಇರೋದು ಯಾವ ವರ್ಷದಲ್ಲಿ ಅಂತ ಕೇಳಿದೆ.
2016.
2010 ನಲ್ಲಿ ಅವರು ರೆಡಿ ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಯು ಕಮ್ ಅಂಡ್ ಯಾವ್ದು ಸೇಲ್ ಡೀಡ್ ಅಂತ ನಿಮಗೆ ನೋಟಿಸ್ ಕೊಟ್ರು.
ಪಾಸ್ಬುಕ್ ನೋಡಿ
ಎಲ್ಲಿದೆ ಅದನ್ನೇ ತೋರಿಸಿ, ದಾಖಲೆ ತೋರಿಸಿ. ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್? ಯಾವ್ದು
Your lordship can see P16 and P15. ಅದ್ರೆಲ್ಲಾದ್ರೂ ದುಡ್ಡಿದೆಯಲ್ಲ ಮೇಲ್ಗಡೆ ರ್ಯಾಪರ್ ನ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Exhibit
P16 and P15.
15, 16.
ಅಲ್ಲ 18 ಅಲ್ಲಿ ಇದೆ. 18 that is 2016.
ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಹೇಳ್ರಿ ಯಾವ್ದು?
P18.
18 ಅಲ್ಲ.
15 ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ಸರ್.
16 ಇದು. 15 ನಿಮ್ ರಿಪ್ಲೈ ರೀ.
ಅಲ್ಲ
ಅವ್ರ ರಿಪ್ಲೈ 15. ಹಾ ಹೇಳಿ. 16 ಅಲ್ಲಿ ಯಾವ್ದು ದಾಖಲೆನೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನು ಬರೀ ಪಾಸ್ಬುಕ್
ಅಕೌಂಟ್ ಇದೆ, ದುಡ್ಡಿದೆ ಅನ್ನೋದಕ್ಕಿಲ್ಲ.
ದುಡ್ಡಿತ್ತು ಅಂತ ತೋರ್ಸಕ್ ಏನಾರು
18 ಡಿಪಾಸಿಟ್ ರಿಸಿಪ್ಟ್ that is 2016.
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಇವೆಲ್ಲ ಅರ್ಧಂಬರ್ಧ ರೆಕಾರ್ಡ್ಸ್
ಅಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇದೆ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಿರಾ?
ಹಾಕಿದ್ದಾರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್.
Heard on appellant counsel and also the counsel appearing for the respondent, and dispute is with regard to the readiness and having concluded the contract, and hence records are necessary of the trial court and appellate court. The counsel appearing with the appellant would contend that would submit that execution is filed. And
execution number 12 of
counsel
2024.
appearing with the respondent would submit that not going to pursue the execution petition till next date of hearing, and hence the said submission is taken on record. List this matter on 4/8. Prasanna BR.
The trial court granted 1/6 share in the A schedule property. That has been confirmed by the appellate court. But however, my lord, the directed to
clear the loan anta. Loan ಇದೆ ಅದನ್ನ ಕ್ಲಿಯರ್ ಮಾಡಿ ಅಂತ.
ಹೌದು, ಲೋನ್ ತಗೊಂಡವರು ಅವರು ನಾವನು.
ಯಾರು?
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1A.
ಹಾ.
She has availed the loan.
Now you are challenging only the portion
Please,
of the
please.
order.
That is only.
Direction given to whom to clear the loan amount?
Liable to clear the outstanding loan from the bank in appropriate share ಅಂತ ಹೇಳ್ತಾರೆ. Appropriate share ಪ್ರಕಾರ ಮಾಡಬೇಕು.
It is ordered and declared that entitled for 1/6 share in each and the Asian properties by means and loan. Loan ಏನಕ್ಕೆ ತಗೊಂಡಿದ್ದು?
ಲೋನ್ ಡೆವಲಪ್ಮೆಂಟ್, ಪ್ರಾಪರ್ಟಿ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಕ್ ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ದೇ ಆರ್ ಎಂಜಾಯ್ಡ್ ದಿ ಬೆನಿಫಿಟ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟೀಸ್ ಆಲ್ಸೋ.
ಯಾವಾಗ ತಗೊಂಡಿರೋದು ಲೋನ್?
ಲೋನ್
ಅದಕ್ಕೆ ಡಿಸ್ಕಷನ್ ಇರ್ಬೋದು ನೋಡಿ. If it is the development of the property, if you get the share over the property, if developed property you are going to get the share, then you are also liable to pay that amount.
Well, that's correct, but development, how they are developed, that is not forthcoming.
ಏನ್ ಮಾಡ್ಬೇಕಾಗಂತಂದ್ರೆ ಏನ್ ಪ್ರಾಪರ್ಟಿ ಏನು?
ಅಗ್ರಿಕಲ್ಚರ್ ಪ್ರಾಪರ್ಟಿ.
ಏನ್ ಮಾಡಿದ್ದಾರೆ ಡೆವಲಪ್?
ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಏನು ಹೇಳಿಲ್ಲ.
ಏನ್ ಗ್ರೋ ಮಾಡಿದಾರ್ರಿ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ?
ಇಲ್ಲ, ಅದು ಏನಿಲ್ಲ.
ಪರ್ಮನೆಂಟ್ ಕ್ರಾಪ್ ಏನಾರು ಇದೆಯಾ?
ಇಲ್ಲ.
It has come in the evidence of defendant number 1A performed the marriage of plaintiff. Defendant number 1A has availed the loan from the Canara Bank to improve the scheduled properties. Exhibit D1 letter shows that plaintiff have given the consent for availing the loan. Thus, as contended by defendant number 1A to 1E, plaintiffs also liable to clear the loan borrowed from the banks in proportionate to their share. The contention of the plaintiff that they are entitled for the share in the A scheduled properties free of charges on these properties. Yesterday the bank loan?
Not they have taken 16 lakhs loan ತಗೊಂಡಿದ್ದಾರೆ.
16 lakhs. ಅದಕ್ಕೆ ಕೇಳಿದ್ರೆ ಏನಿದೆ ಪ್ರಾಪರ್ಟಿ ಅಂತ?
ಪ್ಲಾಂಟೇಶನ್ ಮರಳ, ದಟ್ ಇಸ್ ಪ್ರಾಪರ್ಟಿ.
ಪ್ಲಾಂಟೇಶನ್ ಏನ್ ಪ್ಲಾಂಟೇಶನ್ ರೀ?
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಇಲ್ಲ ಸ್ವಾಮಿ.
ನೀವೇ ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿದ್ರಿ ಲೋನ್ ತಗೊಳಕ್ಕೆ ಎಲ್ಲದಕ್ಕೂ ಡೆವಲಪ್ ಮಾಡಕ್ಕೆ ಪ್ರಾಪರ್ಟಿನ.
ಬಟ್ ಲೋನ್ ಹ್ಯಾಸ್ ಬೀನ್ ಯುಟಿಲೈಸ್ಡ್ ಬೈ ದೆಮ್.
ಯುಟಿಲೈಸ್ ಮಾಡ್ಲಿರಿ, ಯುಟಿಲೈಸ್ ಸ್ವಂತಕ್ಕೆ ಮಾಡಿರೋ ಪರವಾಗಿಲ್ಲ, ಪ್ರಾಪರ್ಟಿ ಡೆವಲಪ್ ಮಾಡಕ್ ಮಾಡಿರೋದಲ್ವಾ?
ಪ್ರಾಪರ್ಟಿ ಏನ್ ಡೆವಲಪ್ ಮಾಡಿದ್ರು?
ಪ್ರಾಪರ್ಟಿ
that contention has negated by the trial court. What contention taken by the
ಅದಕ್ಕೆ ಕೇಳಿದೆ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಏನ್ ಗ್ರೋ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕೇಳಿದೆ.
That is no discussion, not receiving.
No discussion.
Please.
ಅವ್ರದ್ದು ಏನಕ್ಕೆ ನಾನು ಲೋನ್ ತಗೊಂಡು ಇಂಪ್ರೂವ್ ಮಾಡಿದೀನಿ ಅಂತ ಅವ್ರು ಹೇಳಿಲ್ವಾ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ?
ಲೋನ್ ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ.
ಅದಕ್ಕೆ ನೀವು ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ದಟ್ ಈಸ್ ದಿ ಅಬ್ಸರ್ವೇಷನ್ ಮೇಡ್ ಬೈ ದಿ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಫಾರ್ ಅವೈಲಿಂಗ್ ದಿ ಲೋನ್ ಫಾರ್ ಕಲ್ಟಿವೇಶನ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ.
Please.
ಯಾಕೆ ಏನ್ ಕಲ್ಟಿವೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೂನು?
ಪ್ಲಾಂಟೇಶನ್ ಲ್ಯಾಂಡ್ ಅಂತ ತೋರಿಸ್ತದೆ.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ ನೆಕ್ಸ್ಟ್ 24/7 ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 24/7. ಪ್ಲಾಂಟೇಶನ್ ಅಲ್ಲಿ ಏನ್ರಿ ಏನ್ ಬೆಳೆದಿದ್ದಾರೆ ಅಂತ ಕೇಳಿದೆ. 16 ಲಕ್ಷ ತಗೊಂಡು ಏನ್ ಬೆಳೆದಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ
ನೋಡಿ ಹೇಳಿ.
ಮತ್ತೆ ನೋಡ್ಕೊಂಡು ಹೇಳಿ 24/7. ಓನರ್ ಆಫ್ ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಪೊಸಿಷನ್ 30 ಕೊಂಡ hand over the possession. ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ.
Initially sought for an adjournment.
Why an adjournment, counsel?
Because the limited ground, my lords, that the appellant is seeking to urge is whether the courts below, my lords, were right in decreeing the suit, relying on a vague and uncertain commissioner's report.
Uncertain commissioner report.
Please, my lords.
Have you filed objections to the
We
commissioner?
filed
report?
our objections, my lords. He himself admits that the property, my lords, the issue is this. In the concerned survey number, my lords, there's about 1,000 acres of government land. Insofar as the appellant is concerned, as well as the respondent, my lords, by way of unauthorized occupation, the government grants 3
Granted
acres
the land.
and 2.84 acres respectively. Now, the respective ownership is not in dispute. Only a certain portion of my land, my lord, and both properties are adjacent to one another. Only a portion of the land that belongs to the appellant, and we have been cultivating rubber in the said property, my lords, for over 3 decades now. Right from my father's time. Now the issue, my lords, is that the respondent is claiming 0.30 acres of that land. Now the court commissioner, my lords, himself admits that due to unavailability of records, due to unavailability of durasti and other records, my lords, it is difficult to ascertain the exact extent. It is only on this limited ground, my lords, that I would. May I read the commissioner's report? ಮೇಲೆ ತಿಳಿಸಿದಂತೆ ವಾದಿಗಳು ಅನುಭವದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಆಸ್ತಿಯ ದಕ್ಷಿಣ ಭಾಗದ ಆಸ್ತಿಯಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳು ಅನುಭವದಲ್ಲಿ ಇರುತ್ತಾರೆ. ಸದರಿ ಆಸ್ತಿಯು ಗ್ರಾಮದ ನಕಾಶೆಯಲ್ಲಿ ದುರಸ್ತಿ ಆಗದ ಕಾರಣ ಗುರುತಿಸಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ. Subsequent to this, only upon the instructions given by the respondent, he furnishes a report. The respondent shows, my lords, that this is my property and I'm in possession. Based on that, a report and a map is filed. And on the basis of this report, my lords, both the courts below, my lords, have decreed against us. And there is also a history, my lords, to this particular case. Initially, my lords, it was the appellant who had, it was the respondent, my lords, who had filed a suit. Initially, my lords, the appellant had filed a suit, my lords, for possession. And on subsequently, during pendency of the suit, we acquired possession, my lords. And in that case, the respondent had also filed a counterclaim. Now that suit, my lords, came to be withdrawn. And the counterclaim also, my lords, came to be dismissed without reserving any liberty in favor of the respondent to initiate a subsequent suit. Despite which, my lords, they initiated a subsequent suit. Another question of law that we are raising, my lords, is of estoppel.
But issue number 3 is answered as negative. Based on the commissioner report.
Please, my lords, it is, I would want to urge anything apart from the veracity
Whether
and
the
the
plaintiff is
correctness.
entitled to get mean profits from defendant for his wrongful possession over the B schedule property. And also issue number 2 is partly affirmative. Plaintiff further proves that the defendants encroached over the A schedule property and are all illegal
My lords,
possession of B schedule
initially, the
property
trial court, my lords, had refused to grant mean profit. And if your lordship see the sketch also, my lords, that
issue number 2 is answered partly affirmative that
they were claiming, my lords, an extent of 1 acre of land, 1 acre and more. However, the court commissioner said, no, that's not possible, only 30 cents will be granted. Even in that 30 cents, my lords, he has granted it only on the basis of the appellant's, the respondent's instruction that he is in possession and of the said property. The mean profit, my lords, was later granted. If your lordship see the sketch, my lords, that was prepared by the court commissioner, it is more, the entire extent, my lords, is in Kodagu and it is jungle. ಕೆಳಗಡೆ ಅವ್ರ ಮನೆ ಇರತ್ತೆ, ಅವ್ರ ಮನೆ ಹತ್ರ ಏನೋ ಇದು ಕೃಷಿ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. Subsequently, after that, it is all jungle land, my lords. Then the property of the appellant starts. In the property of the appellant, my lords, from almost 30 years, we have been growing rubber, and we're doing tapping also. ಮಧ್ಯದಲ್ಲಿ ಎಲ್ಲೂ ಕೃಷಿ ಮಾಡ್ತಾ ಇರಲ್ಲ, ಆಮೇಲೆ ಮತ್ತೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಮೇಲೆ ಬೆಟ್ಟದ ಮೇಲೆ ನಾವು ಇದು ನಮ್ದು ಜಾಗ ಅಂತ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ. If a proper commissioner is appointed, my lords, to conduct a resurvey. The issue of mean profit also, my lords, was kept open. The trial court had directed for a separate inquiry. The issue of mean profit also, my lords, the appellate court had answered that the respondent is entitled to mean profit. However, a separate inquiry must be initiated.
But commissioner report is very clear that 0.30 cents of land you are in possession of the property, that is an encroachment.
My lords, it is our contention that we are not in encroachment at all. It is two adjacent properties. ಯಾರ್ದು ಎಲ್ಲಿ ಜಾಗ ಇದೆ ಅಂತ ಗವರ್ಮೆಂಟ್ ಅವ್ರ ಹತ್ರನೇ ರೆಕಾರ್ಡ್ಗಳಿಲ್ಲ.
ರೆಕಾರ್ಡ್ ಇದು ಸ್ಕೆಚ್ ಮಾಡೇ ಕೊಟ್ಟಿರೋದ್ರಿ ಲ್ಯಾಂಡ್ ನ ಸರ್ವೆ ಮಾಡಿದಾರಲ್ವಾ? given the no objection to survey the report also, commissioner.
We have clearly stated, my lords, that this particular 30 cents belongs to us. Ivaga if on just a practical.
What material you have placed that 0.30 cents of land belongs to you?
From almost 3 decades, they've been paying tax.
Paragraph number 15.
My lords?
You see the paragraph number 15 of the trial court. Read. You read para 15.
After going through the documents and oral evidence, there is no such encroachment as alleged by the plaintiff. But the defendant is in possession of 0.30 acres of so and so land. The defendant has not established that he is in possession of his land, and the said 3.
ನಿಮಗೆ ಓದ್ಕೊತಿದ್ರೆ ನಮಗೂ ಗೊತ್ತಾಗ್ಲಿ ಅಂತ ಓದ್ತಾ ಇದ್ದೀರಾ?
This defendant has not established that he is in possession of his land, and said 0.30 acres belong to him. No such documentary evidence led to.
Defendant is in possession of 0.30 acres in survey number 155/579, land allotted to the plaintiff. The defendant has not established that he is in possession of his land, and said 0.30 acres belongs to him. No such documentary evidence led to prove the extent of his possession. Therefore, the plaintiff has established encroachment by the defendant, but an extent of encroachment is as alleged by the plaintiff is not proved. 1.50 ಬದಲು only 0.30 ಮಾತ್ರ encroachment ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
Correct.
What is the answer elicited from the CW1?
CW1 clearly admits, my lords, that there is no documentary evidence, and only on the basis of the direction given by the
answer elicited from the mouth of commissioner counsel. You have disputed the report of the commissioner that has been discussed in answering issue number 5. ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ದಕ್ಷಿಣಕ್ಕಿದೆ.
ನಮ್ ಪ್ರಾಪರ್ಟಿ ದಕ್ಷಿಣ.
You are in the encroachment to the area of 0.30 acres.
My lords, the reality on the ground is this, my lords. It's a hill. ಕೆಳಗಡೆ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಇದೆ, ಮೇಲೆ ನಮ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ. ಕೆಳಗಡೆ ಅವ್ರ ಮನೆ.
Your property is on the south of the plaintiff's property.
on the south of the property, my lords, in wherever the respondent is, house is placed, there he is carrying out certain agricultural activity. Above all of that, towards the south, is all jungle land, my lords. There is no possibility of the respondent to even cross that land, come cross about 1.5 acres and then cultivate there. To the south from the entire, we have also created some boundaries, my lords. Certain fencing has been done. Tax katta idivi aa jagakke for almost 3 decades. And even the government authorities, my lords, land has been granted to me 3 acres. Aa 3 acres na survey madilla. They've only surveyed what is given there. So only upon the instructions of the court
You would have requested the court to
we
survey
requested, my
both
lords.
your land and also his
we
land.
requested that, my lords. We requested that, however, it has failed.
Memo of instructions ಕೊಟ್ಟಿದ್ದೀರಾ ಕಮಿಷನರ್ ಹೋಗಕ್ಕಿಂತ ಮುಂಚೆ?
To check.
ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋದು 2.84. ಅವ್ರು they are in possession only to the extent of 2.54. Remaining 30 cents of land.
No, they are.
You are in possession of the property. That is the finding of the trial court also.
My lords, to ascertain who is actually in possession of these 1,000
But
acres
the
is
commissioner
difficult.
was appointed.
The commissioner's report is what I'm challenging. If a commissioner is appointed by this
That's
honorable
why I
court, my
asked
lord.
you, anything is elicited from the mouth of commissioner who has been examined as CW1 before the trial court. Nothing is elicited.
Well, however, his report only clearly indicates, my lords, that.
Report allade 30 cents ನೀವು ಇದೀರಾ ಅಂತ report ಇದೆ ರೀ.
But on what basis has he come to that that finding, my lords, is not provided by him. We have established, we have inquired as to what procedure he adopted. Some unscientific method, my lords, he has adopted and he's provided this.
What is that unscientific method?
Based on the instruction given by the respondent, my lords, he has laid certain stones and he has just measured it with the help of a surveyor. Apart from that, he hasn't seen how much is our extent, how much is their extent, namige grant aide, aurige grant aide. And he very clearly admits, my lords, now governmental map illa, nakasha illa, ಆಮೇಲೆ ಬೇರೆ ಯಾವುದೇ ತರಹದ ದಾಖಲಾತಿಗಳು ಇಲ್ಲ, ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ, we have to go ahead with this one. If a proper survey is conducted, my lords, the real fact will come out. And the sketch may be perused, man. The sketch that.
That's all. ಹೇಳ್ರಿ ಏನು? Even second time also commissioner went and inspected the property when there was no objection.
Initially,
even memo of instructions also filed by both the councils. Hmm. 30 cents also.
Your lordships may see the sketch, my lords, that's prepared by the commissioner.
30 cents of land.
I'm adjacent to the place, man. Your lordships may see the sketch for one moment.
That's all thought.
The sketch, if your lordships may see just for a moment.
ಹೇಳಿ sketch ಕೊಡಿ ಏನು ನೋಡೋಣ. sketch ಅಲ್ಲಿ specific ಆಗಿ ತೋರಿಸಿದಾರೆ ನೋಡಿ, you are in possession to the extent of 0.30.
No, no, Baga, only on logical reasoning, my lords, Baga ಎರಡರಲ್ಲಿ ಅವ್ರು ಕೃಷಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಇದೆ.
ಕೃಷಿ ಮಾಡ್ತಾ ಇರೋದು only remaining area 95 cents.
Please.
Not to the extent of
the 1 acre, my lords.
2.84 cents.
What has been marked as 1 in the sketch, my lords, is entirely jungle area. In that jungle area, there is no possibility, my lords, that the respondent is even cultivating anything. Out of greed, my lords, to acquire my property. It's sketch not the ಕೆಳಗಡೆ ಎಲ್ಲ ಇರುತ್ತೆ ಇಲ್ಲಿ ಮೇಲೆ.
That is also measured. That is 1.72 cents of land. That is not under cultivation. Only cultivation is only 95 cents.
This disputed
total is 2.54. His claim is 2.84, short of 30 cents of land. That is in the possession of you. That is the report.
This disputed portion, my lords. This disputed portion comes under the place where he is
appearing for the appellant and also the counsel for the respondent. This appeal is filed against the concurrent finding of the trial court. The factual matters of case of the plaintiff before the trial court while seeking the relief of declaration and possession. Specific case of the plaintiff is that he is the absolute owner of the A schedule property by virtue of grant by the land grant committee of Madkeri Taluk. And also it is the specific case that A schedule property was the granted land and the defendant is in illegal possession of B schedule property without any right, title or interest. And also sought for the relief of the possession in respect of B schedule property which is in illegal occupation of the defendant. And defendant appeared and filed a written statement contending that he is not in encroachment of any property and also filed a written statement stating that suit is barred by limitation and not entitled for any relief of the declaration and possession as sought. The plaintiff, in order to prove his case, examined himself as PW1 and also got marked document exhibit P1 to 10 and also examined PW2. On the other hand, defendant examined himself as DW1 and got marked document exhibit T1 and T2. The commissioner was also appointed before the trial court and commissioner went and inspected the property and given the report in terms of exhibit C1. And also both the advocates have filed memo of instructions before conducting the spot inspection. And the commissioner report exhibit C1 is very clear that there was a encroachment to the extent of only 0.30 cents of land. And trial court having considered the report as well as the evidence available on record in paragraph number 15, while answering the issue number 2 comes to the conclusion that plaintiff has established an encroachment by the defendant having considered the encroachment to the extent of 0.30 acres belong to him. Also, while answering issue number 4, that is in respect of limitation aspect, also taken note of the pleadings of the parties and also plaintiff is claiming possession of schedule B property on the basis of his title and also considered article 65 of Limitation Act and in detail discussed application of the applicable application of limitation and also having considered the material on record while answering issue number 5 also taken note of the property granted in favor of the plaintiff is schedule A property measuring 2.84 acres in survey number 155/579 and also answering of issue number 3 comes to the conclusion that that is the total extent of land granted to him. And surveyor also submitted exhibit C2 and C3 on basis of exhibit C2 and C3 the commissioner has filed his report as per exhibit C1 and also the answer elicited from the mouth of the commissioner as well as report the same is extracted in paragraph number 22 discussed in detail that plaintiff is in possession of only 1.74 acres in survey number 155/179 and total possession of the plaintiff is 2.54 acres including the portion of the property which is in his occupation and cultivation. And in terms of exhibit P1, the total extent is 2.84 acres and measurement shown in exhibit P5, Sakvali chit is also the same and also taken note of exhibit C3, the surveyor marked the area of 0.30 acres in green color, which is in the possession of the defendant, and disprove the fact that defendant neither led oral or documentary evidence before the trial court with regard to he has been in possession to the extent of 0.3 acres belongs to him, and no documents are produced before the trial court to claim that the 0.30 acres of land belongs to him, and hence granted the relief as sought in respect of only portion of the property, declaring that A scheduled property belongs to the plaintiff and plaintiff is entitled for possession only 0.30 acres in survey number 155/579, and defendant is also directed to deliver the possession of 0.30 acres of land which is identified as is in the possession of the defendant. The judgment and decree of the trial court is questioned in area number 16 of 2021, and appellate court having considered the grounds urged in the appeal memo, and issue is also only with regard to the possession is concerned, that is B scheduled property, though it is claimed measuring 1.50 acres out of 2.84 acres, and taken note of the commissioner report and also formulated the point in the appeal. Whether the plaintiff proves the encroachment as shown in B schedule property, and appellate court also reassessing the material available on record comes to the conclusion that there is an encroachment and answer the point as affirmative with regard to the finding of trial court that there is an encroachment to the extent of 0.3 acres. The same is discussed in paragraph number 35 of judgment of the appellate court, having reassessed the material on record that commissioner was inspected the property and resurveyed the land in view of both the council agreed for the same, and also court commissioner taken note of some of instructions given by both the parties, and also plaintiff has established that only portion of the property to the extent of 0.3 acres ends of land only defendant is in encroachment, not as claimed in 1.50 acres of land as contended by the plaintiff, and answer the same as affirmative. That is point number 2. Being agreed by the finding of concurrent finding of trial court as well as the appellate court present, second appeal is filed before this court. The council would vehemently contend that the report is not based on the scientific report, and also council would vehemently contend that judgment and decree passed by the trial court is against the material on record, and also both the courts relied upon vague and uncertain report of the court commissioner, and hence ought not to have relied upon the report, and hence this court has to frame substantive question of law whether the judgment and decree passed by both the courts are without appreciating the facts and circumstances of the case, much particularly regarding law of estoppel, res judicata, and abandonment of the cause of action. Having heard the appellant, the counsel appearing for the respondent would contend that commissioner was appointed with the consent, and also both of them have given the memo of instructions, and based on the instructions only commissioner conducted the spot inspection and measured the land and given only encroachment to the extent of 0.30 acres of land, not as claimed by the plaintiff to the extent of 1.50 acres of land. And both the courts have taken note of evidence of both the plaintiff as well as defendant, and also the commissioner report, and also the evidence of the commissioner comes to the conclusion that encroachment is only to the extent of 0.30 cents, and hence it doesn't require any interference Having heard the appellant counsel and also the counsel appearing for the respondent, the main contention of the counsel appearing for the appellant that both the courts failed to appreciate the facts and circumstances of the case, and also counsel contend that law of estoppel is applicable to the case on hand, and also res judicata and abandonment of the cause of action. And having perused the plaint averments, the specific case of the plaintiff before the trial court that 2.58084 cents of land was allotted, and A scheduled property is the property is allotted to the plaintiff, and only claim made in respect of enclosed portion. And though claimed 1.50 acres of land as in the occupation of the defendant, but commissioner was appointed, and commissioner went and inspected the spot, and also both the councils have filed memo of instructions and answered the memo of instructions in coming to the conclusion that encroachment is only to the extent of 0.30 cents. No doubt objection is filed to the commissioner report, and commissioner was also examined before the trial court, and nothing is elicited from the mouth of CW1, even though counsel contend that commissioner report is not scientific report, and in the cross examination with regard to the possession of 0.30 acres of land is concerned, nothing is suggested to the CW1 and elicited any answer. And apart from that, he has not made any claim in respect of the said 0.3 acres of land, placing any document before the court, and the same has been considered by the trial court in paragraph number 15 while answering the issue number 2, and appellate court also while answering the issue number 2, having reassessed the same, taken note of commissioner report as well as evidence of PW1 and DW1. And when searching the case, in both the courts have applied their mind for the consideration of factual dispute with regard to the possession of the property which was claimed, and since the defendant also not claiming any right in respect of the A scheduled property is concerned, and only his grievance is in respect of B scheduled property, but he claims that the same belongs to him, but the commissioner identified the said property, that property which is in occupation of the defendant is in survey number 155/579, and the land which was granted in favor of the plaintiff. And when such factual finding and also taken note of the mixed question of fact and law by the appellate court, I do not find any ground to admit and frame substantive question of law, and there is no any ground to admit and frame substantive question of law. In view of the discussions made up, I pass the following order. Second appeal is dismissed. Next 60. Obliged.
Number 16 ಅಲ್ಲಿ process is yet to be completed.
Serial number 60.
16 ಅಲ್ಲಿ RFA RSA
60.1 ಅಲ್ಲಿ
ಅದರಲ್ಲಿ it used to be ಇದು ಸುಮಾರು ಅಯ್ಯಗಳೆಲ್ಲ ಇದೆ.
ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್? ಎಲ್ಲಾರ್ ಸಹ R3C ನ
R3C ಆಗಿದೆ.
R3C
ಆಗಿದೆ.
ಆಗಿದೆ R3C ಆಗಿದೆ.
ಅಯ್ಯ ಹಾಕಿದಿರಿ?
ಅಯ್ಯ ಹಾಕಿದೀನಿ.
ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಆಗಿದೆ.
8 ಗೆ
1 and 3 ಆಗಿದೆ. What about 2? Sufficient ಅಗರ್ ಅಲೋ ಆಗಬೇಕು IAS.
R8
IAS ಅಲೋ ಆಗಬೇಕು ಇದು. ಹೌದಾ? Order on IA number 1 of 23 for there is a delay of 220 days in filing the LR application in bringing the LRs of R3C, and also
R8.
Prayer is sought to set aside the abatement in terms of IA number 2, and also IA number 3 for bringing LRs of R3C on record, and R3C 1 and 3 have been served, and also this court held that R3C 2 is held sufficient, and they have not engaged any counsel and objected for bringing them on record, and for the reasons stated in the accompanying application and affidavit, and affidavit, the applications are allowed by condoning the delay, and abatement is set aside and permitted to bring the LRs on record of R3C, that is R3C 1 to 3. Appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks. ಇದೇನೋ ಒಂದು ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಇದೆಯಲ್ಲ, ಯಾರ್ದಿದ್ದು? ಶಿವರಾಮ ಯಾರ್ದಿದ್ದು?
I am for the
ಟೀಮ ಶಿವರಾಮನ? ಹಾ ಹೇಳಿ.
R8 to 1
8 ಸತ್ತೋಗರ
ಅವ್ರಿಗೆ ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದಿದೆ ಸರ್. ಮೇ ಬಿ ಹೇಳಿ ಸರ್.
ಯಾರಿಗೆ ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದಿದೆ? ಅವ್ರಿಗೆನಾ?
R8 1 to 3
ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂದ್ರೆ ಇಂಟಿಮೇಷನ್ ಡೆಲಿವರಿ ಆಗಿದೆಯಾ ಮೇಡಮ್? ಮತ್ತೆ ಪೇಪರ್ ಬುಕ್ ಪೇಪರ್ ಅಪ್ಲಿಕೇಶನ್ R8 LRs ಹಾಕಿದ್ದೀರಾ? Then you take notice, that's all. Counsel say, Guru Sandeep Singh undertakes to file undertakes to appear on behalf of the LRs of R8. That is R8 1 to 3 na?
1 to 3.
1 to 3. And hence given 2 weeks time to file a wakalat. Objections ಏನಾರು ಇದೆಯಾ ಅಥವಾ ಅಯ್ಯ ಅಲೋ ಮಾಡ್ಬೋದಾ? ಹರ್ಡ್ ಆನ್ ಅಯ್ಯ ಅವ್ರಿಗೆ ಎಲ್ಲಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರ ಇಲ್ಲಿ? ಯಾವ್ದಿದೆ ಮೇಡಮ್? ಅಯ್ಯ ನಂಬರ್ 4 of 23 ನಾ? ಅದು ಒಂದೇ. Heard on A number 4 of 23 wherein prayer is sought to bring the LRs of R8. And hence, counsel appearing for the LRs says no objection. And hence A number 4 of 23 is allowed. Permitted to bring the LRs of
4 to 6 ಇದೆ, 3 ಇದಾವೆ.
4 to 6 ಇದೆ. 6 actually.
Bring LRs of records so and so.
4 to 6
CD,
ಇದೆಯಾ ನೋಡಿ.
44 days CD ಇದೆ.
ಡಿಲೇನೋ ಇದೆಯಾ?
ಡಿಲೇ ಇದೆ.
ಏ ತೋರಿಸಿಲ್ಲ ಇಲ್ಲಿ.
ಅಯ್ಯೋ 4 to ಹಾಕಿದ್ದಾರೆ.
4 to 6 ಹಾಕಿದ್ರೆ and also filed an application to set aside the abatement and also bringing LRs. ಡಿಲೇನಾ? ಡಿಲೇ ಇದೆಯಾ?
44 days.
There is a delay of 84 days. And
44 days.
44 days and hence for the reason stated in the accompanying application of private and seriously not objected by the LRs. Yes sir, allowed, delay is condoned, abatement is set aside and permitted to bring the LRs on record. ಈಗ ಅದನ್ನ ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್, permitted to amend the cast title ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿಗೆ ಅದು ಆಯ್ತು 2 weeks.
ಅದು ಅಯ್ಯ 1 of 25.
1 of 25 is not survive for consideration in view of undertaking made by the LRs of R8. And hence ಅಯ್ಯ 1 of 25 is dismissed. Next. Mostly 44 days delay ಇರೋದು ಅಪೀಲ್ ಇರ್ಬೇಕ್ರಿ. ಅದು ಅಪೀಲ್ ಇರ್ಬೇಕು ನೋಡಿ, ಅಯ್ಯಗಲ್ಲ. ಇದೆಯಾ ಮೇಡಮ್ ಅಯ್ಯ ಏನಾರು?
ಅಯ್ಯ 25 subsequent service of notice by paper publication 1 of 25.
ಅಲ್ರಿ ನೀವು bringing LRs of R8 ಅದು ಅಪೀಲ್ ಇರೋದು ಮೇಡಮ್. ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಅಯ್ಯ
ಅದು 1 of 2017.
4, 5, 6 ಅಲ್ಲಿ ಎಷ್ಟು ದಿವಸ ಇದೆ ಡಿಲೇ? ಈಗ 44 days ಒಂದು 44 days ಇರಲ್ಲ ನೋಡಿ ಹೇಳಿ. ಅವರು ನೋಡಲ್ಲ, ನೀವು ನೋಡಲ್ಲ, ನೋಡಿ ಹೇಳಿ.
220 days 220 days ಡಿಲೇ ಅಂತ ಇದೆ.
ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರ? ಅದ್ರಲ್ಲಿ ಬ್ಲಾಂಕ್ ಬಿಟ್ಟಿದಾರ? ಕೊಡಿ ಹೋಗ್ಲಿ, ನಾನೇ ನೋಡ್ತೀನಿ.
ಅಯ್ಯ ಫೈಲ್ಡ್ ಮೈ ಲಾರ್ಡ್. ಅಯ್ಯ
4, 5, 6 ಕೊಡ್ರಿ. ಅದ್ರಲ್ಲಿ ನೀವು ಎಷ್ಟು ದಿವಸ ಡಿಲೇ ಏನು ಹೇಳೇ ಇಲ್ಲ.
ಮೈ ಲಾರ್ಡ್ 220 days ಡಿಲೇ ಇಸ್ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ.
ನಿಮ್ಮ ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ?
1 of 2023. 1 of 2023.
ಅದಕ್ಕೇನು ಅಫಿಡವಿಟ್ ಇಲ್ಲ ಮೇಡಮ್? ಯಾಕೆ ಅಪ್ಲಿಕೇಶನ್ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿ ಅಫಿಡವಿಟ್ ಆಮೇಲೆ ಹಾಕ್ತಾರೆ? ಇಲ್ಲ ಅಫಿಡವಿಟ್ ಏನು ಇಲ್ವಲ್ಲ? ಡಿಲೇ ಕಂಡೋನೇಷನ್ಗೆ ಇದೆ, ಇಲ್ಲಿದೆ ನೋಡಿ 5 of ಇಲ್ಲಿ ಬರ್ದವ್ರು ನೋಡಿ 3745 days ಇರ್ಬೇಕು ನೋಡ್ರಿ. ಕಂಡೋನ್ ದಿ ಡಿಲೇ ಆಫ್ 3745 days. ಎಲ್ಲ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ಅಪೀಲ್ಗೆ ಇದ್ದಿದ್ದ ಇಲ್ಲಿ ಹೇಳೋದು ಅಲ್ಲಿ ಹೇಳೋದು. ಈಗ ಅಬೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ಮೇಡಮ್, ಇಲ್ಲಿ ಹಾಕ್ತಂಗಿಲ್ಲ. 22 rule 9 ದಟ್ ಈಸ್ ಆಲ್ಸೋ. ಆಯ್ತು. 4, 5 and 6 are allowed. ಅದು ಡೇಟ್ಸ್ ಹಾಕೊಬಿಡಿ ಮೇಡಮ್. allowed and amendment carried out. List this matter for admission ಅಲ್ಲ ಇನ್ನ ಅಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಯ್ತಲ್ಲ ಸರ್ವಿಸ್. List this matter for admission on 24/7. AV Gangadharappa for R2. Neeraja Karan 40 days delay. ಏನಾಯ್ತು ಬಂದ್ರ ಅದರ್ ಸೈಡ್? ಹೇಳಿ. ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ. ಹಾ ಹ್ಮ್ That's all. Third. Huh? ಅದ್ ಮಾಡೋಣ. Heard the appellant counsel and also the counsel appearing with the respondent. This RSA is filed against the order of rejection of IA number 1, wherein there was a delay of 40 days in filing the appeal. The trial court dismissed the application on the ground that though stated that she was suffering from left chest wall injury and left lean medical collateral ligament injury, and no document is placed and also not examined herself before the court and not shown any sufficient reasons. The counsel appearing for the appellant would contend that the delay only 40 days and court has to take note of delay of only 40 days in filing and reasons also given, and the court cannot expect the document for the delay of 40 days and ought to have taken note of in a lenient way, and the same is not considered, and the order is very too technical. The counsel appearing with the respondent would contend that the appellant, though stated that suffering from the ill health, not produced any document and even not entered into witness box to show the sufficient cause, and hence rightly dismiss the same. However, counsel would contend that they are taking note of the non-consideration of appeal. ಅದನ್ನ ಬರಿಲ್ಲ ಬೇಡ, ಮೆರಿಟ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು ಬೇಡವಾ? ಆಯ್ತು, ಏನಾಯ್ತು ಹೇಳಿ ಮೇಡಮ್. Having heard the appellant counsel and also the counsel appearing for the respondent and also reasoning assigned by the trial court, and the appellate court should not be too technical while considering the regular appeal, that is a statutory appeal, for consideration of the impugned order of judgment of the trial court, and delay is only 40 days, and even though reasons are stated that suffering from ill health, and with regard to the 44 days delay, ought not to have expected the medical records, and
Medical certificate is filed.
ಹಾಕಿದೀರಾ?
ಹಾಕಿದ್ದೀವಿ.
ಮತ್ತೆ ಹಾಕಿಲ್ಲ ಅಂತ ಏನು ಹೇಳ್ತಾರೋ?
Eighth paragraph number
ಎಕ್ಸಾಮಿನ್
8
ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅಂತನಾ? ಏನ್ ಹಾಕಿದಿರಿ ನೀವು?
ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹಾಕಿದ್ದೀವಿ.
ಎಲ್ಲ ಹಾಕಿದಿರಿ? ಇದೆಯಾ?
ಲೆಫ್ಟ್ ಚೆಸ್ಟ್ ವಾಲ್ ಇಂಜುರಿ. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ಇದೆ.
ಎಲ್ಲಿದಾಗಂತ?
ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
ಪ್ಯಾರಾ 8?
ಹಾ.
Oh, petitioner who has given the same has not been examined, ಅಷ್ಟೇ, neither has the appellant entered the witness box. ಅದೇ ರೀ ಹೇಳಿರೋದು.
Here it is seen that
except for filing IA number 1, the appellant has not made out any ground to
medical certificate is available on record ಅಂತ ಇದೆ.
ಇದೆಯಾ?
ಇದೆ.
But it is seen that though medical certificate is available on record,
ಹೌದು.
and also having considered an observation is made that medical certificate is available on record but not examined herself before the court. And also the while considering the delay of 40 days application, delay of 40 days, the trial court ought to have taken note of substantive right of the parties and not on technicalities, and ought to have met the substantial justice and not dismissing the application on technical ground, and hence the order impugned is liable to be set aside and matter requires to be considered on merits. In view of the same, appeal is allowed, impugned or passed by the trial court on IA number 1 is set aside. The matter is remitted back to the trial of a first appellate court to consider the appeal on merits. Suit was filed in the year 2013 and appeal was of the year 2022. 22 alla?
Please.
22 na?
Please. 22 minutes.
22. And almost the parties have approached the court 1 decade ago, and hence it is appropriate to direct the first appellate court to dispose of the matter in accordance with law by giving an opportunity to both the respective parties and consider the same on merits within a time bound period of 6 months. 6 months. And main inyadu delay is condoned. ಹಾಕ್ಬಿಡಿ, delay is condoned and consider on merits ಅಂತ ಬರ್ದಿದ್ದೀನಿ, giving an opportunity.
Obligement.
Consequently, IA number 1 filed before the appellate court is allowed ಅಂತ ಮಾಡಿ ಆಮೇಲೆ ಮಾಡಿ operative portion.
Obligement.
Sorry, HR. Decreed.
Lord, it's a
Equally
defendant.
entitled for A1 share. ಹೇಳ್ರಿ.
Lord, suit was filed by one of the the brothers, wife and children seeking partition. Lords, the petition appellant herein was the different number 5 in the suit. In that he has contested the matter. Facts in brief, my lords. The appellants herein and respondents are children of one Narsappa who died, my lords, in the year.
Your main contention that there was already a partition.
It is admitted fact.
On 31/1/1991.
Yes, please. Before that, my lord, what happened, my lords? During the 1986, Narsappa died. He had a vision pattern. He has suggested how they have to, how the property to be partitioned. And after his death, in 1987, accordingly, they have orally partitioned the property. Then, my lords, the the suit schedule A property came to the share of the different number 5 and 6. The appellant here is different number 5. There were some other properties situated, residential property and site properties in Andhra Pradesh. They were given to other sons. And all that were admitted facts. Then to make kata, when they had to bifurcate kata between different number 5 and 6, in the presence of the other 2 sons, with their knowledge, they having been signatory to the document, a partition deed was entered into in the year 1991, by which different number 5 and 6 have divided suit A schedule property. All these things were well within the knowledge of all the parties, including the plaintiffs.
Whether plaintiff was party to the said document of
The
partition?
plaintiff father was party to the said.
Plaintiff father.
Plaintiff father was a signatory. He is not a party. He was a witness to the said document.
Said document.
It is a registered partition deed, and there are 4 sons. It was a partition between 2 sons. The other 2 sons have signed that document as witness. And in the cross examination, the PW1, who is the contesting, who is the son,
He is the son.
son has specifically admits that he was aware of this partition from the date when it was Milord's executed.
That is from 1991 itself.
1991 itself, he was aware of it. He specifically admits. Then the father died in the year 2003. And in the year 2011, my lords,
Suit was filed.
Suit was filed. All these things were taken or on the merit, my lords, when there was already a partition which was well within their knowledge, my lords, and it was acted upon. Immediately mutation had taken place, and this they are trying to in a way say that this partition between number 5 and 6 has happened without making us party or others party, hence it is not binding, is what the contention that they have now taken. Now, our contention regarding limitation is not at all considered, because, my lords, from the date of their, because he contends that as on the date of the partition, I was major, and
is there any averment in the document of registered document that the plaintiff's father had relinquished his right?
My humble submission is that it is not there. But what had happened, my lords?
What would be the mode for devolving upon the property in favor of D5 and D6
what had
when the
happened?
property
Yes, my
belongs
lords,
to the family? Is whether the document is a document of releasing of their right merely because they have signed the document?
My lords, what had happened is the series of incidents that have taken place, my lord. The other properties for which a power of attorney is executed, and based on that, the second respondent has sold those properties.
The family share is property.
Ade, suit B schedule property ante ಹಾಕೊಂಡಿದ್ದಾರೆ. All that B schedule property ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ a power of attorney was executed in favor of the second defendant. Defendant number 2 and respondent number 2 herein.
Who have executed the power of attorney?
All of them.
Whether the property belongs to the family?
Yes. All these are admitted facts. But
the plaintiff father again kotri.
My humble submission is.
Is there any property is given to the plaintiff father?
My lord, so with my
any property his father had sold, the property belongs to the family?
what had happened, my lords, on that clandestinely the plaintiff is also silent. He though claims initially regarding the suit B scheduled property, then he is silent. He says, I don't choose to proceed with it, I don't know and all. What had happened, my lords? We have elicited that the second defendant has colluded and got this.
Filed the suit with the
Got
plaintiffs
filed
ಅಂತ.
we have confronted the documents. ಇಲ್ಲಿ ಅವ್ರು ತಂದ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ನ ಈ RTC ಗಳನ್ನೆಲ್ಲ which are produced by the plaintiff are applied by the second defendant. Then, my lords, limitation is 12 years from the date of their knowledge. Not only this defendant, even the one of the sister who was the first defendant, there was even a writ petition filed seeking permission to examine her as a plaintiff's evidence. She had led evidence as DW3. Categorically, she says that she was very much aware of all these transactions and partitions. However, I am entitled to a share now. They have said.
Schedule B property all are sold.
Schedule B property ಬಗ್ಗೆ it has been given. No order is passed. Even in this, the suit is not decreed in favor in respect of Schedule B property.
Only A schedule property
ಮಾತ್ರನೇ ಡಿಕ್ರೀ ಮಾಡಿದ್ದಾರೆ. ಅದು ಅನ್ಸರ್ಟನಿಟಿ ಇದೆ, ಕ್ಲಾರಿಟಿ ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾ ಏನು ಮಾಡಲ್ಲ ಅಂತ. That is how the fighting is.
ಆಯ್ತು, ಗೊತ್ತಾಯ್ತು. But whether they have challenged that order?
Nobody. We have
B schedule property ಸಂಬಂಧ
ಇಲ್ಲ. We have not challenged.
ಅಲ್ಲ, ನೀವಲ್ಲ,
ಅವರು ಮಾಡಿಲ್ಲ. ಅಲ್ಲ, ಅವರು ಅದ್ಲಿ ಇನ್ ದ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಟ್ಸ್ ಅವ್ರು ಗಿವ್ ಅಪ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ, ನಾನು ಕೇಳಿಲ್ಲ ಅದನ್ನ, ಐ ಡೋಂಟ್ ವಾಂಟ್ ಎನಿ ಶೇರ್ ಇನ್ ದಟ್ ಅಂತ ಸ್ಪೆಸಿಫಿಕಲಿ ಪ್ಲೇಂಟಿಫ್ ಹೇಳ್ತಾರೆ. ಹಾಗಾಗಿ ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಎ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ಇಸ್ 8 acres of land which was partitioned in 1991 between different number 5 and 6. Lords, the suit schedule
same is not binding on the plaintiffs. The father of the plaintiff has not given up his share in the in terms of the document.
My humble submission
maybe a consenting witness to the document.
With great respect, when the plaintiff who was a major as on the date of partition, 91 ನಲ್ಲಿ, and he admits that from that day he was aware of it. Milords, with great respect, Milord, we have even filed an application to frame an additional issue regarding my limitation. Milord,
ಕಾಲ್ ಫಾರ್ ನೋಟ್. ಯಾರು ಇದಾರಲ್ಲ ಅದರ್ ಸೈಡ್?
ಇದಾರೆ, ಬಂದಿದ್ದಾರೆ.
ಕುಲಕರ್ಣಿ ಎಲ್ರಿ ಅವರು? ಬಂದಿಲ್ವಾ? ಕೇವೇಟ್ ಹಾಕಿದಾರಲ್ಲ?
ಕೇವೇಟ್ ಮಾಡಿದ್ದೇವೆ ಲಾಸ್ಟ್ ಟೈಮ್. ಅಲ್ಲಿ FDP ಹಾಕಿ
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ, ಬರ್ತಾರೆ. ವಾಟ್ ಹಿ ವಿಲ್ ಸೇ? 63 ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ. Declared owners and permanent injunction granted confirmed.
The first appellate court judgment में your rush में
ಏನಾಯ್ತು? ಅದು ಆಗೋಗಿದೆಲ್ಲ ಆಯ್ತು, ಗೊತ್ತಿಲ್ಲ. ಈಗೇನು ಅಪಾಲಜಿ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡೋದು ನಾನು? You have to assist the court when the matter is listed before the court.
Dispute, Milord, is relating to identity. The plaintiffs gives
identity of the property.
The plaintiffs gives this description of boundaries, including the land of the defendant on the western side and on the southern side. That is dispute. Plaintiff's extent of 9 acre 20 guntas, I don't dispute, he is in possession of the same. But by giving wrong boundaries in the suit, he is asking my land. What is the dispute between the court?
How he got the property?
He got, my lord, under 2 sale deeds. My lord, his sale deed is
2 sale deeds. Whether the plain schedule is in terms of the sale deeds?
It is not there, my lord. I have given a comparison at page 17, my lord, of the appeal memo. The description in the sale deed and the description, my lord, given in the plaint. My lord, description in the sale deed is exhibit P1 at the right hand side, my lord. The boundaries in sale deed dated 16/1970, exhibit P1.
7 acres of 6 guntas.
Lands of Marigauda and Jendegauda and others. Now, my lord, east, the plain boundaries, lands of children of Puttamma, wife of late Karigauda, M. Joregauda, and Tambegauda, bearing serial number 84 and 85. West, my lord, in his sale deed is lands of Shiwappa and Huchegauda. In the plaint, my lord, west, Neelavadi Revenue Village. Then north, my lord, government road, north, my lord, west Kushala Nagara road, serial number 87/1, my lord, it may be similar, same land. South again differs. South, lands of Kempegowda, that is plaintiff number 1. south, my lord, in the plaint, land of Govindappa, that is myself. This way, by giving a long boundary, my lord, he has covered my land and is asking. That was elicited, my lord, in fact, in the cross-examination of
According to you, your land is not shown in the original sale deed of exhibit P1. That is adjacent to the land of the plaintiff anta.
Now, my lord, the first step.
ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ತೋರಿಸಿಲ್ಲ, ಸೂಟ್ ಹಾಕುವಾಗ ಮಾತ್ರ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಸೋತ್ಗಿದೆ ಅಂತ ತೋರಿಸಿದಾರೆ ಅಂತ.
ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಏರಿಯಾ ನಮ್ದು ಅಲ್ಲಿ ಒಂದು ನಾವು ಪರ್ಚೇಸ್ ಮಾಡ್ತೀವಿ ಸರ್ 63 ಅಲ್ಲಿ ಆಸ್ ಪರ್ ಎಕ್ಸಿಕ್ಯೂಟ್ P10
ಕಮಿಷನರ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಗೆ
ಮಾಡಿಲ್ಲ ಸರ್ವೆ ರೆವಿನ್ಯೂ ಸೈಡ್ ಆದಾಗ ನನ್ ಫೇವರ್ ಬಂದ್ಬಿಟ್ಟಿದೆ, ಅಲ್ಲೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಸಬ್ ಡಿವಿಷನ್ಸ್ ಎಲ್ಲ ತೋರಿಸ್ತಾರೆ. ನೋ ಮಿಲಾಡ್ ಹಿಯರ್ appellate court judgment, my lord, yours may kindly turn total non-application, my lord, page 38, my lord, is the points framed. Page 38, down below at para 13, whether trial court has erred in passing the judgment, whether the trial court has committed an error in decreeing the suit, whether a judgment decree do not call for interference. Even if we take it as my lord correct, the judgment, my lord, your lordship says no oral evidence, PW1 to PW3 is there, DW1 to DW2, not even one sentence, my lord, reference. One refer madidre adu saku. I have produced exhibit D1 to D60. Not even one document is referred, my lord, by the first appellate court. First appellate court refers only to the two sale deeds and decrees the suit without application of mind.
Issue notice, call for records.
My lord, I had the benefit of status quo order, my lord, in the first appeal all throughout.
First appellate court alla?
Yes, I have stated in the affidavit.
Helidira?
Helidini.
Heard on A number 1 of 25 and counsel would submit that the appellant has enjoyed the interim relief before the appellate court to maintain the status quo, and the same may be ordered. And in view of the submission that when the appellant had enjoyed the relief of status quo before the appellate court in the disposal of the appeal memo, and also counsel brought to notice of this court that no discussion was made with regard to the documents which have been produced by the appellant and also the evidence in the judgment of the appellate court, and hence the A1 of 25 is allowed, directing parties to maintain status quo till the next date of hearing.
Great.
The date could be returnable by records ಬರ್ಬೇಕಲ್ಲ ಅದು?
Please.
11/8. ಗೌರವ ಶ್ರೀ. Sale deed null and void.
Lords, I appear for the appellants. Lords, this is a matter wherein both the lower courts have held concurrent judgments, my lord. But my lord, in order to take into the date of events, my lords, Subbappa was the Karta of the family. He died, my lord. There's no specific date when he died. Later on, Putmadappa executed. Putmadappa is his fourth son. Lord, for the ease of reference, I have annexed IA1, the genealogical tree, my lords, for the ease of reference, wherein he has he has executed a will and benefiting his two daughters, my lord. My lords, the whole contention of this petition here is that the scheduled property in the will is ancestral property, my lords. And when the property is not yet partitioned, Putmadappa has no right to execute. He has exclusively no right to execute the will, my lords.
According to you, property belongs to whom?
It is not yet partitioned, my lord. It's
Not yet partitioned. Originally belongs to whom?
It belongs to Putmadappa initially.
Putmadappa only.
Presently, the records are in the name of Shambhulinga Swami, who is the petitioner here in my lords.
Counsel. Originally property belongs to whom?
Subbappa, my lord.
Subbappa.
Subbappa.
How Putmadappa got the right
That is the question, my lord.
over the property?
Yes, my lord.
Was there any relationship between the Subbappa and
He is his fourth son.
Putmadappa?
Fourth son. Putmadappa
Fourth
is the
son.
fourth son. Yes. There was no partition held, my lord. And the plaintiff in the lower
Among the sons of the Subbappa?
Subbappa, yes, my lord. And the lower courts has not considered the point that the partition was not at all held. Lords, initially the plaintiffs went on filing OS 92/13. In the
It
year,
is not your case, counsel. You have contended before the trial court whether the defendant number 1 to 3 prove that in order to an oral partition, plaintiffs have been given 10 guntas, 29 guntas and 4 ankanas house anta ide. Nim defense adu.
my lords, they are relying upon exhibit P11 in RA.
Also, defendant number 1 to 3 prove that social property only belong to their family members and not the plaintiffs anta.
Yes, my lord. My lord,
ನೀವ್ ಯಾರ್ ಮಕ್ಳು? ನಿಮಗೆ ಸುಬ್ಬಪ್ಪ ಏನಾಗಬೇಕು?
Subappa is, the genealogical tree is in page 107, my lord.
107.
Yes. My lords, here Subappa has 4 children, Gauramma, Sushilama, Gurusiddhamma and Subbanna.
Only one son.
My lord, Gauramma was married to Guru Mallappa.
One son, 3 daughters. ಹೌದಾ?
One son, 3 daughters. Yes, my lord. The son was not married.
ನಿಮ್ಮ ಇದು genealogical tree?
My lords,
Genealogical tree ಎಲ್ಲ ಹಾಕಿದಿರಿ?
page 107 of IA, my lord.
107 IA ಜೊತೆ ಹಾಕಿದಿರಿ.
Yes, my lord.
One 105. 106.
Yes, my lord.
ಸುಬ್ಬಪ್ಪ.
Yes. Subbanna is not married and
ಅವನಿಗೆ
he's already deceased, my lord. ಇಲ್ಲಿ
ಅಪ್ಪನಿಗೆ ಸುಮಾರು ಜನ ಗಂಡ್ಮಕ್ಳು ಇದಾರಲ್ರಿ, 4 ಜನ ಅಲ್ಲ 5 ಜನ. ನಂಜುಂಡ ದೇವರು ಅಂತಿದ್ದಾನೆ, ಮಲ್ಲಿಕಾರ್ಜುನ.
ಸುಬ್ಬಪ್ಪನಿಗೆ 5 ಜನ ಮಕ್ಕಳಿರೋದು.
ಹೌದು, ಪಾತಮ್ಮ, ಮಾದೇವಪ್ಪ, ಪುಟ್ಟಮಾದಪ್ಪ, 4 ಜನ ಗಂಡ್ಮಕ್ಳು, ಒಬ್ಳು ಮಗಳು.
Yes, my lord. Here the point in question is Puttmadappa, my lord, the last son.
ಪುಟ್ಟಮಾದಪ್ಪ.
Puttmadappa has 4 children. Wherein Gauramma was married to Guru Mallappa, and after the death of Gauramma, this Guru Mallappa was married to the 3rd daughter in the same family. And the children of the 3rd daughter is respondent 1 and 2 here in my lord. And the children of
Property was standing originally in the name of late ಸುಬ್ಬಪ್ಪನ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ? ಹಾಕಿದೀರಾ?
my lord, cross ಅಲ್ಲಿ ಇದೆ my lord. ಕ್ರಾಸ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿದೆ. ಅದು ಸುಬ್ಬಪ್ಪನ
ಒಪ್ಕೊಂಡಿದಾರ?
ಪ್ಲೇಂಟಿಫ್ ಗಳೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, ಸ್ಟೇಟಿಂಗ್ ಇದು ಆನ್ಸಿಸ್ಟ್ರಲ್ ಪ್ರಾಪರ್ಟಿ ಸುಬ್ಬಪ್ಪನಿಂದ ಪುಟ್ಟಮಾದಪ್ಪಂಗ್ ಬಂದಿದೆ ಅಂತ.
ಆಯ್ತು, ಈ ಮಾದೇವಪ್ಪ, ಮಲ್ಲಿಕಾರ್ಜುನ, ನಂಜುಂಡ ದೇವರು ಅವ್ರಿಗೆ ಯಾವ್ದು ಪ್ರಾಪರ್ಟೀಸ್ ಬಂದೇ ಇಲ್ವಾ?
my lord, ಅದು ಮಲ್ಲಿಕಾರ್ಜುನ ದೇವರು ಮತ್ತೆ ಪುಟ್ಟಮಾದಪ್ಪನ ಹೆಸರಲ್ಲಿ ಜಾಯಿಂಟ್ ಅಕೌಂಟ್ ಮಾಡಿದ್ರು.
ಯಾವ್ದನ್ನ?
ಇವ್ರು ವಿಲ್ ಸಬ್ಜೆಕ್ಟ್ ಪ್ರಾಪರ್ಟಿ
ಈ ಪ್ರಾಪರ್ಟಿನ ಅಂದ್ರೆ ಜಾಯಿಂಟ್ ನೇಮ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು ಅಂದ್ರೆ was there any partition among them?
No partition, my lord.
No partition.
In the name of partition, in exhibit P11 in RA,
partition.
In the name of partition, the court has held it is a partition deed. But whereas the nature of the document is exchange deed, my lord.
Exchange deed between?
Exchange deed between Puttmadappa and Mallikarjuna Devaru and his son.
Agar allige already there was a partition and both of them have exchanged the property. That's all. Now you are contending that there was no partition among the children of late Subbappa.
ಅಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಅನ್ನೋದು ಇವ್ರ ಮಧ್ಯದಲ್ಲಿ ಬಂದಿರಲ್ಲ my lord.
ಯಾರ ಮಧ್ಯದಲ್ಲಿ?
ಮಲ್ಲಿಕಾರ್ಜುನ ದೇವರು ಮತ್ತೆ ಪುಟ್ಟಮಾದಪ್ಪ ಅವರಿಬ್ರು ಮಧ್ಯದಲ್ಲಿ.
But now how they got the property?
Well, it is mentioned as sale in the RTC. In the RTC, it is mentioned as sale.
Sale? That
is mentioned.
RTC ಅಲ್ಲಿ?
RTC ಅಲ್ಲಿ. But from whom it is taken ಅಂತ ಬರ್ದಿಲ್ಲ my lord.
From whom he had purchased ಅಂತ ಇಲ್ಲ?
ಇಲ್ಲ.
ಸೇಲ್ ಡೀಡ್ ಹಾಕಿಲ್ಲ ಅವರು?
ಸೇಲ್ ಡೀಡ್ ಹಾಕಿಲ್ಲ.
ಬಟ್ ನೀವು ಒಟ್ಟು ಕುಟುಂಬದ ಪ್ರಾಪರ್ಟಿಗೆ ಸೇರಿದ್ದು ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಮೇನ್ಲಿ?
my lord,
ಸುಬ್ಬಪ್ಪನಿಗೆ ಸೇರಿದ ಆಸ್ತಿ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
my lords, the only point we have is they themselves have admitted in the cross, my lords. If you look at page number 33, my lords.
33 of?
33, running page of 33.
Appellate court?
ಇಲ್ಲ my lord, ಇಲ್ಲಿರ appeal ಬಂದ. RSA appeal.
RSA ನಲ್ಲ appeal ನಲ್ಲ 33 appellate court judgment on the?
Yes, my lord.
Ink page 33 na?
Ink page 33.
ಆಯ್ತು. On perusal of the cross examination PW ತನ್ನ ಅಜ್ಜ ಪುಟ್ಟಮಾದಪ್ಪನ ತಂದೆ ಹೆಸರು ಸುಬ್ಬಪ್ಪ. ಸುಬ್ಬಪ್ಪನ ಮಕ್ಕಳು ಮಲ್ಲಿಕಾರ್ಜುನಪ್ಪ, ನಂಡಪ್ಪ, ಮಾದೇವಪ್ಪ ಮತ್ತು ಇತರ ಪುಟ್ಟಮಾದಪ್ಪ. ದಾವ ಹಾಕಿದ ಸರ್ವೆ ನಂಬರ್ಗಳು 4 ಇರುತ್ತವೆ. ಸೋನ್ಸೋ ಈ 4 ಜಮೀನುಗಳು ಮೂಲತಃ ಸುಬ್ಬಪ್ಪನಿಗೆ ಸೇರಿದ ಜಮೀನುಗಳು ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ. ಏನ್ ರಿಂಗ್ ಇದೆ? ಸುಬ್ಬಪ್ಪನಿಗೆ ಸೇರಿದ ಜಮೀನುಗಳು
they have admitted themselves, my lord. The partition
ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ ಅಂತ.
Yes.
ನಾಡು ಹೆಂಚಿನ ಮನೆ ಮತ್ತು ನಿವೇಶನ ಕೂಡ ಸುಬ್ಬಪ್ಪನ ಮೂಲಕ ಪುಟ್ಟಪ್ಪ ಮಾದನಿಗೆ ಬಂದಿದ್ದವು ಎನ್ನುವುದನ್ನು ಒಪ್ಪಿದ್ದಾರೆ.
Yes, my lord.
ಹಾ
This is our case, my lord.
ಹಾ
When they themselves have admitted, civil judge and JMFC ನಲ್ಲಿ they have not considered the point ಯಾರಿಂದ ಬಂತು whether Puttamadappa had a right to execute the will anta. That point is not at all addressed.
This is the extraction clearly shows that these properties are allotted in favor of the Puttamadappa.
ಅವರಿಂದ ಬಂದಿದೆ ಬಟ್ ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲ.
ಈ 4 ಜಮೀನುಗಳು ಮೂಲತಃ ಸುಬ್ಬಪ್ಪನಿಗೆ ಸೇರಿದ ಜಮೀನುಗಳು. ಅಲ್ಲೇನೋ ಏನಕ್ಕೆ ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಬರೆದವ್ರು ಗೊತ್ತಿಲ್ಲ. ಆಮೇಲೆ ನಾಡು ಹೆಂಚಿನ ಮನೆ ಮತ್ತು ನಿವೇಶನ ಕೂಡ ಸುಬ್ಬಪ್ಪನ ಮೂಲಕ ಪುಟ್ಟಮಾದಪ್ಪನಿಗೆ ಬಂದಿದ್ದವು ಎನ್ನುವುದನ್ನು ಒಪ್ಪಿದ್ದಾರೆ.
ಅದು
ಸುಬ್ಬಪ್ಪನ ಮೂಲಕ ಪುಟ್ಟಮಾದಪ್ಪನಿಗೆ ಬಂತು ಅಂತ.
ಅವ್ರ ಪುಟ್ಟಮಾದಪ್ಪನಿಗೆ ಬಂತು ಬಟ್ ಮಿಕ್ದವ್ರಿಗೆ ಹೋಗಿಲ್ಲ, ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲ.
ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ಆನ್ಸರ್? ಎಲ್ಲಿ ಸೆಟ್ ಮಾಡಿಸಿರೋದು? It is admitted fact the first defendant is the karta of the family. Yaar first defendant?
Shambhulinga Swami.
And first defendant was the cultivating the land as agricultural. He denied that first defendant availed a loan for benefit of family. He admitted that after the marriage of his brother, first defendant got married. He denied that on 17/1999 Puttamadappa not executed the will. The appellant counsel argued that suit scheduled property is ancestral property. Do not have any right to execute the will. He admitted that a fifth defendant. So ಮುದುಮಪ್ಪನ ಮಕ್ಕಳಾದ ಗೌರಮ್ಮ, ಸುಶೀಲಮ್ಮ, ಗುರುಸಿದ್ದಮ್ಮ ಹಾಗೂ ಸುಬ್ಬಮ್ಮನ ಮಕ್ಕಳು ಸದರಿ ಪುಟ್ಟಮ್ಮ ದಾಖಲ ಸ್ವತ್ತುಗಳನ್ನು ಅವರ ಮಕ್ಕಳಾದ ಸುಶೀಲಮ್ಮ, ಗುರುಸಿದ್ದಮ್ಮರವರಿಗೆ ಮರಣಾಂತರ ಸೇರಬೇಕು ವಿಲ್ ನೋಂದಣಿ ಮಾಡಿಸಿದ್ದಾರೆ.
ಇಲ್ಲಿ ಬರ್ಡನ್ ಆಫ್ ಪ್ರೂಫ್ ಇರೋದು ಪ್ಲೇಂಟಿಫ್ಗೆ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ. ಅವರನ್ನ ಎಲ್ಲೂ ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ. ಬಟ್ ಅಲ್ಲಿ ಕ್ವಶನ್ ರೈಸ್ ಮಾಡಿದವರು ಲೋಯರ್ ಕೋರ್ಟ್ಸ್ ಅಲ್ಲಿ ವಿಲ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಬಗ್ಗೆ ಅವ್ರು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ವಿಲ್ ನ ಕೊಟ್ಟು ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ 1/2 ಶೇರ್ ಕೇಳಿದ್ದಾರೆ. If I may take you to page 71. Let's page 71.
ಒಂದೇ ನಿಮಿಷ.
OS judgment, my lord.
That is the observation in paragraph number 26. There is no document to show that Puttamadappa inherited his properties from his forefather. It is the case of the plaintiff, the property are self-acquired property, there is no sale deeds or any allotment letters that have been produced. ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದ್ದು ಪುಟ್ಟಮಾದಪ್ಪ ಸುಬ್ಬಪ್ಪನಿಗೆ ಸೇರಿತ್ತು ಆಸ್ತಿ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಎಲ್ಲಿದೆ ದಾಖಲೆ ಅಂತ ಕೇಳಿದೆ.
ಮೆಲಾಜ್ ಅವ್ರ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಮೆಲಾಜ್. ವಿ ಡೋಂಟ್ ಹ್ಯಾವ್ ಎನಿ ಸ್ಪೆಸಿಫಿಕ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಿಯರ್.
ಮತ್ತೆ ಏನ್ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ? ಅವ್ರ ಅಪ್ಪನಿಗೆ ಬಂತು ಅಂತ ಅಂದಿದ್ದಾರೆ ಅಷ್ಟೇನೆ.
ಅವ್ರ ಅಪ್ಪನಿಗೆ ಅವ್ರ ತಾತನಿಂದ ಬಂತು.
ಐಟಮ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಮನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಲ್ಲಿಗೆ ಅಡ್ಮಿಷನ್ ಈಸ್ ವೆರಿ ಕ್ಲಿಯರ್ ದಟ್ ದೇರ್ ವಾಸ್ ಆಲ್ರೆಡಿ ಎ ಪಾರ್ಟಿಷನ್ ಆಲ್ಸೋ.
Malaj, if you may look at page 71 of OS1.
I'm not convinced. Any of records barely note.
My lords, I also seek for,
Appellant counsel, directed the registry to get the records of trial court and appellate court.
my lords,
List this matter on 11/8. ಏನ್ ಹೇಳಿ?
ಅವರು ಅಲ್ಲಿ ಲೋಕಲ್ ವಿಲೇಜ್ ಅಕೌಂಟೆಂಟ್ ಆಫೀಸ್ ಎಲ್ಲ ಹೋಗಿ ಖಾತಾ ಚೇಂಜ್ ಮಾಡಿ ಟ್ರಾನ್ಸ್ಫರ್
ಏನಾಗಲ್ಲ, ಅದೇನ್ ಚೇಂಜ್ ಆಗಲ್ಲ. Subject to result of this appeal.
ಕೈಂಡ್ಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಲ್ಸೋ my lord.
This notice order ಮಾಡಿಲ್ಲ. I am not convinced. I will go through the records and then I will issue notice. If there was a case for considering there is a case for consideration of second appeal. Because you have not placed any document to show that originally property belongs to the Subappa. All documents are stands in the name of Putmadappa. Putmadappa executed the will. Next, Sangamesh RB, Krutika Raghavan.
My lords, I'm appearing for respondent number 1. I filed my wakalat yesterday, my lords. I've also received a copy of the appeal.
ವಕಾಲತ್ ಬಂದಿದೆ, ತೋರಿಸಿದಾರಲ್ಲ. ವಕಾಲತ್ not filed. ಆಯ್ತು. The wakalat is filed and the same is accepted.
In fact, a caveat
on
was
behalf of
entered, my
Arvind.
lords. A caveat was entered. I served on the caveator. Last
Bit of
date of hearing,
counsel.
the caveator comes and he says he will engage other counsel. Then again, lords, I gave a concession. I said, fine. I gave one more set of copies. Now, lords, in spite of your lordships granting 5 days time to file the wakalat, yesterday they have filed the wakalat.
I'm
They are
not
again
seeking time, my lords. I'm just clarifying that it
Now
Oh,
was
she is
filed
ready,
yesterday. I'm ready.
All right, so I'm ready. This is a suit for specific performance where both the courts have held against me. Lords, the sale agreement is dated 27/7/1987. Lords, before that, I just want to submit copies of documents, lords, which I had in the last date of hearing stated, lords. I'll make one copy of the exhibits for your lordships. Easy reference. I'll just, lords, mention the dates, then I will take your lordships to the documents. 27/7/1987, lords, is the agreement of sale.
1987.
Yes, lords. Total consideration is 2,52,000, out of which 1,25,000 is paid as advance. 1,67,000 is the balance. The understanding is that, lords, this 1,60,000 is outstanding loan in Canara Bank, which is availed by the owner. That is the respondent number 1. And the said balance with the Canara Bank is required to be cleared by me. So, lords, under the agreement, what was required to be paid to the first respondent owner is completely paid. And the obligation was upon the respondent purchaser, that is defendant purchaser, to pay the entire loan to the Canara Bank. Then, my lords, after the loan is cleared, then I will take the sale deed. Lords, this was the understanding. Then, my lords, in the due course, of course, there was no time fixed in the agreement, my lords. After the clearance of the loan, I was required to take the sale deed. Lords, in the due
Actually,
course,
who has to clear the loan? You
I
or-
have to clear,
you
purchaser
have
has to clear, the purchaser has to clear the loan.
That is balance amount.
The balance amount 1,60,000. So there was no requirement to pay any money to the owner, my lords.
Owner.
Yes.
Whatever the amount payable is already paid by way of 1,25,000.
1,25,000, no more amount is required to be paid to the owner.
Yes.
But gradually I cleared the loan in the year 2005. But there was a time gap because, my lords, in the meantime, Canara Bank filed a suit, and in the suit, my lords, Canara Bank files a suit. In the suit, the Canara Bank makes the owner, that is the defendant number 1, also as a party. They make me also as a party. In the meantime, after the execution of the agreement, the owner, my lords, defendant number 1, gives a special power of attorney to me,
To contest the
authorizing me to repay the entire loan to the Canara Bank. On the basis of that special power of attorney, I repay the loan. Then one more most important document executed is the registered GPA, authorizing me to deal with the property in its entirety in any manner I want, my lords, in the year 1994.
94.
Yes, my lords. The registered GPA, my lords, is executed in my favor 25/8/1994. Lords, that is produced as Exhibit P9. Now, lords, all these documents are produced. I clear the loan, then I issue a notice on 27/2/2007. Then they don't give a reply. 7/11/2007, I issued legal notice. Then I proceed to file a suit. Lords, 27/2/2007, I issue the first notice. In the meantime, 17/3/2007, lords, the first defendant sells the property, collusive sale deed executed in favor of defendant number 3.
Sale on?
Sale on 17/3/2007.
Your legal notice on what date?
Legal notice on 7/11/2007. Before that, one more notice.
7/11.
7/11/2007. Earlier to that, one more
It is
notice.
after the sale.
After the sale, I am not aware of the sale. But much prior to that, notes, I issue one more notice on 27/2/2007, calling upon them to come and execute the sale deed. I have cleared
27/2/2007.
February 2007. After receipt of that notice, they keep quiet. Then they execute a sale deed.
But sale deed in the year 2007 in the month of March. But you have given notice in the month of February itself.
February I give, very next month, they issue the sale deed. Notes, then I pursue them, they don't talk, they don't. Notes, in fact, your lordships may kindly peruse the first defendant is a very powerful person. And I go to their ashram, I wait there, they make me wait for days together in Coimbatore, lords. And they don't give me an appointment to meet the person. And lords, I'm made to run around for almost 6 months. I had to talk to those personal assistants. They were, and lords, absolutely all the efforts to meet him, lords, doesn't materialize. Then finally I issue a legal note. And of course, I had not expected that I would have to face these things, lords, looking at the personality the first respondent is holding in the society as on today. Then, lords, without any option, on 27/11/2007, I issue the notice, then I file a suit. Lords, the trial court says that the GPA, the trial court does not say anything, lords. There was no occasion for the defendant number 1 to execute the registered GPA authorizing all the powers to the purchaser. With this reasoning, the trial court says the GPA cannot be accepted because it is executed in the year 1994. 94. Because the agreement is of the year 87. Then, lords, the GPA comes into existence after the bank files the suit against the suit. After the bank files the suit, then the GPA comes into existence. And in the suit filed by the bank,
what is the discussion in respect of GPA by the trial court?
Lords, the GPA, the trial court says, I cannot look into because it is executed at a subsequent point of time. There was no occasion to execute the GPA. This is the finding. What's most important finding I want to stress upon is in the suit filed by the bank for recovery, I am made as defendant number 3. And in that suit, my lords, the defendant number 1 owner.
Suit was filed in the year by the bank?
94, my lords.
94.
Yes. All those exhibits I'll take your lordships. In the compilation I have sent. And in the suit, my lords, a specific written statement is filed by the defendant number 1 saying that I have sold the property to defendant number 3 and I have authorized him to clear.
There is an admission.
There is clear admission. I'll take one paragraph, lords, for your lordship's perusal. Clear admission. I have sold in favor of defendant number 3. Defendant number 3 is entitled to clear the loan and he is the owner of our property. Whatever you are entitled, you please recover it from him.
Yes.
On the other hand, I file written statement. In fact, my written statement is prior to his written statement. In my written statement, I say they have already sold the property to me. They have executed an agreement and given a GPA also. As per the GPA, I am entitled to pay the entire dues. Please give me some installments. I'll repay. This is my written statement. After mine, the first defendant files the written statement. No defendant number 3 is entitled to pay. Lords, after all these admissions, then lords, the suit is decreed. After the suit is decreed, I pay the entire money
to the
lords,
bank.
To the bank. I have produced, my lords, receipts for having paid to the bank money. About 8 or 9 receipts I have produced as exhibit P2 to P13. All these receipts, my lords, original receipts are in my custody. I produce the receipts. Lords, the trial court says merely because you're holding the receipt, that doesn't give me a presumption that the agreement is valid. Lords, the trial court and the first appellate court say that the balance amount which is required to be the bank, that is 1,67,000, is handwritten, that is pen written in the agreement. Therefore, I don't believe. Now, lords, with this background, this is the lords skeletal facts which I have stated now. With this background, if lordships permits, I'll take your lordships to some of the documents which I have lords now filed it along with a memo, lords, the exhibits.
What do you say, madam, regarding your written statement in the suit filed by the bank?
My lords, that has also been considered and answered by both the courts. If your lordships permit me, I will take a.
Is a clear admission on the part of you
that
you
my
have
lord, there's a
executed
categoric finding that there is no admission and there is no clarity over what I am saying. In fact, that submission of mine has not been accepted by the trial court in the suit filed by Canara Bank. Can I just take your lordships through that portion of the judgment of the first appellate court?
What do you say with regard to your pleading before the suit?
My lord,
filed by the bank?
my lord, that there was no admission, my lord.
No admission.
No, my lord, and in fact, that statement that we have made, the court has observed, only says it is confined to some portion of the property where there's a poultry farm where we permitted them to remain. There's no admission of a sale.
Is it the government in the written statement?
Please,
That only portion of the property was
that is the observations of the court, my lords.
an observation by the court, but is it your defense in the written statement?
My lords, I don't have the benefit of the records of that connected matter, my lords. That's an earlier.
How can a court can give such finding before the court when there is a specific admission in the
I
written
just have
statement that you have already sold the
two
property and
submissions
also
on that, my lords.
executed a GPA?
Please, I just have two submissions on that, my lords.
Is it not estoppel?
My lords, that admission, alleged admission aside, there are independent findings of
Your
the
lordships,
court.
I'll only read 3 lines, my lords.
Records bandilala?
Records bandila.
Registry is directed to get the records of the trial court and appellate court. An interim relief
I
ಕೇಳಿದಿರಾ
have
ನೀವು?
sought for an interim order of status quo, my lords. Let
My
that
lords,
be known.
I have one.
For this reason, my lords. Now, defendant number 3, in the meantime, after filing of the issuance of notice, they sell it in favor of defendant number 2, my lords. Who is none other than the disciple of defendant number 1.
Even also
Then-
sold the property in favor of D2.
Then D2 sells in favor of defendant number 3. D3 is none other than the daughter of defendant number 1. But it is all collusive sale deeds they are executing in favor of each other, my lords. So therefore, my lords, I only seek your lordship's indulgence to grant me an interim order of status quo or not to alienate, my lords.
PIಯ ಕಿಟಿಯ ಕೇಳಿದಿರಿ?
ಹೌದು.
So,
My lords, I'm sorry to interrupt, my lords. There's one judgment I'd like to place before your lordships in connection with the relief that they're seeking. Just give this. Would my lords have paragraph 16 of the judgment? May I read, my lords? This court has categorically held that the High Court acquires jurisdiction to deal with the second appeal on merits only when it frames a substantial question of law as required to be framed under section 100 CPC, and it cannot grant an interim order without framing substantial question of law. In this regard, a few decisions and relevant paragraphs are usefully quoted below. I will skip that, my lords, and I would take your lordships through paragraph number 17. As per section 100, a High Court can proceed to hear a second
then I will
appeal.
frame the substantive question of law.
My lords, then I will have to be heard on that question separately, my
I'm
lords.
hearing you also.
My lords, in the meanwhile, my lords may not grant any interim orders. Any short date may be fixed. My lords may fix the question. I will endeavor to assist your lordships by answering those questions. Then his prayer for interim order may be
One more
considered.
submission may I make, lords. Now the caveat is entered on behalf of defendant number 1.
Defendant number 1.
Defendant number 1. She is appearing on behalf of defendant number 1. The property is in the name of defendant number 3.
Now property
Now,
is in
presently it
defendant
is in the
number
name of
three.
defendant
Already
number.
sold.
No, my lords, defendant number 1 sells to defendant number 2
My lords, the
in
sale occurred
2007.
prior to the
Defendant
suit.
Now defendant number 2 again sells in favor of defendant number 3, who is the daughter of defendant number 1.
Oh, daughter of defendant number
Daughter
1.
of defendant number 1.
My lords, that
Defendant number 3, my lords, I will seek interim order only against defendant number 3. Your defendant number 1 is the one who has appeared now.
Now the property stands in
Stands in the name of defendant number 3. Let there be a direction against defendant number
my
3 not
lords,
to
I
alienate
just have
further.
one submission to make, my lords.
You have no locus to plead on behalf of the respondent number 3.
My lords, my difficulty is only this.
Property was sold by you in
Please.
favor of defendant number 2.
It was sold prior to the institution of the
Whatever
suit,
it
my
may be,
lords.
madam, whatever it may be. Now what is the right you are having now?
Please.
Now what is the right you are having?
My lords, then,
What is the locus you are having now to
Well-
oppose the interim order?
my lords, I'll have to indemnify all of those people if,
You have already lost the right over the property.
please.
Then what is the locus?
My only difficulty is this, my lords. If any order is passed,
What difficulty to you? Nothing is in
I
your
am
hands.
responsible to
Nothing-
indemnify all of
nothing-
these persons, my
nothing is
lords.
in your hands.
My lords may, I only have this request. My lords may direct notice to be served on all of those parties. My only concern is, my lords,
You cannot plead on behalf of the respondent number 2 and 3. You are having wakalat only for R1.
please.
You have wakalat on respondent number 2 and 3? No.
My
You have
lords,
only-
no,
you have
it's
filed
only on
wakalat
behalf
only-
of R1, but the only
Already-
difficulty of
already you
R1
have
here, my
sold the
lords.
property to the defendant number 2. Defendant number 2 in turn sold the property in favor of defendant number 3.
Please,
What right you are having?
they all derive their rights from me, my lords.
Then you have no locus at all. Yes.
My
now
lords, but
realize-
the suit, this relief for specific performance is against me, my lords, and the contract of specific performance, they have failed to
Lispendence.
establish.
Lispendence arises.
Not lispendence, my lords. In fact, 2 I had sold even before the suit was instituted. That is recorded by the trial court. He subsequently amends his pleading after I file my written statement saying he files the suit in December of 2007.
ಒರಿಜಿನಲ್ ಓನರ್ ಯಾರು ಇದ್ರಲ್ಲಿ?
Nane,
Contender number one was
I
the
am the
original
owner.
owner.
ಅಲ್ಲಲ್ಲ, ನಿಮ್ಗೆ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಟ್ಟವ್ರ ಯಾರು?
D1.
No, that is
D1
why,
only.
please.
Originally
D1 was the owner at that time.
Owner.
D1 was the owner at that time. He sells it to D2, who is none other than his own disciple. Then the disciple again sells it in favor of daughter of defendant number one.
He avails the loan and also got it cleared the loan through you and now.
Through me, my lords. I have produced all the original receipts before the court.
My lords, all these subsequent transfers have not been challenged by my learned friend. May I just point out his suit
Why
has,
they have to challenge, madam?
please.
When there was an agreement in favor of them.
And that agreement
And
I
if
have been
any-
defending, my lords. And that agreement is with me.
You may be defending.
Please.
You are not denied that agreement was not executed.
I have, my lords. I have in these
What is your
proceedings.
written statement in the suit?
My lords, I will show. I will show in these proceedings,
Show
my
me your
lords.
written statement. What you have filed written statement in the original suit? In the bank suit.
My lords, that was a suit by the bank. And there is a finding of the trial court.
You are also a party. You have
Please,
filed
he is
this-
also a party. He is also a
He is
party.
also a party. You are also a party.
And the
You
court
have
has held against
You
him.
have admitted that you have executed a sale agreement and GPA in favor of the.
My lords, my
appellant.
instructions are there is no such admission. If I may
Lords,
be
I have-
permitted to place
you
the
get
written
the record.
I
submission.
have amended the plaint, sought for cancellation of that sale deed in favor of D2, my lords.
Ah.
Subsequently, after it came to my notice, I have amended the plaint and sought for cancellation of sale deed in favor of D2.
D2.
Yes, my lord.
Executed by D1.
Yes, yes.
That is also a relief you have sought.
That I have sought for. I have carried out the amendment and I have sought for that.
But he has not challenged the judgment of Canara Bank suit, my lords. There
Why
it
should
says,
I have paid them entire money.
there is an observation, there's a categoric finding that he is not the buyer of the property. That observation now is operating against him. He is seeking to use that over here based on a written statement. But the finding by the trial court is that, illa naan ivrag marilla anta.
Your own admission is not an estoppel?
My lords, but that admission has been set aside in judgment.
What admission? How can the court can set aside your
My
admission?
lords, it was a triable issue. They tried it as an
But
issue.
whether court can look into the admission in coming to a conclusion that other reasons can.
My lords,
give
they have furnished reasons for recording.
Then
Permit
section
me to
what-
read
what-
3
what
lines in
section
the
58 of Evidence Act says admission.
My lords, but this was
Admission
after
need not be
trial.
proved. Admission need not be.
But he
proved.
has not challenged that judgment.
Why he has to challenge, madam? He only cleared the loan of the bank. You
My-
authorized him to clear
My lords,
clear
there
the
are two
loan.
courts with concurrent
No, no, no,
findings
stated.
saying that he has not cleared the loans.
So
Lords,
he
may I-
heard the appellant counsel and also the counsel appearing for the respondent number 1. And respondent number 1 is the original owner of the property, and counsel appearing for the appellant would submit that the respondent number 1 executed the sale agreement as well as the power of attorney. And also bank filed the suit against the respondent number 1 for the availing loan and did not clear the loan, and hence the appellant only made the payment of entire loan amount in favor of the bank. And in spite of there is an admission on the part of defendant number 1 that he had already executed the sale agreement as well as power of attorney, and also specific stand was taken that the appellant only taken the responsibility of clearing the loan of the bank and cannot claim the loan amount from defendant number 1. And again, the defendant number 1 sells the property in favor of defendant number 2, and defendant number 2 also in turn sold the property in favor of defendant number 3. And counsel would contend that as on today, the respondent number 1 is not having any right over the property once the property was sold in favor of D2, and D2 in turn sold the property in favor of D3 and cannot oppose the application filed on IA number 1 of 25 and no locus to object for the relief as sought in IA number 1 of 25. Having heard the appellant counsel and also appellant counsel placed on record memo along with documents, and also having considered the document of GPA and also the bank receipts and also
Written statement in
written
OS
statement filed in
464 of 87.
OS filed by the bank,
Yes, my lords. 464 of 87.
bank in OS
464 of 87.
4 of 87.
Exhibit P38.
My lords, I'm
That is-
sorry if I may just,
That is exhibit P38.
Sorry, P37. my lords,
P37, P37. To evidence the said submission, the counsel appearing for the respondent placed on the judgment of the apex court in 2025 within bracket for four Supreme Court cases 215 brought to notice of this court, paragraph number 16, wherein observation is made that in an RSA there cannot be an interim order unless the substantive question of law is framed. And having considered the said submission also, and in view of already the R1 had sold the property in favor of respondent number 2, and respondent number 2 in turn sold the property in favor of respondent number 3, and as on today, the respondent number 1 is not having any interest over the property. When such being the case, the judgment which has been relied upon by the counsel appearing to the appellant will not come to the aid of the respondent number 1, and only respondent number 1 is a formal party in view of already lost the interest in respect of the property, and hence this court has to issue notice against respondent number 2 and 3, even though there is a concurrent finding, and having placed on record along with memo, it is a case for reconsideration, and hence reconsideration and matter requires to be reconsidered. Admit the following substantive question of law arises for the consideration of this court, whether both the courts have committed an error in ignoring the WS exhibit P37 Allah?
P37.
Exhibit P37, wherein R1 categorically admitted regarding
Sale of property.
Sale of property and execution of power of attorney.
He said, my lords, I have already sold it to defendant number 3, who I am also a party there. Page 50, my lords, of the compilation. Second para. These defendants submit a heavy loss in the business, and in order to discharge the loans and other commitment, they have sold the entire
Exhibit P35, Henry?
P37. my lords.
P35 is the sale agreement, my lords. It's
Sale agreement.
35 is the sale agreement.
My lords, I'm sorry to be interrupting.
P9
Lord, P9 is the registered
is the
GPA, which
GPA, my
authorized
lords.
me to sell the
GPA, authorized to sell the property.
registered GPA.
And P11?
P11 is the
11 is
special
the
power of
special
attorney.
power of attorney authorizing me to repay the entire loan,
Loan amount.
mentioning the loan account.
My lords, I'm so sorry, but can I just point out one paragraph from the first appellate court's judgment, my lords? It's directly on the written statement that they're relying on in the
Lords, may
connective
kindly come
suit.
to page 50.
My
for
lords
a
may
moment.
just have page
Ma'am,
69.
That is the challenge made before this court.
My lords may just, my lords, I understand, my lords may just, for my sake, peruse that one paragraph, my lords. I'll just read that paragraph out. If my lords would have page 69. Para number 64, seventhly, the grounds, I'm just,
Madam,
my lords, I'm only,
estoppel. Once you have admitted that.
my lords, I will just read the portion on the judgment, my lords, that's at P45. My learned friend is not referring to
Madam,
P45.
at the time of main arguments, that's all. Now I am.
Lords, the
refraining only
wordings used in the
substantive-
written statement, I'll read
not
two lines,
deciding the
lords.
matter on merits. Huh?
Wordings used in the written statement, I'll read two lines. Hence, these defendants, that is
Bank loan
defendant,
ತಗೊಳ್ಳೋದು,
have
bank loan
no right,
ಕೊಡೋದಿಲ್ಲ,
title or
purchase
interest.
ಮಾಡೋದು, sale agreement
And they have
ಬರ್ಕೊಡೋದು,
relinquished all their rights in favor of
ಪರಪಟಾಣಿ
third
ಬರ್ಕೊಡೋದು,
defendant.
and one defending the very act of the defendant number 1. Huh?
And third defendant is liable to pay the entire loans to the bank. I have relinquished all my rights in favor of third defendant. This is the statement, my lords, they make in the written statement.
My lords, may I just, my lords, this page 70, may I just read out that one
They
relevant?
made it clear. You have lost the interest over the property. You have already sold the property in favor of defendant.
My lords, it's just to bring out the correct facts, my lords, because
In turn, you have already sold the property in favor of defendant number 3. What right you are having now to oppose this appeal?
my lords,
You have
this,
no locus at all now.
my lords, only to
Yeah,
assist
yeah.
the court, I just want to point out the relevant
You got
provision,
the
my lords.
benefit from the bank. You got the benefit from the appellant, and then also sold the property in
That-
favor of defendant number 2.
My lords, I received
Hear
no
me first.
benefit from
Hear
the
me
bank.
first.
Please.
Hear me first. You got the benefit from the appellant.
No, my
from-
lords.
From the bank, and also executed the power of attorney to clear the loan. of
That
the
is not
bank.
at all the case, my
Then,
lords.
then you have sold the property in favor of defendant number 2 by receiving the consideration.
Please, my lords,
Then
that is
again-
not the
again you
case.
sold the, in turn, your purchaser had sold the property in favor of.
My lords,
defendant
that is
number
not
3.
at all the case. Those,
That we will consider in the
those
case.
facts are being
That we will
misrepresented,
consider in this
misrepresented
case,
to your
madam.
lordships.
Don't interrupt, madam. I am a
Please.
frame in substantive question of law.
Please.
ಹೇಳಿ madam. Ignoring the document exhibit P35 coupled with exhibit P9 and also exhibit P11 and also both the oral and documentary evidence available on record, in dismissing the suit and confirming the same. Whether the courts below committed grave error in failing to appreciate the evidence given by the first defendant in OS number 464 of 87 and also the written statement wherein categorically admitted the very execution of sale agreement, that is exhibit P35, and also the execution of power of attorney exhibit P11, and also the exhibit P9 registered power of attorney, and the same is as against the principles of estoppel. Issue notice against the respond number 2 and 3.
It's interim order of obstruction.
Interim order in ಕೇಳಿದ್ದೇಳಿ heard on IA number 1 of 25 and having considered the grounds which have been urged in the application as well as the grounds urged in the respondent counsel and also the principles laid down in the judgment, and this court admitted admit ಅಂತ ಹಾಕೋಬಿಡಿ madam, admit ಬಂತಲ್ಲ, admitted the second appeal and framed the substantive question of law, and when there is a specific document of exhibit P35 and 37
9 and 11.
and also exhibit P9 and 11, it is appropriate case to grant the relief of temporary injunction restraining the third respondent in further alienating the property till the disposal of the second appeal.
I'm obliged.
Obliged.
With your lordship can permission. 66.
ಹಾ
Kindly have it tomorrow, man.
ಯಾವುದು
66, next matter.
ಪಾರ್ಟರ್ಡ್ ಎಲ್ಲ ನೋ ಡೇಟ್,
Tomorrow, man.
ನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಕೌನ್ಸಿಲ್.
Tomorrow.
ಪಾರ್ಟರ್ಡ್ ಎಲ್ಲ ನೋ ಜಡ್ಜ್ಮೆಂಟ್. ಆಲ್ರೆಡಿ ಹರ್ಡ್ ಓನ್ಲಿ ಫಾರ್ ರಿಪ್ಲೈ.
I'll reply not.
Only reply, ಸಾಕು ಕೊಡಿ ಏನು. I don't have any papers to dictate tomorrow.
ಅದು ನೋಟ್ ಡೌನ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿಲ್ಲ. ಇದೆ ಮೇಡಮ್, ಯಾವುದು ಅಡ್ಜನ್ ಅಬ್ಸಲ್ಯೂಟ್ ಇದು ಲಾಸ್ಟ್ ಅಲ್ಲ ಲಾಸ್ಟ್ ಅಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿತ್ತಾ? ಏನಾಗಲ್ಲ ಬಿಡಿ ಅನ್ಸುತ್ತಿದೆ. ಅದೇ 12th ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಇಲ್ಲಿಗೆ ಬನ್ನಿ, ಪರವಾಗಿಲ್ಲ. ಒಂದ್ಸತಿ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಬೇಡ ಬೇಡ, ಒಂದ್ಸತಿ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡ್ತಾರೆ. ಒಂದ್ಸತಿನೂ 3-4 ಸತಿ ಆಗಿದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಆಯ್ತು.
ಬರ್ತಾರೆ. ನಮ್ಗೇನ್ ಗೊತ್ತಿಲ್ಲ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬರ್ತಾರೆ. ಗೊತ್ತಿಲ್ಲ ಸರ್, ನಾನು ಇವತ್ತು ಬರ್ತಾರೆ. ಹಾಗೆ ಇರ್ಬೇಕು, ಫಾದರ್ ನೇಮ್ ಮತ್ತೆ ಹೆಂಗ ಇಲ್ಲ ಆಧಾರ್ ಕಾರ್ಡ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಆಧಾರ್ ಕಾರ್ಡ್ ತರಿಸ್ಬಿಡಿ ಎಲ್ಲ ಆಧಾರ್ ಕಾರ್ಡ್ ತರಿಸ್ಬಿಡಿ ಸರ್. ಇಲ್ಲಿ ಹೆಂಗಿದೆ ಹಂಗ ಏನು ಮಾಡುತ್ತೆ ಕೇಳಿ ನೋಡಿ ಸರ್, ಕೇಳಿ ನೋಡಿ ಆಧಾರ್ ನಮ್ಗೆ ಬೇಕು ಅಂತ ಕೇಳಿ ನೋಡಿ. ಅಷ್ಟೇ ಹಿಂಗಾದ್ರೆ ಈಗ ಹೆಂಗಿದೆ ಎಲ್ಲ ಪಾಸಿಟಿವ್ ಮಾಡಿ ಆಧಾರ್ ನೇಮ್ ನಾಟ್ ಅವೈಲೇಬಲ್ ಅಂತ ಬರೆದು ಫಾದರ್ ನೇಮ್ಗಳು ಒಂದು ಇದ್ರೆ ಹಾಕಿ ಇಲ್ಲದ್ರಿಲ್ಲ ಅದು ಇದು ನಾವು ಹೇಳ್ತಾರೆ ಅದು ಇದು ಏನಿದೆ ಅವನ್ನೆಲ್ಲ ನಂಬರೆಲ್ಲ ಕೊಡ್ತಾರೆ ಆಧಾರ್ ಕಾರ್ಡ್ ಹಾಕಿ
ಈಗ ಸಬ್ಮಿಷನ್ ನನಗೆ ಇದು ಕಳಿಸಿದ್ರು ವಾಟ್ಸಪ್ ಅದನ್ನ ನಾನು ಬರ್ತೀನಿ ಅದಕ್ಕೂ ಫೋನ್ ಮುಂದಕ್ಕೆ ಅದು ಹೇಳ್ತೀನಿ ಸಂತೆ ಹೆಸರು ಒಂದು ಆಮೇಲೆ ನಾವು FIR ಏನು ನಂಬರ್ ಅದಾವ ಸರ್ ಮನಿ ನಂಬರು ಅವೆಲ್ಲ ಇಲ್ಲ ಹೆಚ್ಚು ಕಡಿಮೆ ಇದಾವೆ ಸರ್
ಹಾ 17 70 ಹಾ ಸರ್ ಅದು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಇರೋದ್ರಿಂದ ಎಲ್ಲಾನು ಬಂದಿರುತ್ತೆ ಅಲ್ಲಿದೆ ಸರ್ ಇದರಲ್ಲಿ 98 ಅವರಿಗೆ ಬೇಕಂತ ಹಾ ಅದು ಸೈನ್ಗೆ ಸಿಗ್ನೇಚರ್ಗೆ ಚೆನ್ನಾಗಿದೆ ಕಿವಿದು ಪಾಸ್ವರ್ಡ್ ಬೆಳಿಗ್ಗೆ ಬಂದಿಲ್ವಲ್ಲ ಇಲ್ಲಿ ನಾನು ಯಾವ್ದು ತೆಗ್ದೇ ಕೊಟ್ಟಿಲ್ಲ ಇಲ್ಲ 65 ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ ನೋಟಿಸ್ ಅಲ್ಲ ಮಾಡಿದವರು ಕಂಟಿನ್ಯೂಸ್ ಮಾಡ್ತಾರೆ ಅದಕ್ಕೆ 11 ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಬೇಕಾದ್ರೆ ಹೇಳ್ತೀನಿ 11 8 notice ಅಲ್ವಾ?
Serial number 71 ಹೇಳಿ ಏನು? ಹ್ಮ್ 382 ಹಾಕಿಲ್ವಾ? ನಾಳೆಗಿದೆಯಾ? this tomorrow. 71 list this matter tomorrow along with RSA 382 along with ಬಲ್ಲ ಬಟ್ ಒಟ್ಟಿಗೆ ಹಾಕಿ ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ. 382
Pastor matter 50.
Appearing to the appellant notes. But I'm filing a memo in respect to respondent number 5 and 7. They are formal parties. They have been placed ex parte in regular appeal.
Counsel for the appellant files memo to dispense the notice against R5 and R7, R5 to 7.
R5 to 7.
And they are the formal parties and also they were placed ex parte.
Party in regular appeal as well as in OS original suit. They have not filed any written statement. They have not contested.
But appear ಆಗಿದ್ರು WS ಹಾಕಿಲ್ಲ.
Yes, they have not contested the matter.
They were placed in RA, ex parte in RA, and though appeared in original suit, not filed the WS. And hence, notice against R5 to 7 dispensed at the risk of the appellant. ಅಷ್ಟೇ.
Not there is an
ಮತ್ತೆ 4 refused.
4 is refused.
Notice issued against R4 refused and hence held sufficient. This is the matter for admission. On 24/7.
My lord, there is an IA.
ಅದನ್ನ consider ಮಾಡೋಣ.
Please, my lord.
24/7.
The urgency is, my lords, FDP proceedings are going on and the commissioner report has reached finality. So they are pressuring.
Already filed commissioner report?
Please, it is yet to be filed before the honorable court.
To be filed. ಆಯ್ತು. 24/7 ಬರುತ್ತಲ್ಲ?
15th ಇದೆ
ಯಾವಾಗಿದೆ
ಸ್ವಾಮಿ,
date?
15th ಇದೆ next date.
15th ಇದ್ರೆ list this matter on 14th for admission.
Grateful, my lords.
50.
ಎಷ್ಟು ಮಾಡೋಣ?
50.
I'm sorry.
50. ಹೇಳಿ.
I'm sorry, I was not present in the morning, my lord.
ಹೇಳಿ 50.
My lord, it's a defendant's appeal. The suit is for partition and separate to the trial, filed by the respondents. We had raised two contentions, my lord. One is the father of the plaintiffs had filed a suit before Bhadravati court. He died during the pendency of the suit. Subsequently, his LRs were brought on record. They did not prosecute the suit, and the suit came to be dismissed. Subsequent,
Not on merits.
not on merits. It was dismissed for non-prosecution. Subsequent suit is filed by the children who are the parties to the earlier suit without disclosing any of these averments in the plea. So my submission was it is hit by order 2 rule 2. Of course, the provision of order 2 rule 2 may not apply for a partition suit, but that was the contention that was taken before the trial court. And the second ground on which this appeal is filed is that item number 2, 6 and 7 are the self-acquired properties. To substantiate that item number 2, 6 and 7 are the self-acquired properties, sale deeds were produced before the trial court. That has not been considered by the trial court. And the trial court holds that since they had no other avocation other than the agriculture, so therefore these properties are acquired out of the joint nucleus of the joint family.
How many joint family properties?
There are totally 8 items. There are totally 8 items.
8 items.
Out of which 2, 6 and 7 are the self-acquired properties. That is the contention taken by the defendants. Thirdly, these are the main grounds on which the trial court has totally and we had also taken up the plea of earlier partition. May I request your lordship to kindly turn to and the fact that pursuant to the oral partition, mutation entries were not effected. The trial court and as well as the first appellate court disbelieves the earlier partition.
Was there any mutations?
There was no mutation. There was no mutation.
There must be some material.
There was no material.
Earlier partition. No such document.
There was no material. So these are the three grounds on which that were taken by the defendants in the trial court. The trial court has disbelieved it and proceeded to pass the decree.
Second appeal ಅಲ್ಲಿ ಏನಿಲ್ಲ.
ಅಷ್ಟೇ, ಸುಮ್ಮನೆ I don't want to drag all this.
1 to 4.
1 to 4.
ಏನ್ ಹೇಳ್ತೀರಿ?
That earlier partition, my lord, what they have taken, they did not even allow present for cross examination. Therefore, both the courts have held that DW1, who has not offered for cross examination, he has failed to prove the earlier oral partition, and all the entries.
No, he was subjected to cross examination for
No. That is the finding of both the courts, that he did not.
He did not further cross
examination.
Full ಆಗ್ಲಿಲ್ಲ ಅವ್ರದ್ದು. And therefore the evidence is disbelieved.
Only defendant number 1, not plaintiff's father, my lord. Therefore, courts have held that it is not acted upon, therefore it is not proved.
Who took the specific contention that earlier there was a partition anta?
Defendant.
That is one of the
DW1, DW2, DW3, DW4 idare.
ಎಲ್ಲ everybody has taken that
They are the sons who have examined.
Cross examination ಬರ್ದಿದ್ದಾರೆ ಯಾರು?
DW defendant number 1. He did not offer himself for further cross examination.
Defendant number 1
ಹೌದು.
who has been examined as DW1.
He did not offer himself for further cross examination.
For all other defendants, DW2, 3, 4 ಯಾರು ಅವರು?
They are the sons who have been examined to prove
ಹೇಳೋದೇ ಇಲ್ಲ.
properties are self-acquired properties. Only to that extent.
Our contention, their contention was item number 5. They were only concentrating on their property. That is item number 2, 6 and 7 ಬಗ್ಗೆ ಮಾತ್ರ ಅವರು evidence ಕೊಡ್ತಾರೆ.
ಯಾರು?
Defendant 2, 3, 4.
Defendant number 2, 3, 4.
They were only concentrating on item number 2, 6 and 7 to say that they are self-acquired properties. ಅಷ್ಟೇ, ಅದನ್ನ ಮಾತ್ರ ಅವರು ಹೇಳ್ತಾರೆ.
In respect of 2, 6 and 7.
ಹೌದು. They have produced the sale deed also to indicate that these properties are purchased by.
Who was the karta of the family?
Karta of the family. May I request you one? I have produced the genealogical tree at ink page number 95. Siddappa.
Siddappa, a propositors of the family.
Siddappa was the
having
propositor.
3 sons. Siddhamma, Kariyappa, Hanumantappa, one daughter, 2 sons. ಅವನಿಗೆ ಸಿದ್ದಮ್ಮಂಗೆ ಏನು?
Plaintiffs are the children of Hanumantappa.
Defendants are the children of Kariyappa.
Kariyappa.
Correct.
But Hanumantappa himself had filed a suit earlier.
He had filed a suit for partition.
But that was not adjudicated on merits.
No, Miller.
On account of death,
But these people had come on record as a legal representatives, but they failed to prosecute that suit, and nothing has been stated in the subsequent suit about the filing of earlier suit. That is the only thing that should have been considered.
Third, this matter is listed for admission, and I heard the counsel appearing for the respondent. This second appeal is filed against the concurrent finding. The factual matrix of the case of the plaintiff before the trial court, that suit scheduled properties belongs to the joint family, and they are in joint possession and enjoyment of the suit scheduled property along with the defendants. And defendants appeared and filed a written statement, and particularly first defendant took the contention that there was a oral partition on 12/4/1968. And first defendant also took the contention that present suit is not maintainable in view of the decision in OS number 80 of 1987. And also contend that suit is hit by Order 2 Rule 2 of CPC. And further contention was taken by the defendant number 1 that item number 2, 6, 7 and 8 are his exclusive properties. And defendant number 3 also took the specific defense that item number 7 is his self-acquired property, and defendant number 4 took his specific defense that item number 2 is his self-acquired property. The trial court allowed the parties to lead evidence, and plaintiff number 2 has been examined as PW1 and also examined other witnesses as PW2 to 4 and got marked document exhibit P138. But PW2 not subjected for cross examination, and therefore evidence of PW2 was discarded. The PW3 and 4 submitted themselves for cross examination by the defendants number 3 and 4 after the addition of defendant number 3 and 4. On the other hand, the defendant number 1 and 4 have examined as DW1 and 2 respectively, and also examined 2 witnesses as DW3 and 4, and got marked document exhibit D1 to 21. But DW1 submitted himself for cross examination on 21/7/2012, and subsequently he did not appear, and hence his evidence was not considered. And trial court, full stop. The trial court, having considered both oral and documentary evidence, comes to the conclusion that properties are ancestral properties, answering issue number 1, and also answered issue number 2 as partly in the affirmative and partly in the negative with regard to ಅದೇನೆ ಅದ್ರಲ್ಲಿ ಏನಾರು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ ಅಂತ ಏನಾರು ಇದು ಮಾಡ್ಯಾರ, ಪಾರ್ಟ್ಲಿ ಯಾಕೆ ಮಾಡಿದ್ರು ಇಶ್ಯೂ ನಂಬರ್ 2ನ? ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲಾನು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟೀಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಫೈಂಡಿಂಗ್.
ಹೌದು. Whether the plaintiff prove that suit schedule properties being joint family, they are in joint possession.
And the same is answered partly ಅಂತ ಯಾಕೆ ಮಾಡಿದ್ರು ಅಂತ ಕೇಳಿದೆ. ಇಶ್ಯೂ ನಂಬರ್ 2 ನಲ್ಲಿ 2, 3 and 6
that is wrongly framed.
Then not correct. Answered the same as affirmative in coming to the conclusion that social properties are the joint family properties, and though took the defense that item number 2, 6, 7 and 8 are the self-acquired properties of defendants as contended by the first defendant, third defendant, fourth defendant, and the same was answered as negative, and granted the relief of partition in respect of the social properties, coming to the conclusion that entitled for 1/3 share in all the social properties. Defendant number 1 and 2 are also having 1/3 share each in the social property. Being agreed by the finding of the trial court, an appeal is filed in RA number 89 of 2013, and appellate court, having considered the grounds urged in the appeal as well as the respective submissions of both the counsels, formulated the point whether the trial court erred in answering the order 2 rule 2 is not applicable, and also whether the trial court committed an error in coming to the conclusion that there was no any evidence of oral partition between Hanmantappa and defendant number 1, and whether the trial court committed an error in answering the other issues in respect of specific contention that item number 2, 6, 7 are the exclusive properties of defendant number 1, 3 and 4, and whether it requires interference of this court. The appellate court, also having reassessed the material available on record, answered all the point for consideration as negative on reassessment of both oral and documentary evidence. And confirmed the judgment of trial court, and hence the present second appeal is filed before this court. The main contention of the counsel appearing for the appellant before this court that both the courts have failed to take note of the fact that item number 2, 6 and 7 of the social properties were also the joint family properties. Instead of sale deeds are produced before the trial court, that the same having been purchased by defendant number 1, 2 and 3. And also it is the contention of the appellant counsel that The conclusion of both the courts that the respondents are in joint possession and enjoyment of the social property is erroneous and also not justified in ordering for partition in respect of item number 1 to 8 scheduled properties. Although different number 1, 3 to 5 had produced exhibit D1, D2, which reflect that properties are stands in the name of respective parties. And hence this court has to admit and frame substantive question of law. The counsel appearing to the respondent would contend that in order to prove the factum of earlier partition, no document is placed before the court. Only defense was taken and mere taking of defense is not enough. The counsel also would vehemently contend that when the family properties are in existence and the same has not been disputed, and if any other properties are purchased by them, and the same is purchased out of joint nucleus and not placed any record before the court that they were having other income other than the joint nucleus of the property. And hence their contention cannot be accepted that those properties are self-acquired properties. And both the courts have taken note of the said fact into consideration and answered the relevant issues as negative, that defendants have not proved the same that they are the self-acquired properties. Having heard the appellant counsel and also the counsel appearing for the respondent, and it is not in dispute that they are the legal heirs of Siddappa. Siddappa. It is also not in dispute that the plaintiffs are children of Hanumantappa, who is the son of Siddappa and Srimati, son of Hanumamma. ಸಿದ್ದಪ್ಪ ಇದಾರಾ ಇಲ್ಲಲ್ಲ
ಸಿದ್ದಪ್ಪ ಇಲ್ಲ
ಮತ್ತೆ 1/3 ಹೆಂಗ್ ಮಾಡಿ ರಾಕೆಗೆ ಕೊಟ್ಟಿದಾರ ಸಿದ್ದಮ್ಮನಿಗೂ 1/3 ಕೊಟ್ಟಿದಾರ
ಇಲ್ಲ
1/3 ಹೆಂಗ್ ಮಾಡಿದ್ರು defendants are the legal heirs of Kariyappa. Kariyappa is no more.
Kariyappa is also no more.
No more. And no doubt the Hanumantappa earlier had filed the suit. And also no dispute that he passed away during the pendency of the suit. And also the plaintiffs were brought on record as legal heirs in the earlier suit. But the same was also not adjudicated on merits. The very contention of the counsel appearing to the appellant that Order 2, Rule 2 was not invoked by the trial court and appellate court. And the very submission cannot be accepted. And earlier suit was filed by the father, but the same was not adjudicated on merits. And the same was dismissed for non-prosecution.
Dismissed for non-prosecution.
Dismissed for non-prosecution. The other contention of the appellant counsel that specifically pleaded by defendant number 1, defendant number 3 and 4, that item number 2, 6 and 7 are the self-acquired properties of the respective defendants. It is emerged during the course of evidence that though DW1 took the specific defense regarding oral partition, and he was subjected to partly for cross-examination, and thereafter he did not subject for cross-examination, and hence his evidence has not been accepted. And defendant number 1 only pleaded regarding earlier oral partition, and the same has not been substantiated. And in order to prove the factum of the earlier oral partition is concerned, parties have not acted upon, and nothing is placed on record that parties have acted upon, and hence the very contention that earlier there was a partition also cannot be accepted, and the same was also taken note of by both the trial court and appellate court. It is also important to note that Hanumantappa earlier had filed the suit, and this court already observed that the same has not reached its finality. But the fact that family was having other family properties, that is item number 1, 2 na?
Item number 1 to 1, 3 to 5.
1, 3 to 5.
8.
And also the item number 8, including the house property and also the agricultural land property in bearing survey number 2/1, 25/1, and also 51/2B, and the same is not disputed, that those properties are belongs to the family. But only contention was taken that they have acquired the properties number 2, 6, 7, and they are the independent properties. And the fact that there was no any partition prior to purchasing of this property, and though they have produced the sale deed and having independent income to purchase those properties also not established by the defendant number 1, since he was not subjected to cross examination in full, and though other defendants examined and nothing is placed on record that they were having independent income to purchase those property, and hence both the trial court and appellate court not accepted their contention. And when searching the case in the absence of documentary evidence that they were having independent source of income to purchase the property, question of coming to the conclusion that those properties are their self-acquired properties also cannot be accepted, and both trial court as well as the appellate court reassess the material available on record, and the fact that all the joint family properties are standing in the name of defendant number 1, and when defendants have not produced any separate income to purchase the item number 2 in the name of defendant number 4, also taken note of by the appellate court, discussed in detail the evidence of witnesses including DW1, DW2, DW3, and except stating in the affidavit that they have purchased the property out of their independent income, nothing is placed on record, and hence I do not find any error committed by the trial court and appellate court in granting the relief and confirming the same. Under the circumstances, I do not find any ground to admit and frame any substantive question of law. In view of the discussions made above, I pass the calling order. Second appeal is dismissed.
T4. Varun Gowda.
These are concurrent findings as a suit for declaration injunction, my lords. But my lords, one question of law that was open, which wasn't, my lords, adjudicated, is that, my lords, your lordships may come to page 50 of the trial court judgment and
page 50.
50, my lords. Third line from the last, my lords. If I may be permitted to read, my lords. It is further stated by PW1 that the said Amrut Lal Karni had executed a GPA and affidavit dated so and so in favor of one N. Srinivas. They are marked at exhibit P3 and P4. The said GPA is unregistered. So, my lords, the factual aspect is, my lords, that the plaintiff, respondent's vendor, who had sold the property, alleged sale deed, in favor of the respondent, my lords, had executed a GPA in favor of one N. Srinivas, which GPA is unregistered, which is a finding recorded by the trial court itself. That question of, my lords, that should have, the trial court ought to have indulged themselves in adjudicating that question of law. The first appellate court also, my lords, ignores the fact that the GPA was unregistered and upholds the fact that the sale deed was having legal sanctity. Therefore, my lords, they also affirm the order of the trial judge. Place one judgment, my lords, of this honorable court before your lordship. In similar circumstance, para 14, my lords, this honorable court itself, insofar as, my lords, GPA based same transactions are concerned, para 14 is the observation I may be reading. An attempt is made on behalf of the plaintiffs to contend that the second plaintiff has sold the property as a general power of attorney holder and not as a title holder. It is argued that the power of attorney is not compulsorily registrable. The submission is noted with care. Suffice it to note that the deed of power of attorney is not one of the instruments specified under Section 17 of the Registration Act compulsorily registrable. However, if a power has been created empowering the attorney to sell the property, if a document that gives a right to the attorney holder to sell the immovable property, then it would be a document creating an interest in the immovable property which would require compulsory registration. And, my lords, the judgment of Suraj Lamp Industries is also referred to in that matter. This question of law should have been indulged by the, my lords, the lower court as well as the first appellate court. When they themselves have come to the finding that the GPA is unregistered, question, the sale deed will have no legal sanctity. So in view of that, my lords, they have not even dealt with this aspect of the matter.
Counsel.
And my lords, another submission.
Document is not a compulsory registrable document. That is only for authorizing to execute the document and not conveying any document, only power to appear as an agent to transfer the property. That's all.
My lords, what happens is, it's a GPA coupled with interest to sale. When that is the case, the judgment says that it
But
should
what
be
is the
compulsory.
GPA? Nature
Please-
of the
please-
GPA, nature of the GPA. You have got copy of the GPA?
No, my lords.
Ah.
Exhibit P3 is the GPA and there was an affidavit that was executed. On the basis of
Affidavit
that,
and GPA.
yes,
Both
on
are
the-
executed
yes,
by the
but
original
it's
owner.
unregistered
Original owner.
by the original owner.
Based on that GPA only he acted upon.
The GPA
and
holder
he-
has sold that property in favor of
Property
the
to-
respondent plaintiff.
Then
It should have been registered. Is the, my lords,
counsel.
when the GPA, my lords, is coupled with interest and the judgment says that it should be registered, my lords, there's another judgment of the Honorable
Only
Supreme
coupled
Court.
with interest, counsel, only appointing an agent to execute the document. Interest was not delivered. But here is a case of interest was delivered.
My lords, they have sold the property. He has sold it by the sale deed.
Selling the property, authorizing him to act upon as an agent.
My lords, that would not be the case. I'll place another judgment of this Supreme Court, my lord, which has, my lords, affirmed the findings.
While authorizing him to execute a document, it compulsorily registrable ಅನ್ನೋ ಕೇಳಿದೆ.
Under section 17(1)(b), it should
17(1)(d)
be.
ನಲ್ಲಿ only appointing him as an agent, that's all, to do an act, that's all.
But my lords, when there is a conveyance of title and ownership, my lords, that document should be registered. Is the
That
humble submission.
document is registered. Conveying any property in favor of him,
And transferring any title or ownership, my lords, that property should be compulsorily registerable, my lords.
whether any interest is transferred to the person.
The case is such that the alleged original grantee was granted the land in 1972 is the case of the plaintiff. He has executed this GPA in favor of one Mr.
GPA
and an affidavit.
And an affidavit.
And an
What
affidavit.
it says affidavit?
My lords, it's a affidavit, it gives him the right to sell the property if any.
Right to sell.
Yes,
Only right to sell.
yes.
Not
act-
conveying the property to a person
My lords,
in terms of the affidavit.
so what happens then, my lords, acting upon
ಮೊದಲೆಲ್ಲ
that,
ಏನಾಗ್ತಿತ್ತು ಅಂದ್ರೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ. ಪ್ರಾಪರ್ಟಿ
Yes.
ಏನ್ ಮಾಡ್ಬಿಡೋರು ಒಂದು
Through GPS.
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್,
yes, my lord,
GPA,
yes,
ಪೊಸೆಷನ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡೋದು ಅದೆಲ್ಲ ಮಾಡ್ತಾ ಇದ್ರು.
that was a practice.
ಆವಾಗ that cannot be, but here is a case only selling of the property ಅಂತ ಅಂದ್ರೆ but is only appointing an agent ಅಷ್ಟೇ. Whether property was sold in favor of him.
The plaintiff, why the sale deed? Please see, my lords, it was sold. by
Sale,
the-
that is executed by GPA holder.
Yes,
But whether property is conveyed based on the sale agreement.
that is the case, that is the case of the
agreement,
respondent plaintiff, stating that the property is conveyed to her. And she
GPA,
claims,
property is conveyed
yes, and she claims ownership through that GPA.
through that GPA.
Yes, yes, my lords, which is why, my lords, I'm citing these,
That's what I asked you.
please,
Told.
which is why she is claiming, my lords.
Issue notice against the respondent and also in the meanwhile get the records of the trial court. The judgment remove the structure and hand over the vacant possession.
My lords, one submission in this
Say
regard, in the course of these proceedings before this lordship, my lords, what has happened is execution proceedings, my lords, notice hasn't been issued to me. They have proceeded with the execution proceedings
Without the
and an
notice.
order has been passed. Yes, and I have,
Without the notice.
yes,
What order has been
this
passed?
or I'll just pass on to your lordship. Now, my lords, what is happening is she has taken possession, what my lords, what
Already
order,
taken possession.
and now she's trying to alienate that property.
But already
We have-
possession was taken. Now how RSA is maintainable, counsel?
Lords,
Counsel for the DHR
if- on the
presented
facts
that
of the
time,
matter, if
decree
I
has been-
succeed in the,
Decree has been fully satisfied.
that's what, my lord, I have not issued any notice, has not been issued to me. I have not received any notice. I have not been given an opportunity to, my lords, appear in the execution proceedings.
Property along with the DHR and JDR was absent during the said time. Auto sheet ಇದೆ ಇದ್ರದ್ದು execution 7/23.
I'll just,
The social property, AC sheet house was in dilapidated condition and the door was kept open and on inspection, no movables. Issue notice to the judgment letter on IA 1 and 2 ಅಂತೇನೋ ಇದೆಯಲ್ಲ notice ಆಗಿ.
I have not received any notice, my lords. Had I received a notice, I would have taken part in the proceedings.
Copy notice to so and so RPD returned as unserved. Substituted service,
They have taken substituted service thereafter. But my lords, I have not been issued a notice at all, at least given an opportunity, my lords, to showcase my stand in the execution
I issue
petition.
notice against the respondent and call for records.
My lords, one submission in that regard. Now, since because there are efforts being made to alienate the property, at least so far as that is concerned, I may be protected, my lords. Otherwise, my appeal will not lead to any benefit, my lords.
Further alienation.
Yes, please, my lord, because that's what's happening.
Counsel appearing with the appellant would submit that he has filed an application. IA number 1 of 23, praying this court to stay of ಏನ್ ಕೇಳಿದ್ರಿ stay ಏನ್ ಕೇಳಿದ್ರಿ ನೀವು injunction ಏನ್ ಕೇಳದಂಗಿಲ್ಲ
ಇಲ್ಲ
stay ಕೇಳಿದಿರಿ.
Earlier when this was filed, we had sought to stay the impugned orders. Subsequent development is
order stay ಮಾಡಕ್ ಬರಲ್ಲ ಈಗ according
that
to you
doesn't-
already
no, that doesn't survive, my lords.
So
All
then
I'm
you
saying
can make an application, fresh application.
all
that's
I'm saying is in the
present IA
subsequent-
not survive for consideration in view
Yes.
of the already possession was handed over. Your submission is that without giving any notice, delivery was
Yes.
done.
Yes,
Then
my
you can file necessary application for preventing him in further alienation.
Your lordships may observe in one line
Ah.
in the order that some protection may be given till.
ಅಲ್ಲ protection ಈಗ ನಿಮ್ಮ application it becomes
I'm not
infectious
pressing,
now.
not on that application.
ಮತ್ತೆ?
In view of the
You have to
subsequent
make, you have
facts.
to fresh an application, that's
Please,
all.
please.
Hold.
I'll file.
Council insists for passing an order on IA number 1 of 23, but the council produced the order sheet passed in execution number 7 of 23, brought to notice, produced order sheet alla, brought to notice of this court that possession has been delivered and execution fully satisfied. But council contend that no notice was issued by passing such an order, and hence contend that there must be an order not to alienate further, but the application become infectious in view of only stay of the earlier order was stay of the concurrent finding was sought and the same become infectious and liberty is given to make necessary application for seeking appropriate relief.
Please.
List this matter on 11/8.
Please.
62. Shauri Hecha.
Decreed equally entitled for half share. ಹೇಳ್ರಿ
So
council.
lordship heard the matter in the morning.
ಅವ್ರೇನ್ ಬರ್ಲಿಲ್ಲ ಅಲ್ಲ?
Caveat ಇಲ್ದಾರೆ ಅಂತ ಕರೆದ್ರಿ.
ಕೇವೇಟರ್ ಇದ್ರಲ್ಲ ಅವ್ರು ಎಲ್ಗಳಿಲ್ಲ
ಬಂದಿಲ್ಲ.
ತಗೊಳ್ಳಿ. Heard this matter for some time and noticed that counsel for R1 is absent and matter is passed over. And in spite of it also, in the afternoon also counsel is absent. And hence list this matter on. ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್, ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ.
May I seek a small indulgence, FDP ಇದೆ ಸ್ವಾಮಿ, ಅದನ್ನ at least.
FDP ಏನಕ್ಕಿದೆ ಸ್ಟೇಜ್?
ಅಲ್ಲ ಅವರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಈಗ ನೋಟಿಸ್.
ಬರೀ ಫೈಲ್ ಆಗಿದೆ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ತೀನಿ ನೋಡೋಣ. ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
16/7.
16/7. ಅದು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ I'll consider it and I will admit it. In if there are grounds.
Yes.
Further argument 66. Rangaramu, A. Swanish.
ಏನ್ ಪಾಸ್ ಅವ್ರಿ ಬೆಳಗ್ಗೆನು ಕೇಳಿದ್ರಿ ನಾನು ನೀವೇ ತಾನೇ ಮಾಡೋದು, ಯಾರು ಮಾಡ್ಬೇಕು? ಪಾಸ್ ಓವರ್ ರೀಚ್ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದೀನಿ. ಆಯ್ತು ಪಾಸ್ ಓವರ್.
67.
ಇದು ಪಾಠ ಏನಾಗಿದೆ ಹೇಳಿ? ಸಿದ್ದರಾಮಯ್ಯ ಫಾರ್ R1 to 4, R9 and 10. Your formal party. ವಿಡ್ರಾ ಮಾಡಿದೀರಾ ನೀವಾ ಅವರ? ನೀವೀಗ ಇದ್ರಲ್ಲಿ ನಿಮ್ದೇನಿಲ್ವ ಹೇಳೋದು? ಓನ್ಲಿ ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ. ವಾಟ್ ಅಬೌಟ್ ಆರ್ ವಿ? You are supporting the appellant. ಏನ್ ಗ್ರೌಂಡ್ ಏನ್ರಿ?
This the ground is, before the trial court, there is no pleadings and there is no challenge to the settlement deed, my lord. The settlement deed has given effect to, it is the partition, my lord, it has, item number 8 has been given to the plaintiff. Here, the motivation has been affected. Thereafter, my lord, after his death, those land, my lord, which they have gone to his share, they have sold also, my lord. They have sold it. My lord,
Item number 8 was given to the plaintiff.
Yes, my lord.
And mutation was also
Yes, my lord.
entered.
Yes.
And he sold the property.
Yes.
Ah.
No, my lord, his children sold the property after his death. My lord, the trial court says, my lord, even though there is no pleadings, there no challenge with the, but the trial court said, the very appellate court, my lord, I'm sorry, appellate court, they passed an order stating that, my lord, the
It was dismissed.
Suit was dismissed.
Appellate court remanded the matter.
Remanded the matter. Without noticing that there is no pleading with regard to the correctness of the settlement deed, my lord. And without noticing the settlement deed has been given effect to. Well, your lordship on that day, my lord, has item number, point number 4 and 5 at page 49 has asserted that the IA-7 filed by the appellant for
Order 1 rule 10 ಹಾಕಿದ್ರು.
ಹಾಕಿದ್ರು, ಅದು ಅಲೋ ಆಗಿದೆ ಅಂತ.
Impleaded one ಎಂತದ ಹೆಸರು ಅಮ್ಮ ಏನೋ ಹೆಸರಿತ್ತಲ್ಲ ಅವ್ರದ್ದು.
No, she was not a party in the, Chinnamma is not a party in the suit, my lord, so he want to implead. My lord, so far as Chinnamma is concerned, in the settlement deed, land has been given to the minor children, appointing one Puttaya as the guardian for when she was suspended for her education and all those things, my lord. And in the said settlement deed, it has said, my lord, even if they can sell the land for their marriage purpose and for education, all those purpose. In the settlement deed, my lord, there is a government that land has been given to that Chinnamma also.
She is a daughter ಅಲ್ವಾ? ಅವ್ರಿಗೆ ಏನು ಕೊಟ್ಟಿಲ್ವಲ್ಲ ಶೇರು?
ಇಲ್ಲ, ಅವ್ರು ಮೈನರ್ಸ್ ಇದ್ರು.
ಅವಾಗ ಮೈನರ್ ಇದ್ರು.
ಪುಟ್ಟೆ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
But original suit she has not been made as party.
Plaintiff has not made it.
And the plaintiff not made her.
ಅವರೇ ಮಾಡ್ಬೇಕಾಯ್ತು, plaintiff ಮಾಡ್ಬೇಕಾಯ್ತು. We are not the plaintiffs.
ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರನ್ನ ಬಿಟ್ಟು ಡಿಸೈಡ್ ಮಾಡಕ್ಕಾಗಲ್ವಲ್ಲ? That's the reason.
ಆಗಲ್ಲ, ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ. ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಂಪ್ಲೀಟಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
I will read once, madam.
ಆಯ್ತ್ರಿ, how can the court can decide in the absence of Chinnamma that they have already given the share in favor of Chinnamma? Party ಅಲ್ವಾ?
ಹಾಗಲ್ಲ, ಅವರು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ಒಂದು ಎರಡನೇ ಇದೆ ಫೈಲ್ಡ್ ಇಂಪ್ಲೀಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ in the RA, but it has not been amended. That Chinnamma is also no more now.
ಲೀಗಲ್ ಏರ್ಸ್ ಇರ್ತಾರಲ್ಲ.
ಇಲ್ಲ, ಬಂದಿಲ್ಲ. ಈಗ ಒಂದ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಯಾರ. ನನ್ನ 4ನೇ ಹೆಂಡತಿಯ ಹೆಣ್ಣು ಮಕ್ಕಳಾದ, ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್, ಐ ವಿಲ್ ರೀಡ್ ಇಟ್ ಮೇಡಮ್. ಅಂದಾಜಿದಾಗ ಸೊತ್ತು ಬಂದಿದ್ದಾರೆ. 4ನೇ ಹೆಣ್ಣು ಮಕ್ಕಳಾದ ಮೈನರ್ ಜಯಮ್ಮ ಮತ್ತು ಚಿನ್ನಮ್ಮ ಇವರುಗಳಿಗೆ ಪೋಷಣೆ, ವಿದ್ಯಾಭ್ಯಾಸ, ಲಗ್ನ ವಗೈರೆ ಮಾಡಲು ಕೊಟ್ಟಿರುವ ಸತ್ತು ಡಿ ಶೆಡ್ಯೂಲ್ ವಿವರ ಡಿಟೋ ಕಸಬಾ ಹೋಬಳಿ ಅಂತರಸನಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 93ನೇ ನಂಬರು ಖುಷ್ಕಿ 1 ಎಕರೆ 9 ಗುಂಟೆ ಆಕಾರ 1 ರೂಪಾಯಿ ಒಳ ಜಮೀನಿಗೆ ಚೆಕ್ ಬಂದಿ. ದಿಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಗಿವನ್, my lord. But for the purpose of his marriage, those land has been sold and their marriage has been conducted by that Puttaya, my lord. Furthermore, there is no bleeding at all, my lord, with regard to the with regard to the validity of the settlement deed. It has been given effect to. He has taken the share. Those lands here, their children have sold it after the death of his father. The trial court has observed that this aspect and said that they see in the absence of any pleadings, the settlement deed cannot be set aside. No, he has not challenged the settlement deed also, my lord.
Instead of trial, appellate court would have been considered the matter by the appellate court itself.
Yes, sir.
The issue is only daughter was impleaded. And the limited purpose matter is remanded. Here also made it clear, observation is made, for the limited purpose of impleading the daughters and to ascertain the extent of shares to which each of the parties to the suit are entitled in the suitable properties. This court is considered opinion that the ends of justice would be met if the matter is remitted back to the lower court. That would have been done by the appellate court itself.
Yes.
Impleading the daughters as parties. Defendant number 5 as to item number 12 to 14. Appellate court would have.
Is what?
Instead of remanding, it itself would have decided the same. I will set aside the order and remand the first appellate court itself, let the first appellate court itself implead.
Father has affected the settlement deed, and to which he has given certain extent of lands to the children, including the daughters.
Including daughter has also given, my lord.
That was not challenged by the plaintiff, either in this suit or earlier, but that has been acted upon. Now, reopening of all these things will result in
But that too for the limited purpose only the matter is remitted back.
remitted back only for the purpose of impleading and ascertaining the share. But after holding that exhibit D, the settlement deed is not valid.
He said, my lord, the estimate is not valid, my lord.
Whether any relief is sought in the plaint regarding settlement deed is concerned?
No. Nothing, my lord.
I request your lordship to kindly see the judgment of the trial court.
Except the settlement deed, any other properties are available?
Certain other properties are available, which was retained by the father. But in respect of which
Who appears for the plaintiff? Appear ಆಗೋದು ಇದರಲ್ಲಿ? Who appears for the plaintiff?
ಇಲ್ಲ, ಸಿದ್ದರಾಮಯ್ಯ ಬೇರೆಯವ್ರಿಗೂ ಅಪೀಲ್ ಆಗ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರಿಗೆ ಬೇರೆಯವರಿಗೆ.
If this second appeal is considered, who is going to affect? Plaintiffs ಅದೇ ಯಾರು ಅಂತ ಕೇಳಿದೆ. ಯಾರು ಅಪಿಯರ್ ಆಗೋದು ಅವ್ರಿಗೆ? ಅಡ್ವೊಕೇಟ್ ಯಾರು ಇಲ್ಲಿ? ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಏನು? Whether plaintiff procedural properties are joint family properties of plaintiff and defendant number 1 to 3, whether the description of the properties belonging to plaintiff, defendant 1 to 3 given in the plain schedule is not correct, whether the suit is bad for non-gender of daughters of the Doddarangayya as parties as claimed in written statement of defendants. ಇದನ್ನ ಏನು ಆನ್ಸರ್ ಮಾಡಿದ್ರು ಇಶ್ಯೂ ನಂಬರ್ ನೆಗೆಟಿವ್ ಮಾಡ್ಬಿಟ್ರಾ ಡಾಟರ್ಸ್ ನ ಪಾರ್ಟಿ ಮಾಡೋದಿಲ್ದಾಗ whether there is any cause of action for the suit, whether the plaintiff
partly decreed. Lordship may kindly see in respect of item numbers 12 and 14. In respect of other properties, suit is dismissed.
Decreed.
Partly
Dismissed.
Suit is partly decreed. Insofar as item numbers 1 to 11, 13 and 15
ಈಗ ಸೆಟ್ಲ್ಮೆಂಟ್ ಡೀಡ್ ಪ್ರಕಾರ ಯಾವ್ದಾವ್ದು ಪ್ರಾಪರ್ಟಿ ಬರಲ್ಲ ನಿಮ್ಮ ಪ್ರಕಾರ? ಮೋಸ್ಟ್ಲಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಡೀಡಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಏನು ಡಿಗ್ರಿ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ತಪ್ಪು ಮಾಡಿದಾರೆ ಅದನ್ನ.
Appellate court has held that the settlement deed is not valid.
Not valid.
That is totally incorrect, my lord. That will have to be reconsidered.
Suit of the plaintiff is dismissed partly in respect of suit item number 1 to 11, 13 and 15. Suit of the plaintiff is decreed partly in respect of suit item number 12 and 14. 12 and 14 ಮಾತ್ರ ಕೊಟ್ಟಿದ್ರು.
ಅದಕ್ಕೆ ಕೊಟ್ಟಾರೆ. Because those properties are retained by the father, my lord.
ಯಾವುದು?
12 and 14.
12 and 14.
ಹೌದು, ಅದು ರಿಟೈನ್ ಮಾಡಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ?
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಅಪೀಲ್ ಹಾಕ್ತವ್ರು ಯಾರು?
Plaintiff.
Plaintiff.
Challenging,
The order of the trial court.
ಅಂದ್ರೆ ಚಾಲೆಂಜಿಂಗ್ ದಿ ಅದರ್ ಶೇರ್ಸ್.
Yes.
ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ಗೆ.
ಹೌದು, ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ ಚಾಲೆಂಜ್ ಇಲ್ಲ, ಅದರಲ್ಲೂ ಅಪೀಲಲ್ಲೂ ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ ಚಾಲೆಂಜ್ ಇಲ್ಲ.
ಬಟ್ ಅಪೀಲಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಲ್ಲೇನ್ರಿ? ಅಪೀಲಲ್ಲಿ ಏನ್ ಗ್ರೌಂಡ್ ಏನ್ ಅವ್ರಿಗೆ ಮೇನ್?
ಅಪೀಲಲ್ಲಿ settlement deed is not binding.
Whether plaintiff proves the suit schedule properties are in joint, ಅದು ಆಯ್ತು. ಪಾಯಿಂಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಪೀಲಲ್ಲಿ?
ಅಪೀಲಲ್ಲಿ
Paragraph 18. This is the first word.
Error in holding the partition as per the settlement deed effected by the father Doddarangaya as per the document marked as exhibit D3 dated 25/1965 as legal and binding. That is the issue.
That was the.
ಅದ್ರ ಮೇಲೆ ಅವ್ರು ಆನ್ಸರ್ ಮಾಡಿರೋದು.
This question, when there was no challenge before the trial court. I request your lordship to kindly see the judgment of the trial court. Paragraph, internal page 24. Is a very lengthy. Internal page 24 of the trial court's judgment. Last 8 lines. 8. It is further pertinent to note that the claim of the suit which prevails in this case as on today, your lordship got it. There is no pleading by the plaintiff with regard to the relief sought for by the plaintiff in this case. That is, plaintiff in the present suit has not made any averments with regard to the aspect that the settlement deed as per exhibit D3, by virtue of which his deceased father had effected partition during his lifetime on 25/1965, is concerned. The same is unjust, unfair, and there is no equal distribution of the properties among the co-partners of the joint family. And therefore, the said document is not having any binding effect on him, plaintiff. And also it is contended that there is no prayer in the plaint as to exhibit D3 document is not binding on the plaintiff. Therefore, in the absence of the pleading and prayer in respect of the said document, it is contended that exhibit D3 document, which is a certified copy of the registered document executed by the deceased father of the plaintiff and defendant number 1 to 3, that is deceased Doddarangaya, during his lifetime, while he was residing with his last wife, that is the fourth wife, Vidharaya Lakshmamma, and her children, that is defendants 1 to 3, and daughters at the relevant point of time, had effected partition in respect of the properties bearing suit item numbers 1 to 3, 5 and 7, as referred above supra. Since the said settlement date, which is remained unchallenged by the plaintiff either during the lifetime of his father or after his death, till prior to filing of this suit, that is at any point of time, and also contended that as the document at exhibit D3, that is on the basis of settlement date, plaintiff had received his share, which was allotted to him by virtue of the said document, and on the basis of the said settlement date, which is more than 30 years old document, the same has been acted upon by the parties, including the plaintiff, as the name of the parties to some of the suit schedule properties. Their names have been mutated, and suit item number 8 was allotted to the share of the plaintiff, and some of the properties till today stands in the name of the said Doddarangaya, that is the father of the plaintiff and defendant number 1 to 3. Under these circumstances, as the plaintiff for the last more than 3 decades has kept mum without challenging the said document earlier to this suit or in the present suit, and as well as in view of the provisions of section 90 of the Indian Evidence Act, the question of raising presumption of the said document or its execution does not arise. Whereas it is also contended by the defendant number 1 to 3 that during the lifetime of the father of the plaintiff and defendant number 1 to 3, by virtue of exhibit D3, plaintiff and defendant number 1 to 3 have been residing separately since the date of exhibit D3, that is during the lifetime of Doddarangaya, and the sons and daughters of Doddarangaya had settled the joint family properties by allotting the shares to them as contemplated under exhibit D3. Accordingly, the sons and daughters, including the plaintiff, have got their names to the kata of the land allotted to their respective shares in revenue records and the plaintiff's khata affected by virtue of MR 20/75/76 in order to cause harassment to the defendant. The plaintiff filed form number 7. This is how it proceeds.
ನೀವೇ ಅಪೇರ್ ಆಗ್ತಿರಲ್ರಿ ಪ್ಲೇಂಟಿಫ್ಸ್ಗೆ?
ಇಲ್ಲ ಮೇಲೋಟ.
R124 ಅಂದ್ರೆ ಯಾರು? ನೀವೇ ತಾನೆ ಪ್ಲೇಂಟಿಫ್ ಸೂರಪ್ಪನ ಮಕ್ಳು ತಾನೆ ನೀವು? ಭೀಮಕ್ಕ, ಮೀನಾಕ್ಷಮ್ಮ,
ನಿರ್ಮಲಾ ಕಮಲಮ್ಮ ಮೇಲೆ. ನಿರ್ಮಲಾ ಕಮಲಮ್ಮ.
ನೀವೇ ಸೂರಪ್ಪನ ಮಕ್ಳಿಗೆ ನೀವೇ ಇಲ್ಲನ್ರಿ ಅಪಿಯರ್ ಆಗೋದು? R124 ಅಂದ್ರೆ
ಇದರಲ್ಲಿ R9 and 10.
appeal filed by the Surappa passed away. His LRs are brought on record. Bhimakka, Ranganatha, Meenakshamma, Ravi Kiran, Narayana. ಸೂರಪ್ಪನ್ಗೆ ಯಾರು ಭೀಮಕ್ಕ ಅಂತ ಯಾರೋ ಒಬ್ರು ಇದಾರೆ. ಈ ಭೀಮಕ್ಕ ಯಾರು ಇದರಲ್ಲಿ ಪಾರ್ಟಿ R1ಗೆ ನೀವೇ ಇದ್ದೀರಿ? ರಂಗನಾಥ ಅವನ ಎಲ್ಲಾರ್ಸ್ಗೂ ನೀವೇ ಇದ್ರಿ. ಎಲ್ಲಾರ್ಸ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ತಂದಿದಾರಲ್ಲ. R1 ನೀವೇ ಅಲ್ವಾ ಭೀಮಕ್ಕನ್ಗೆ?
ನನ್ನ ಹತ್ರ ಇಲ್ಲಿ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. ವಕಾಲತ್ ಅಷ್ಟೇ ನನ್ನ ಹತ್ರ ಹಾಕಿದ್ರೆ 9 and 10 ಅಷ್ಟೇ ಇದೆ ಮೇಡಮ್ ನನ್ನ ಹತ್ರ.
1 to 4 ನೀವೇ ಹಾಕಿದಿರ ನೋಡಿ. 2 to 4 ಹಾಕಿದಾರ, 1 to 4 ಹಾಕಿದಾರ ನೋಡಿ ಮೇಡಮ್. Suit is filed by Surappa alias Chandrappa. In the appeal he passed away. His LR Bhimakka brought on record. Bhimappa is R1. R1 ನೀವು ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ? R1 to 4 ಅಂತ ಇದೆ.
1 2 3 and 4 ಇದೆ ಮೇಡಮ್.
ಸರ್ ಇವರು ಎಸ್ ನಾರಾಯಣ
ಭೀಮಕ್ಕ ಸೈನ್ ಮಾಡೋರು ನೋಡಿ. ನಾರಾಯಣ ಇದಾರಾ?
ಮೀನಾಕ್ಷಮ್ಮ ಭೀಮಕ್ಕ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
ಭೀಮಕ್ಕ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ. ಮತ್ ನೀವೇ ಇದ್ದೀರಿ?
ಮೀನಾಕ್ಷಮ್ಮ ರವಿ ಕಿರಣ್.
ಮತ್ ನಾವು ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ನಮ್ದೇನಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಿ.
ಸೀನಿಯರ್ ಏನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರು? ಸೀನಿಯರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನು ಕೊಟ್ಟಿದ್ರು ಅಷ್ಟೇ ಹೇಳಿದೆ ಮೇಡಮ್.
ನೀವು ಓದ್ಬೇಕ್ರಿ ಫೈಲು. ಈಗ ನಿಮ್ ಸಬ್ಮಿಷನ್ ನೋಡಿ, ನಾನು ತಪ್ಪ ಆರ್ಡರ್ ಬರ್ದ್ರೆ ಎಲ್ಲಾರ್ಗು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಕ್ಕೆ ತಾಕತ್ತಿದೆಯಾ? ಯು ಆರ್ ಹಿಯರ್ ಟು ಡಿಫೆಂಡ್ ಯುವರ್ ಕ್ಲೈಂಟ್ಸ್. Suit filed by the Surappa. Surappan LRna brought on record as R1. You are representing R1 also. Now says you are only formal party namden illa anta. ಎಲ್ಲಿ ನಿಮ್ ಸೀನಿಯರ್ ಅಲ್ಲಿ?
ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
PB ಸಿದ್ದರಾಮಯ್ಯ ಬರ್ತಾರಾ ಏನು? ಅವರು ನೋಡಿಲ್ವಾ ಫೈಲು ಅಥವಾ ಏನು? ನಿಮ್ಗೆ ಯಾಕೆ ಆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ರು ಅವರು?
ನೋಡಿದಾರೆ ಮೇಡಮ್, ನೋಡಿದ್ದಾರೆ.
R2 to 4 ಅವರು ಆಕ್ಚುಲಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಅಲ್ವಾ?
ಅವ್ರು ಡಿಫೆಂಡೆಂಟ್ಸ್.
ಮತ್ ನೀವ್ ಹೆಂಗೆ ಪ್ಲೇಂಟಿಫ್ಗೂ ಅಪೇರ್ ಆಗ್ತೀರಿ, ಡಿಫೆಂಡೆಂಟ್ಸ್ಗೂ ಅಪೇರ್ ಆಗ್ತೀರಿ ಈ ಅಪೀಲ್ ಅಲ್ಲಿ? ನೋಡ್ರಿ, ಬೇರೆ ಏನೋ ಕಾನ್ಫ್ಲಿಕ್ಟಿಂಗ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್. ನೋಡಿ, ವೆರಿಫೈ ಮಾಡಿ ಚೆಕ್ ಮಾಡಿ ಹೇಳಿ. ನೋಡಿ, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 16/7 ನೋಡ್ಕೊಂಡು ಹೇಳಿ, ಸಬ್ಮಿಷನ್ ಮಾಡಿ. 16/7
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ 68 ಜನಾರ್ದನ ಜಿ.
Petition, my lord.
Yes.
Kindly pass over, my lordship.
ಕೌನ್ಸಿಲ್ ಏನ್ 3:15
Kindly have it on tomorrow, my lordship.
2018 HRRP ಏನಿದೆ ಹೇಳಿ. 7 ವರ್ಷ ಆಯ್ತು ಒಂದು HRRP ಗೆ.
Yes, my senior head up in the Samanadar court.
Be there, you assist the court.
I should kindly.
If junior has no time, a junior can grab the opportunity and assist the court. You have to grab the opportunity. When the opportunity comes to you, you assist the court.
Kindly have it on tomorrow, my lord. Tomorrow, my lord.
ಏಕೆ ಓದ್ಲಿಲ್ವಾ ನೀವು? 2018 HRRP ರೀ. ರೈಟ್ ಆರ್ ರಾಂಗ್ ಡಿಸಿಷನ್ ಮಾಡೋಣ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಮಾಡಿದಾರೆ ಗೊತ್ತಿಲ್ಲ. ಎಷ್ಟು ವರ್ಷ ಕಾಯ್ಬೇಕು ಅವನು ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್?
I am for the landlord, my lord.
ಅದೇನೆ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಪಿಟಿಷನ್ ಏನಾ?
Yes, my lord.
ಆಯ್ತು ಹೇಳಿ, ತಪ್ಪೇನಾರು ಇದ್ರೆ ಸರಿ ಮಾಡೋಣ, ತಪ್ಪಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ.
No, my lord, kindly have tomorrow, my lord.
ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಪಿಟಿಷನ್ ಇದು?
Yes, my lord.
ಯಾವ ವರ್ಷದಲ್ಲಿ ಬಂದಿದ್ದು ಕೋರ್ಟ್ಗೆ? 15 10 ವರ್ಷ ಆಗೋಯ್ತು ಆಗ್ಲೇ.
Yes, my lords.
ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ 2018ರಿಂದ ಇಲ್ಲಿವರೆಗೂ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ? Dismissed on the ground ಏನು 27(2)(a) and R. Dual relationship ಇಲ್ಲ ಅಂತನಾ?
Put for partition is present, pending consideration.
ಆಲ್ರೆಡಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
They are also
Partition suit
contesting. They are also contesting in that suit.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇಫ್ ನೋ ಡ್ಯೂರಲ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಂತಂದ್ರೆ
There is a dual relationship between
ಏನಿದೆ? ದಾಖಲೆ ಏನಿದೆ ರೀ?
rental agreement is there, my lords.
ರೆಂಟಲ್ ಅಗ್ರಿಮೆಂಟ್ ಇದೆಯಾ?
Which pertains to a different property, not signed by my father.
Rental agreement marked as exhibit PC, it is clear that said agreement is not concerned to this petition schedule premises bearing Khata number 52/3. That is the reasoning.
Yes, my lords.
ಯಾವ್ದೋ ಬೇರೆ ಪ್ರಾಪರ್ಟಿಗೆ ಅಂತ?
Same, both are the same numbers. my
ಆಯ್ತು.
lords.
Revision petitioner counsel seeks time list this matter on 24/7.
69. R.V. Sadashivappa, Archana Murthy.
Early hearing filed. ಅಲೋ ಆಗಿಲ್ಲ ಅದು?
ಇಲ್ಲ ಹಂಗೆ.
Correspondence.
ಆಯ್ತು ಹೇಳಿ.
Landlord's petition, my lord. Filed under section 27.
27(2)(a) and R.
A and R. The same is dismissed. And therefore I am before my lord.
ರೀಸನ್ ಏನು? ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಡ್ಯೂರಲ್ ರಿಲೇಶನ್ಶಿಪ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಗಿಲ್ಲ ಅಂತ.
ಆಗಿಲ್ಲ ಅಂತ ಒಂದು.
ಏನ್ ನೀವೇನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಅದಕ್ಕೆ?
ನಾವು ನಮ್ಮ ಕ್ರಯ ಪತ್ರ ಕೊಟ್ಟಿದ್ದೇವೆ.
ಏನ?
ಕ್ರಯ ಪತ್ರ ಕೊಟ್ಟಿದ್ದೇವೆ. ಖಾತೆ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೇವೆ. ಪ್ಲಸ್ ಟ್ಯಾಕ್ಸ್ ಕೊಟ್ಟಿದ್ದೇವೆ.
ಓನರ್ಗೆ ಆಯ್ತು. ಟೆನೆಂಟ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಟೆನೆಂಟ್ ಕೊಟ್ಟೋದಕ್ಕೆ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಬಿಟ್ವೀನ್ ದಿ ಟೂ. That is marked as exhibit P10.
P10. Exhibit P10. ಕೊಡ್ರಿ ಮೇಡಮ್ ಅದೇನು? ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ 22/1/2001.
Yes.
ನೀವು 20ರಲ್ಲಿ ಪಿಟಿಷನ್ ಹಾಕಿದಿರಿ. 2001ರಿಂದ 20ರವರೆಗೆ ರೆಂಟ್ ಹೆಂಗ್ ಕೊಟ್ಟ?
And their contention is that there is an agreement to sell.
Agreement to sell.
Agreement to sell in their favor. But they have not produced that before the court.
Agreement ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
At the same time, they say it is oral agreement. Nothing has been established.
Sale agreement is oral agreement.
Not with me, with my vendors. So they have not produced that document at all before
Agreement
the
is
court.
not produced.
But in the light of exhibit P10, that is the agreement, and that is lease deed, they cannot deny the relationship and commit default in payment of rents. They are due about 4 lakhs and odd till now. Before that time also.
2001 ಇಂದ ನಿಮಗೆ ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅವರು?
ಇಲ್ಲ.
From the date of this document, why you kept quiet for a period of 20 years?
I filed a suit for ejectment. But by mistake, instead of filing it for the scheduled premises, filed for the entire property. So that was dismissed suit.
On the ground that.
Yes. Then
Description
we
is
filed
not
the
correct.
RFA before this honorable court. The RFA, we withdrew the original suit itself, stating that such a mistake has been committed and we will rectify it. This honorable court was pleased to grant liberty to us, and thereafter, since the scheduled premises is a residential premises whose rent is less than 3,500, it comes within the purview of the Rent Act. Therefore, we filed the HRC.
Evidence need no
order. Of course, I may.
But except this document of exhibit P10, no document to establish that there is a dual relationship between landlord and tenant. Except this.
No other document because.
Any admission in the evidence?
Yes, I take my lord's attention to the.
Whether they denies the signature of exhibit P10.
Yes, Your Honor.
LTM?
Yes, yes.
LTM ಅಲ್ಲ?
LTM ಅಲ್ಲ ಸ್ವಾಮಿ, ಸಿಗ್ನೇಚರ್ ಇದೆ.
LTM ಇದೆ?
ಇಲ್ಲ, LTM ಅಲ್ಲ ಸ್ವಾಮಿ, ಸಿಗ್ನೇಚರ್.
ಸಿಗ್ನೇಚರ್ ಇದೆಯಾ?
ಸಿಗ್ನೇಚರ್.
ಏನ ಕ್ಷಮ ಅಂತ ಇದೆಯಲ್ಲ ಅದ?
ಕ್ಷಮ ಅಲ್ಲ ಸ್ವಾಮಿ.
I may take my lord's.
ತೋರಿಸಿದ್ದಾರೆ.
It
has been disputed. This
Exhibit P10 was produced during the cross examination of the RW1.
RW1.
ಹೌದು.
ಹಾ.
That is tenant.
ಅದೇ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
Content ಮಾಡಿದ್ದಾರೆ.
ಹಾ.
Kindly see the schedule of the agreements one.
ಯಾವ ಅಗ್ರಿಮೆಂಟ್?
Exhibit P10.
ಇದ್ರಲ್ಲೇನೆ?
ಹೌದು.
ನನಗೂ 3 ತಿಂಗಳ ಮುಂಚಿತವಾಗಿ ತಿಳಿಸಬೇಕೆಂದು ನಾನು ಒಪ್ಪಿ ಬರೆಸಿರುತ್ತೇನೆ. ಶೆಡ್ಯೂಲ್
ಶೆಡ್ಯೂಲ್ ನೋಡಿ.
ಪೂರ್ವಕ್ಕೆ ಮಾಲೀಕರ ಸ್ವತ್ತು, ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ, ಉತ್ತರಕ್ಕೆ ಮಾಲೀಕರ ಸ್ವತ್ತು, ದಕ್ಷಿಣಕ್ಕೆ ಮಾಲೀಕರ ಸ್ವತ್ತು. ಹಾ. 3 times owner's house ಇದೆ, ರಸ್ತೆ.
Scheduled property is pertaining to 1086.
10 into 20 ವಿಸ್ತೀರ್ಣದ ಹೆಂಚಿನ ಮನೆ. ಹಾ.
1086/A.
1086/A. ಅದೆಲ್ಲಿದೆ ಆ ಡೀಟೇಲ್ಸ್?
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. Exhibit P10 ಅಲ್ಲಿ.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಹೌದು.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಏನು ಕೊಟ್ಟೆ ಇಲ್ವಲ್ರಿ?
Schedule of the Exhibit P10 ಸ್ವಾಮಿ.
P10 ಏನೇ? ಬೌಂಡ್ರಿ ಕೊಟ್ರೆ ಬಿಟ್ರೆ ಇನ್ನೇನಿಲ್ಲ 10/20 ಅಂತ.
ಅಷ್ಟೇ 10/20.
ಸೈಟ್ ನಂಬರ್ 1086/A ಅಂತಿದೆ.
ಎಕ್ಸಿಬಿಟ್ P10 ಅಲ್ಲ?
ಹೌದು.
ಮೊದಲೇ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲ?
ಹೌದು.
ಶೆಡ್ಯೂಲ್ ಅಲ್ರಿ ಅದು. ಬೆಂಗಳೂರು 22 ಯಶವಂತಪುರ SC ರಸ್ತೆ, 2ನೇ ಪೈಪ್ ರಸ್ತೆ, ರೆಸಿಡೆಂಟ್ ಹೋಟೆಲ್ ಮುಂದಿನ ರಸ್ತೆ, ಮನೆ ನಂಬರ್ 86/A ರಲ್ಲಿ ವಾಸವಾಗಿರುವ ರಾಜೇಂದ್ರ ಪ್ರಸಾದ್ ರವರ ಮಗನಾದ ಆರ್ ರಘುನಾಥ್ ಪ್ರಸಾದ್ ಬಾಡಿಗೆದಾರರಾದ ನಾನು ಒಪ್ಪಿ ಬರೆಸಿಕೊಟ್ಟ ಮನೆಯ ಬಾಡಿಗೆ ಕರಾರು ಪತ್ರ ಕ್ರಮವೆಂದರೆ
ಬಿಫೋರ್ ದಿ ಆನರಬಲ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಈಸ್ ಐ ಆಮ್ ರೆಸಿಡೆಂಟ್ ಆಫ್ ದಿ 1086 ಸೆಕೆಂಡ್ ಪೈಪ್ಲೈನ್ ಯಶವಂತಪುರ ಬೆಂಗಳೂರು. They are claiming the ownership 1086/A/2/1. Which is adjacent to the 1086.
Now we are not deciding the title of the parties, relationship between the parties is
Why I am
concerned.
telling before this honorable court is OS 108, which was filed by the earlier was dismissed for this reason only.
Not for the entire property.
Entire thing merits for dismiss ಆಗಿ they are directed to approach the declaratory suit ಹಾಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Declaratory suit ಹಾಕೊಳ್ಳಿ
ಅಂತ direct ಆಗಿ ಹೇಳ್ತಾರೆ.
That is the observation.
Yes, your Honor. For the reason he has purchased a property from some other person. Later, same property was purchased from BDA. Same property.
Here, my lord may catch him. He says he has purchased. What is the document that he has got it?
No, I am not disputing my title. I am disputing about the title of the 1086 where I am residing from 1970.
1970.
1970.
And what capacity you are residing there?
The earlier owner, Mr. Ram Singh Thakur was the owner. My the time of entering the premises in 1960, I was minor. Respondent was minor. ಅವಾಗ ಏನಾಗಿತ್ತು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಂತಂದ್ರೆ ಸೇಲ್ ಡೀಡ್
ಮೈನರ್ ಪರವಾಗಿ ಯಾರು ಅವಾಗ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರು?
ಅವ್ರು ನಮ್ಮ ತಂದೆಯವರು ಇದ್ರು, ನಮ್ಮ ತಂದೆಯವರು ಎಲ್ಲ ವ್ಯವಹಾರ ಮಾಡಿದ್ರು, ಪೇಮೆಂಟ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರು. ಡ್ಯೂರಿಂಗ್ ದಟ್ ಟೈಮ್ ಅದೇನಾಯ್ತೇನೋ ರಾಮ್ ಸಿಂಗ್ ಠಾಕೂರ್ ಅವರು ಓಡೋಗ್ಬಿಟ್ರು, ಇದುವರೆಗೂ ಸಿಕ್ಕಿಲ್ಲ. That is the main contention before the honorable trial court.
According to you, the property belongs to Ram
Singh Thakur.
Ram Singh Thakur.
The property which they have purchased.
ನಿಮ್ ತಂದೆ ಯಾವ ಕೆಪಾಸಿಟಿ ಮೇಲೆ ಆ ಮನೆಗೆ ಬಂದ್ರು?
ಅವಾಗ ಅವ್ರದ್ದು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಏನೋ ಮಾಡಿದಂತೆ ಸ್ವಾಮಿ, ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಕಾಪಿ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ. That is the reason. The property which they are claiming is adjacent to my property. It is admitted fact in the evidence. 10686 is in the north side of my schedule ಅಂತ ಒಪ್ಕೊಳ್ತಾರೆ ಸ್ವಾಮಿ. It is a small property. 50 into 30.
ಆಯ್ತು ನೋಡೋಣ, ಅವ್ರು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಲಿ ಕೋರ್ಟ್. ಆಯ್ತು, PW1 ಹೇಳಿ.
Please, my lord.
ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನು ಆನ್ಸರ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ ನೋಡಿ.
My lord may kindly take cross examination.
Regarding cross examination of DW1, any answer is elicited regarding
Yes,
tenancy is concerned?
I am just taking my lord's attention to that.
RW1 na?
Yes. I know reading and writing of Kannada language. I can read English language also, but not so comfortable. I used to sign in English language. For more than 50 years, I have been staying in petition scheduled premises. During my childhood, my parents came in possession of the petition scheduled premises in the year 1970. They came in possession of the property as a purchasers at the time. At that time, Raghunath Singh was the owner of the property. Just a minute. I have not seen the title deeds of Raghunath Singh. In this case, I have taken contention that we are the owner of petition scheduled premises. I have no document to show that I am the owner of the petition scheduled premises. It is true to suggest that the objection to main petition bears my signature. The wakalat shown to me bears my signature. Same is marked as Exhibit P9, and signature of the witness is marked as Exhibit P9A. I have not executed any rental agreement with reference to the petition scheduled premises, as I am the tenant in the petition scheduled premises. I read it once again. I have not executed any rental agreement with reference to the petition scheduled premises, as I am the tenant in the petition scheduled premises. Here he claims ownership. Now he claims he is the tenant.
No. He is not claiming any tenant. I have not executed any rental agreement with reference to the petition scheduled premises, as I am the tenant in the petition scheduled. ನಾನು ಟೆನೆಂಟ್ ಅಂತ ಯಾವ ದಾಖಲೆನೂ ಬರ್ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ. ರೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರ ಇದು.
The document shown to me does not bear my signature. For the purpose of identification of the document shown
is marked as Exhibit P10.
Witness, document is marked as Exhibit P10. Signature shown to the witness as signature is only for the purpose of identification of the signature shown to the witness is marked as Exhibit P10A and B on both the pages. It is incorrect to suggest that I have executed rental agreement in favor of Rajamma and Lakshmikant, who are the vendors of the petitioners. My vendors are Lakshmikant and Srimati Rajamma. I have verified the documents produced by the petitioners in this case. I do not know petitioners have purchased the petition scheduled premises from Rajamma and Lakshmikant on 22/1/2005. I do not know if petition scheduled premises standing in the name of the petitioners as per Khata certificate and Khata extract. I have not verified Exhibit P3 and 4. I do not know if petitioners have paid the tax of the petition scheduled premises and they have produced Exhibit P5. It is true to suggest that either in the Khata certificate or in the Khata extract of the petition scheduled premises, my name or my father's name not mentioned as owners. It is incorrect to suggest that the adjacent to the petition scheduled premises shops are there. I do not know if petitioners have purchased the house in my occupation along with 4 shops adjacent to the petition scheduled premises. I do not know if Jamir is in possession of shop premises adjacent to the petition scheduled premises in the same building. For the suggestion that in the said building in one portion, Ifran is carrying on business, witness answered that not in the same building but in the different building. I do not know if Ahmad is carrying on the business in 2 shops. For the suggestion that you are staying in the petition scheduled premises, witness answered that he is staying in door number 1086, Second Pipeline Road, Yeshwantpur Circle, Bangalore. The measurement to the property in occupation is 15 by 20 feet. For the question that what is there towards the eastern side of property in your occupation, he do not know as he is unable to identify the direction. I am unable to say the property situated towards sunrise and sunset. My house is facing towards the Second Pipeline Road. It is incorrect to suggest that even though I can very well identify the directions, intentionally I am deposing falsely. In front of house in my possession, after the road, Thakur Singh building is situated towards the left side of my house. Thakur Singh building is situated right side. Shiva Singh building is situated. I have not disclosed above said boundaries in the proceedings. The entire property bearing number 1086, measuring 15 by 20. I do not know if the entire premises bears 1086 is measuring 40 feet into 50.3 inches. There is no nexus between petition scheduled premises and the property in my occupation. I do not know if I am possession of one portion in the property bearing number 1086. I do not know after purchase of the property by the petitioners, corporation in 2 bits, the corporation has given new number as 1086/A-2-1. My father has entered into oral agreement with Raghunath Singh I do not know what is the nature of agreement as I was minor. My father informed me that he has purchased the house. I do not know whether Raghunath Singh has executed any sale deed in favor of my father and mother. He has not executed any sale deed in my favor. It is true to suggest that either my father during his lifetime or mother or myself have not filed any suit for specific performance of the contract against Raghunath Singh. I do not know whether my father has paid rupees 35,000 to Raghunath Singh. It is their case 35,000 is paid towards the agreement to sell. It is incorrect to suggest that I am in possession of the petition scheduled premises as a tenant on a monthly rent of rupees 2,300. It is incorrect to suggest that I am executed rental agreement agreeing to pay monthly rent of 1,800 per month. Enhancement at rate of 5% per year. It is incorrect to suggest that I am deposing falsely for the suggestion that whether Raghunath Singh has inducted your father as a tenant. Witness answered that I do not know. I do not know if towards the east, north, south remaining property of petitioners is situated around the property in my possession. I do not know that. I do not know if these properties are owned by a petitioner and in western side there is a road. It is true to suggest that the present petitioners have filed OS number 1823 of 2009 in file of the City Civil Court, Bangalore. It is true to suggest that again the dismissal judgment passed by the City Civil Court, Bangalore, petitioners have referred appeal in RFA 1249 of 2015 on the file of the Honorable High Court of Karnataka. I do not know if suit OS number 1823 of 2009 was withdrawn with permission of the Honorable High Court of Karnataka in RFA 1249 of 2015. It is true to suggest that after withdrawal of the suit, this petition was filed. So the suit itself he denies, though he is a participant in the suit. And even in the RFA also he is a party. And I have produced the order copy of this honorable court. I may invite my lord's attention to that. Exhibit P6, please. IA 1 of 2009 was filed for early hearing, is not pressed. Hence, IA number 1 of 2009 is rejected. An application IA number 1 of 2020 is filed by the appellants seeking permission to withdraw the suit filed by them in OS number 1823 of 2009 on the file of this 12th additional city civil judge so-and-so on the ground that there is a formal defect in filing the suit. The appellants have sought for liberty to file fresh suit on the same cause of action. The appellants are permitted to withdraw the suit. Insofar as liberty sought for filing fresh suit on the same cause of action, such liberty cannot be granted as the appellant themselves claim that the formal defect was that the notice of termination under 106 of the Transfer of Property Act was issued in respect of the entire building, though ejectment was sought only in respect of a portion. However, the appellants are at liberty to take fresh steps, including termination of tenancy, and then launch a fresh suit on the fresh cause of action. After this, my lord, the present case is filed because there is no question of filing another suit because the provisions of the Rent Control Act, the Rent Act attracts. In the light of his cross-examination, saying for every question, I do not know, I cannot read this, that, and all that, how does he overcome Exhibit P10 executed by his father? Because he is not the tenant, his father was the tenant, he died, and therefore the children, wife and children are before the court.
According to you, father of the respondent had executed this document.
Because he was the tenant.
Father ಅಲ್ಲ
No, father ಅಲ್ಲ. Sorry, ಇವರು ಅವರಿಗೆ ಅರ್ಲಿಯರ್ ಓನರ್ಗೆ
ಎಸ್ ಲಕ್ಷ್ಮೀಕಾಂತ ಮತ್ತು ಶ್ರೀಮತಿ ರಾಜಮ್ಮನವರಿಗೆ ಅಂತಿದೆ.
They are earlier vendors of the petitioners.
ರಘುನಾಥ್ ಪ್ರಸಾದ್ ಬರ್ಕೊಟ್ರ ರಘುನಾಥ್ ಪ್ರಸಾದ್ ಯಾರು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಏನಾ? ನಾಟ್ ಫಾದರ್. Why you did not produce this document exhibit P10 before the original suit?
As on that day, my lord,
Ah.
we had no such knowledge. Then we approved the vendors
Hmm.
because he started denying the relationship.
Hmm.
Then they said, we have got some document,
Hmm.
we'll search and give.
Hmm.
So at a later stage, they were able to give us,
Hmm.
and therefore we have produced before the court.
Hmm.
And in
ಇದೇ ಸಿಗ್ನೇಚರ್ ಇದು ಮತ್ತೆ ಇದು ಮತ್ತೆ ಇದು ಇದು ಎಕ್ಸಿಬಿಟ್ P10 ಇದು ಎಕ್ಸಿಬಿಟ್ P9 ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತೆಗೆದು ಗೊತ್ತಾಗುತ್ತೆ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡಕ್ಕೆ
I would like to make the submissions. Kindly produce the exhibit R6 one.
Exhibit R6 sir.
Yes, sir.
R6 huh.
It is an order by development Bengaluru Development Authority.
Hmm.
I would like to read. ಶ್ರೀಮತಿ ಶಶಿಕಲಾ ಮತ್ತು ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮೀ ಅವರು ಬೆಂಗಳೂರು ನಗರ ಗುರುಕುಲ 1ನೇ ಹಂತ 4ನೇ ಫೇಸ್ ನಿವೇಶನ 1086/A ಅನ್ನು 1086/A1 A2 ಮತ್ತು A2 ಆಗಿ ಮಂಜೂರು ಮಾಡಲು ಕೋರಿರುತ್ತಾರೆ. My contention before the trial court is they have not purchased the 1086. They have purchased the property 1086/A. And he is not the owner of the property based on the sale deeds 1086/A. That is my contention before the honorable trial court. When he is not the owner of the property, there is no question of executing the rent agreement with the petitioner's firm as per the exhibit P10. And in the notice issued by the petitioner, cause of action ಬಗ್ಗೆ ಏನು ಹೇಳೋದಿಲ್ಲ. ಏನು ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಹಿಂಗ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಅದ್ರ ಪ್ರಕಾರ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಖಾಲಿ ಮಾಡಿ ಅಂತಾರೆ.
ಕ್ರಾಸ್ ಅಲ್ಲಿ ಏನಾರು ಇದೆಯಾ PW1 ನೀವೇನಾರು ಹೇಳೋದು
ಹೇಳ್ಬಿಡ್ತೀವಿ
ಏನಾರು ರಿಲೀಸೆಟ್ ಮಾಡಿಸಿದೀರಾ?
ಮಾಡ್ಸಿದ್ದೀವಿ
ಹೇಳಿ.
Class examination dated 24/3/2021. 24/3/2021. The petition should have premises fee was purchased in the year of 2004 or 2005 in the month of February. In the names of in these names ಅಂತ ಹೇಳ್ತಾರೆ. If it is suggested that the respondent is residing 1086 second class pipeline Yeshwanthpura, I state that residing in 1086/A2(1) ಅಂತ ಹೇಳ್ತಾರೆ. Then he denies the suit filed before the honorable civil court. I do not know why OS number 102/1823/2000 was filed against the respondent. I have given evidence. It is true that the said case was dismissed, stating that he is not the owner of the property. I think he is denied that one. I have produced a certified copy of the notice issued in the OS numbers one, OS number 1823/2009, which has been marked as exhibit R1. It is true that I have issued a legal notice to respondent on 28/12/2008, and the respondent has given a reply to said legal notice. Now I see the certified copies of the said legal notice and the reply notice and have identified the same. The certified copy of the legal notice now marked as exhibit R1, and it is true that the said legal notice was mentioned in the address as 1086 second pipeline Yeshwanthpura, Bengaluru. The measurement of the petition schedule property is 15/20. In respect of sale deed which is purchased in the name of Srimati Shashikala, the description of the property towards the north is 1086 is mentioned. I am residing in the 1086 one, not in the property as purchased by the petitioners. That is the main contention before the trial court one. It is, further, the property was purchased from Lakshmikant and Rajamma. At the time of sale of the said property, the vendor had introduced respondent as their tenant. It is false to suggest that the property which Lakshmikant and Rajamma have sold to me was allotted to them by the BDA. It is true that I have produced a transfer agreement executed by the BDA in the name of Lakshmikanta and Rajamma in OS number 23. Now I see the certified copy of the said transfer agreement, which has been marked as Exhibit R3. Then I will kindly peruse the R3 one. Transfer agreement. Exhibit R3. 1st July 1987, they have entered into a sale agreement with BDA. And kindly see the schedule of the said agreement. Exhibit R3. Next page alli our schedule ide. Site number 1086/A, formed by the Bengaluru Development Authority, Bangalore, first stage, 4th phase, Gokula extension. It is entirely different. They are claiming the right over the property, which they are not the owners of the property. Furthermore, this transfer agreement, as discussed in OS number 1823/2009, does not have a legal certitude. This one. It is just like a sale agreement. Based on the sale agreement, the petitioner have purchased the property by executing the sale deed. You would get sale deed agilla from BDA.
Yes, sir.
It is true to suggest that in Exhibit R3, property number is mentioned as Exhibit 1086A in the schedule. In the bond, its north side is shown as Exhibit 1086. The document shown to me is certificate copy of the sale deed produced by me in OS number 1823/2000, and same is marked as Exhibit R4. It is true to say that Exhibit R4 property number is mentioned as 1086/A/21. The document shown to me is sale deed dated 18th 1982, which was produced by me in OS number 1823/2000. Same is marked as Exhibit R5. It is in respect of the R5 is in respect of the property which said to have been allotted to one NV Bhatt. Son of Narayan Bhatt, wherein the schedule has been mentioned as 1086/A/2.
One bar 86 of my lord is the correct number for the whole property. When it was purchased in 2 bits under 2 sale deeds, they have bifurcated.
That's what as
That's all.
exhibit
Beyond that, there
R3
is
has
no
been
dispute
mentioned.
at all. And
R6
all
was in a particular one here.
other 4 shops are also
Document nim title deed, sale deed.
num seal.
Then he relies upon transfer document. Transfer document ಅಲ್ಲಿ 1086/A ಇದೆ.
ಹೌದು. Same
ಹೌದು.
property was
ಅಲ್ಲ,
purchased.
ಈ ಬೈಫರ್ಕೇಶನ್ ಮಾಡಿದಾಗ A1, A2 ಇವೆಲ್ಲ ನಡೆದಿದೆ.
ಆಯ್ತು.
1086 is the main
title deed ಯಾವುದು ಅಂತ ಕೇಳಿದೆ.
sale deed, my lord. My lord,
P2 ನಾ?
one ನಿಮಿಷ. 22/1/2005, exhibit P2.
rental agreement 2001 ಅಂದ್ರೆ ನಮ್ಮ previous purchaser, ನಮ್ಮ previous vendor.
And the rental agreement which is produced at exhibit P10 is of the year 2001. Property number as such is the same, 1086.
Kindly produce exhibit P2, Swami. Schedule ಅಲ್ಲಿ 1086 bar A, bar 2, bar 1 ಅಂತಾನೆ ಮೆನ್ಷನ್ ಆಗಿದೆ. After that one, a sale deed is there, exhibit which is not has been marked as exhibit, Swami. 22/1/2005 ಇನ್ನೊಂದು sale deed ಇದೆ. In the name of Shashikala, Srimati Shashikala.
Both are sisters. Both are parties here and both are sisters.
Kindly see the schedule, Swami. 1086 bar 2 1 A bar 2 bar 1. In the schedule, ಪೂರ್ವಕ್ಕೆ ರಸ್ತೆ, ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ, ಉತ್ತರಕ್ಕೆ 1086 ನಂಬರ್ ಸುತ್ತ ಇರುತ್ತದೆ. Even they have produced the entire sketch, building construction ಮಾಡಕ್ಕೆ approved plan ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. Approved plan is also mentioned. So north ಅಲ್ಲಿ 1086 ಅಂತಾನೆ ಮೆನ್ಷನ್ ಆಗಿದೆ. Building has been constructed over there in their properties, not in this property. It is a small house. ತುಂಬಾ ಹಳೆ ಮನೆ ಸ್ವಾಮಿ ಇದು.
Portion, this is only a portion, as I submitted to my lord, this is only a portion. There are other 4 shops also. Kindly see that the schedule that is given to exhibit P10, ಉತ್ತರಕ್ಕೆ ಪೂರ್ವಕ್ಕೆ ಮಾಲೀಕರ ಸ್ವತ್ತು, ಉತ್ತರಕ್ಕೆ ಮಾಲೀಕರ ಸ್ವತ್ತು.
ಆಯ್ತು, all the 3 sides ಮಾಲೀಕರ ಸ್ವತ್ತು.
Yes, all the 4 sides, 3 sides, 1 side road.
Have you examined any witnesses in respect of exhibit P10?
No, neither I have examined nor he has examined. No, we are not examining.
ಮತ್ತೆ ಸತ್ತೋಗ್ಬಿಟ್ರು. He died. The person is exhibited. He has died. So ಹಂಗಾಗಿ
I would like to produce one sketch, Swami.
ಕೊಡಿ. ಬೇರೆ ಕೋಟಲ್ ಮಾರ್ಕ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಅದು ಮೆಮೋ ಜೊತೆಲಿ ಕೊಟ್ಟಿದ್ದೆ ಅಲ್ಲಿ, ಮೆಮೋ ಜೊತೆಲಿ ಕೊಟ್ಟಿದ್ದೆ at the time of argument. ಅದರಲ್ಲಿ the entire property.
What is it?
Sketch ಕಾಪಿ ಇಲ್ಲ, ನೋಡ್ತೀನಿ.
86A2, 86A1.
ಅದರಲ್ಲಿ ನಾರ್ತ್ ಸೈಡ್ ನೋಡಿ ಸ್ವಾಮಿ, 1086. Where I am residing in the property. ಆ ಸ್ಕೆಚ್ ಅಲ್ಲೇ ಗೊತ್ತಾಗುತ್ತೆ the entire property was built up now, which belongs to petitioner. Not in 1086.
To say that it belongs to him, he has not placed any material before the court. To say that he is a owner of the property or otherwise.
Order reserved.
Please.
70.
Mohan Kumar T.
Macha.
Yeah, Prashant.
About the appellant.
Responding.
ಇಲ್ಲಲ್ಲ.
Submission. I'll go through the trial court records now once because I've not gone through. I'll go through once. As per the judgment, I'm ready, my lord. Yesterday, as I submitted, my lord, the same thing, my lord. They have produced the documents. Based on that documents only, the court has enhanced the compensation. But once I will go through the trial court records, there is anything.
ಏನು ಪಾಸ್ ಓವರ್ ಮಾಡಬೇಕು ಈಗ?
Pass over ಬೇಡ ಸ್ವಾಮಿ. ಮತ್ತೆ
ಆಟೋ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್, ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಪ್ರೆಸೆಂಟ್. ಎಜೆ ನೀವು ಇದ್ದೀರಾ? ಓನ್ಲಿ ಫಾರ್ಮಲ್ ಪಾರ್ಟಿನಾ ನೀವು? ಆಯ್ತು. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವತ್ ಬೇಕು, ಯಾವತ್ ನೋಡ್ತೀರಿ?
21st or 22nd. ಅವ್ರಿಗೂ ಕೇಳಿದೀನಿ ರೆಕಾರ್ಡ್ಸ್ ಆಗುತ್ತೆ.
ಯಾರಿಗೆ?
ನಮ್ಮ
21/7.
Please.
71 and 72. Pure Kerala.
Have been taken, my lord. On the last date, my lord, matter was admitted. Notice was issued. Steps have been taken.
Notice to R2 for first time. Notice ಸರ್ವಾಗಿಲ್ವಾ?
ಇಲ್ಲ, steps ತಗೊಂಡಿದ್ದೀವಿ. ಆಮೇಲೆ ಪೇಪರ್ ಬುಕ್ ಇನ್ನೊಂದು
Avoiding of both CRs, madam.
Paperwork, my lords, in 2 days I will file it, my lords.
Appellant counsel submits that is going to file paperwork within 2 days.
Please.
ಏನ್ ನೋಟಿಸ್ ಹೋಗಿದೆ ಏನಾಗಿದೆ ಮೇಡಮ್ ಅವೈಟ ಏನಂತ
Steps
ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಪಿ ಎಫ್ ಅಂತ ಇದೆಯಲ್ರಿ
ತಗೊಂಡಿದ್ದೀವಿ, steps ತಗೊಂಡಿದ್ದೀವಿ.
ಯಾವಾಗ
ಇವತ್ತು ತಗೊಂಡು.
ಇವತ್ತ ಮತ್ ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಬೇಕಲ್ಲ ಈಗ ಇದುವರೆಗೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ನೀವು
ಅಲ್ಲ, ಮೊನ್ನೆ ಅಡ್ಮಿಟ್ ಆಗಿ ನೋಟಿಸ್ ಮಾಡಿದ್ದಷ್ಟೇ.
ಅಡ್ಮಿಟ್ ಆಗಿದ್ದು ಯಾವಾಗ
ಲಾಸ್ಟ್ ಡೇಟ್
23/6
Last
Start
order
date
appeared on
ಹಾಕ್ಕೊಟ್ರಿ?
21.
ಸ್ಟಾರ್ಟ್ ಡೇಟ್ ಹಾಕಿ ಕೊಟ್ರಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆದ್ರೆ
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಒಂದು ಅಪೀಲ್ ಆಲ್ರೆಡಿ ಮುಂಚೆ ಅಡ್ಮಿಟ್ ಆಗಿತ್ತು.
21 ಅಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದು ಒಂದು.
ಹ್ಮ್
ಬೇರೆ ಅಪೀಲ್ಸ್ ಗಳ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆಗ್ತದೆ.
ಅಲ್ಲ ಆಯ್ತು ಅದ್ರಲ್ಲೂ ಕೂಡ ಪಿ ಎಫ್ ಕೊಟ್ಟಿಲ್ವಾ
ಅದ್ರಲ್ಲಿ ಆಲ್ರೆಡಿ ಸರ್ವಿಸ್ ಆಗಿದೆ.
7 ಅದು ಕೂಡ
ಅಲ್ಲ, ಒಟ್ಟು 3 ಅಪೀಲ್ ಮೊನ್ನೆ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಒಂದು ಅಪೀಲ್ ಮಾತ್ರ ಮುಂಚೆನೆ ಅಡ್ಮಿಟ್ ಆಗಿತ್ತು. ಅದ್ರಲ್ಲಿ
ಯಾವ್ದ್ರಲ್ಲಿ ಜಾರಿ ಆಗಿದೆ ಹೇಳಿ
ಒಂದರಲ್ಲಿ ಮಾತ್ರ
ಜಾರಿ ಆಗಿಲ್ಲ
ಒಂದರಲ್ಲಿ ಮಾತ್ರ ಆಗಿದೆ.
ಒಂದ್ರಲ್ಲೂ ಆಗಿಲ್ಲ ಯಾವ್ದ್ರಲ್ಲೂ ಆಗಿದೆ ಎಲ್ಲ ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಪಿ ಎಫ್ ಅಂತಲ್ಲ ಇದೆ ನೋಡ್ರಿ
ಲಾಸ್ಟ್ ಒನ್ ಆಗಿದೆ.
72.3 ನಲ್ಲಿ ಮಾತ್ರ ಆಗಿದೆ.
3 ಅಲ್ಲಿ ಆಗಿದೆ. 72.3
ಆಗಿದೆಯಾ
that was the one, my lords, initially which was admitted.
ನಾನ್ ಫೈಲಿಂಗ್ ಪೇಪರ್ ಬುಕ್ ಅಂತ
ಅದ್ರಲ್ಲಿ 2 ದಿನದಲ್ಲಿ ಆಗ್ತದೆ.
ಆಯ್ತು ಬಟ್ ಬೇರೆದ್ರಲ್ಲೆಲ್ಲ ಯಾಕೆ ಪಿ ಎಫ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದೆ ಈಗ ಮೊನ್ನೆ ಆಗಿರೋದು
ಮೊನ್ನೆ ಆಗಿದೆ.
ಯಾವಾಗ ಇವತ್ತು ಕೊಟ್ರ
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಕಟ್ಟಿದ್ದೀವಿ.
Appellant counsel submits that PF paid in all the matters. Hence issue notice against R2 in RSA 37 of 22 and issue notice to R2 to R7 in RSA 1200 of 21 and also issue notice to R2 to R9 in RSA 1205 of 21. List these matters on. Yadar one date kalkotri?
Sir, 11/8.
11/8.
Please.
73 A Madhusudan Rao.
Here for the respondent, man.
This is the case in which whether the illegitimate son is also entitled for the share in the ancillary property or not. In the earlier occasion also it was argued.
Matter already admitted on IA is filed for TI and matter may be considered on merits. List the matter for final hearing. ಆಯ್ತು ಎಲ್ಲೋದ್ರು ಅವ್ರು ಯಾರು ಮಧುಸೂದನ್ ರಾವ್ ಎ ಮಧುಸೂದನ್ ರಾವ್ ಇಲ್ವಾ
ಇಲ್ಲ ಸರ್.
Concurrent finding with the both the courts below, my lord. 1/3 share given to the appellant.
ಯಾವ 23/6 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು ಬನ್ರಿ ಏನು
This matter may be kindly have it on next week, my lads.
ಯಾಕ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೇ ಮೆರಿಟ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಐಎ ಕ್ಯಾನ್ ನೀಡ್ ನಾಟ್ ನೆಸೆಸರಿ ಅಂತ ಹೇಳಿದಿರಿ.
Senior is arguing on parted matter, my lads. On parted matter ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ. Next Monday or Tuesday, my lads.
ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಎಲ್ಲ ತುಂಬಾ ಇದೆ. ನಾವೆಲ್ಲ ಒಂದೊಂದ್ ದಿವಸ ಒಂದೊಂದು ಡೇಟ್ ಅಂತ ಕೊಡ್ತೀವಿ. Appellant counsel seeks time counsel for the respondent. Present list this matter ಯಾವ್ದಾದ್ರು ಕಡಿಮೆ ಇದ್ರೆ ಕೊಡಿ ಮೇಡಮ್ ನೋಡಿ. 22/7.
74 K Srihari. Venkatesh Hechan.
Maybe for the respondent.
For the appellant, my lord, seniors on his legs, my lord. I'm seeking for a short adjournment, my lord.
He will be on legs only. Everyone is on legs only, including me.
Concurrent findings of the court below, my lord.
I don't understand what submission you made. Senior is on
That's he's
his
in
legs
another
ಅಂದ್ರೆ?
court, my lord. He's hearing in another
That you have
court.
to make submission.
Sorry, my lord.
ಹೇಳ್ರಿ ಏನು?
But concurrent findings of.
Concurrent finding. Whether is coming now?
My lord, my lord, a short date may be given, my lord.
Last time order sheet ಕೊಡಿ ಮೇಡಮ್. Want of time.
ಅದ್ರ previous hearing next time ಮಾಡ್ತೀನಿ ಅಂತ time ತಗೊಂಡ್ರು ಅವರೇ.
ಈಗ ಅವರೇ ಇಲ್ವಾ? ತೊಗೊಳ್ಳಿ. Appellant counsel seeks time counsel for respondent present. Discuss matter on ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಇದ್ರೆ ಕೊಡಿ ಮೇಡಮ್. ಶಾರ್ಟ್ ಡೇಟ್ ಗಳಿದ್ರೆ ಕೊಡ್ರಿ.
17th or
17/7 ಆಯ್ತು ನೋಡೋಣ ರೀಚ್ ಆಗುತ್ತೆ ಇಲ್ಲ ಅವತ್ತು.
Obliged.
RSA ಉತ್ತಣ.
Lord, I may be permitted to file objections.
ಯಾವ್ದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಐಯಾಗ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತಾ ಇದ್ದೀರಾ?
ಅದೇ ಅವರು ಐಎ ಹಾಕಿ
ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ ಮೇಡಮ್. Statement of objections filed by the respondent counsel on IA number?
On IA number 2.
2 ನಾ? 2 ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಅದೇ ಇದರಲ್ಲಿ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಡಿಷನಲ್
1 of 25 ಇದೆ. 1 of 24 ಇದೆ. ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ಈಗ?
ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್.
IA 1 of 25 ಆಗರ. IA 1 of 25. ಕಾಪೀಸ್ ಕೊಟ್ರಾ?
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಆಯ್ತು. ಕಾಪಿ is also served on the other side. Next.
75.
I appear for the appellant, my lord.
Yes,
on 3
counsel,
cases.
Other side served and unrepresented,
They are represented from the beginning. Nobody has come.
all the cases. Aye, head.
My lord, this is the regarding, my lord, all the three cases, my lord. They are the stationery suppliers to the bank. And without supplying the stationeries, the official who was in charge of this branch, my lord, he has.
I only admitted this appeals.
ಅದು ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. ಇದು ಇವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್, ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕಾಣುತ್ತೆ.
Records ಬಂದಿದೆಯಾ ಮೇಡಮ್?
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಕಾಣುತ್ತೆ. ಅದ್ರ ಒಂದೇ ಒಂದು ಇಶ್ಯೂ, ಮೈ ಲಾರ್ಡ್, ದಟ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಇಸ್ ವೆದರ್ ದೇರ್ ವಾಸ್ ಎನಿ collusion between the parties.
But allegation is that with the collusion, all these documents are created anta.
ಅಲ್ಲ, some documents forged, some documents are inflated, some documents are bogus. These three categories, my lord. And that official who was involved in this, he has been issued charge sheet and he was dismissed from service of the bank for forgery, inflated bill and all those things. Then he approached that industrial tribunal, CJT. There also they concurred the findings. And now that person has not entered the box at all in all these cases. That one. Then these people, that number one case, my lord, that Satish Naik, that is 1792. He has admitted. Letter was sent to him. He says admitted, I will give, and he has not given the money. And number two also, he is closely related to the that employee. That is respondent number one in trial court, Mr. Umesh Pai. He is his sister and this person's sister. They are sisters, co-brother. And like that, another case also, my lord, that Prabhu papers. They are also that close relatives. So all the three cases, they are all close relatives of Mr. Umesh Pai. And this entire thing has been proved, my lord, that trial court has clearly explained, my lord, that how this all these persons they are colluded and how much loss caused to the bank. In the first case, they caused that 1792 that he has to pay 1,25,710.
1,25,710. In first case.
First case. Second case, mine RSA 1794. He has to give 87,699.
87,699.
And third case 1795, my lord, he has to give 1,28,514. Total there were 7 cases. Out of 7 cases, 4 cases declared and they paid the entire amount and matter was closed. And these 3 people only they preferred the appeal and they are before this appellate. They before the preferred the appeal, my lord. The appellate authority, my lord, only 2 questions he raised. One is that forgery, that is whether because there is a charge of forgery where the documents were not referred to handwriting expert, number 1.
Appellate court reversed the same.
Appellate court in these 3 cases, they say that no, that because these people that documents are not that forgery and all, it is not established. Number 2, one important, my lord, that whether that stationeries were delivered or not, they have not produced. In fact, bank produced 1,081 documents. All the vouchers have produced. That stationery, that person has to produce it because whether that he should have the receipt for having delivered the receipt. That is what the contention. That is what the reason mentioned in the trial court. Because that whether it is produced or not, now if he has produced, then he has bank will give an acknowledgement that he has to produce, that I have produced. But all these persons they have agreed. Second person also in the order it is clearly mentioned, he has agreed.
Go to the reasoning of first appellate court.
Appellate court, my lord. Appellate court.
Reason for reversing the finding of transfer.
Yes, my lord. Page number
first
30,
case
35.
All
the case, all one judgment.
Common judgment.
Common judgment, my lord.
Common judgment.
Common
Yes.
judgment. All 7 cases, common judgment. Here, first case, my lord. First case is 1792. Syndicate Bank versus Satish Naik.
1792.
Yes, my lord.
1792 ಕೊಡಿ ಮೇಡಮ್. 94 ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ನೀವು.
OS 61. Page number 35. As point number 1 and 2 are interrelated, they are taken together for discussion at the same time to avoid repetition. The specific contention of the plaintiff bank is that through its SRD branch, it was getting required stationery printed through the printers, namely defendant number 2, in all the cases by placing work orders and also supplying white paper. The printers, namely the defendant number 2 in all the suits, after printing and supplying the stationery at the SRD section of the plaintiff bank, used to raise bill and submit vouchers and amount vouchers, and the amount would be credited to their account. Through its internal inspection, the plaintiff came to know about the fraud committed by the defendant number 1 and 2. One is that employee of the bank, in collusion with each other regarding submitting the false vouchers, forging the documents regarding the printing of stationery and supplying without actually doing so, and caused loss to the plaintiff bank. The plaintiff bank had categorically contended that defendant number 1 and 2 in collusion with each have caused loss to the plaintiff bank. As such, the plaintiff bank got issued notice to defendant number 2 in all the suits. But as the defendant number 2 in all the suits have failed to pay the amount received by them illegally in collusion with the defendant number 1, the plaintiff has constrained to file the suit. In this case, no doubt the plaintiff bank had examined PW 1 to 3 to prove its case and marked documents as many as 1087, namely bills and relevant vouchers. No doubt the said vouchers and bills produced by the plaintiff bank goes to show that the defendant number 2 printers have submitted bills seeking payment as regards the stationery printed by them. Further, they also disclose that the said amount of bills were paid to them by way of account transfer. The court is of the opinion that the plaintiff bank had categorically contended that the collusion with the defendant 1, its employee, and defendant number 2 in all the suits have cheated plaintiff bank by playing fraud and misrepresentation. But this court is of the opinion that PW1 in the chief examination dated 66/2006 had marked documents pertaining to OS number 61/2002, exhibit P1 to P17. As regards OS 7/99, documents at exhibit P18 and 31, and OS number 171/98, relevant documents are marked at exhibit 32 to 45. The perusal of exhibit P1 to 45 in all these three suits goes to show that though the plaintiff bank had contended that bills or vouchers produced by the defendant number 1 and 2 to recover the amount are bogus, are created without there being work orders from the plaintiff. But this court is of the opinion that whenever forgery is pleaded, the same needs to be proved by the plaintiff bank. But first of all, the plaintiff bank had not made any effort to seek opinion of the expert by sending documents examination and report to the handwriting expert regarding the signatures. Nowhere in the plaint or in the deposition of PW3, it is specifically contended that those signatures are forged by the defendant 1 and 2 in collusion with each other in all the suits. Further, this court is of the opinion that PW1 in his cross-examination dated 16/10/2008 had categorically admitted that their head office SRD section was having a go down and an offer is in charge of the same. The SRD section of the plaintiff bank is maintaining its stock register. The stock register is maintained regarding the issuance of the paper to the respective printers. There is also mention of the stock register regarding the item received from the printer after stationery was printed. It is also admitted that along with the stationery items bill, delivery memo would be received by the SRD section by the bank. It is also admitted that after receipt of the goods or stationery, initial will be put on the delivery note and it will be sent to the payment. Then after verifying the delivery note and bill vouchers would be prepared in the bank. Further, PW1 has admitted that the bank is having records to show that which stationery is delivered to which section of the bank. Further, it is admitted that balance of the stock of stationery is mentioned at the end of every month. It is also admitted that record is also maintained regarding the expense of annual printing stationery. Further, it is admitted by PW1 that quotations submitted by the printer are maintained by the plaintiff bank. Further, PW1 has categorically admitted that while preparing and signing the voucher, the officer concerned will inspect the print order. Further, it is admitted that the person who issues the print order will check and put the signature to the same. But PW1 had categorically admitted in the cross-examination that he does not know who had signed the bill. Further, PW1 had admitted that he does not remember the other stationery shown in the print order was received in the godown or not, and he has not verified the stock register regarding the same. He has also inspected the delivery note and tallied with the stock. The court is of the opinion that the above categorical admits of PW1 forces this court to draw an inference that the plaintiff bank had maintained stock register regarding stock or stationery received from the printer. It is also admitted that item-wise stock register is maintained by the plaintiff bank, though the plaintiff bank had marked documents exhibit P1 to P1087, but the plaintiff bank had failed to produce a stock register to show that the bank has not received any stock or stationery printed from any of the defendants of the above suit, but the amount is paid to them by account transfer. This court is of the considered opinion that the plaintiff bank categorically contends and without printing and supplying the stationery to defendant number 2 in collusion with the defendant number 1 had received money and made wrongful gain. But the burden is on the plaintiff bank to prove the case, and without issuing a print order and without printing the stationery, only false bills were submitted by the defendant number 2. Further, court is of the opinion that the plaintiff bank had failed to prove that the collusion with the defendant number 1 and defendant number 2 made wrongful gain, causing loss to the bank. Further, this court is of the opinion that the plaintiff bank had much harped on the letters said to have been submitted by the defendant number 2, admitting their liability regarding furnishing the false vouchers and bills to make unlawful gain. But the defendants have categorically contended in their respective written statements that their signatures were obtained by the plaintiff bank on the condition that it is required by the plaintiff for the police investigation. The defendant number 2 had contended in the written statement that their signatures were taken on blank paper, but the contents of the CM were not written. When there is so much of, when that is so much, the plaintiff bank has to prove the said contention. This court is of the opinion that to mere admission of the signature of the letters of the defendant number 2 does not absolve the burden of the plaintiff bank to prove the same. But the plaintiff bank had not made any efforts to prove the same. Further, this court is of the opinion that when the plaintiff bank had contended that there was a forgery and falsification of document, the burden is of the plaintiff bank to prove that whose signature was forged and which documents were falsely created by the document number 1 and 2. But the plaintiff had failed to make any efforts to obtain report of any handwriting expert regarding alleged forgery. For the aforesaid reasons, this court of the opinion that the plaintiff bank had failed to make out a case that the defendant number 1 and 2 in collusion with each other had submitted false bills and made wrongful gain by getting the amount of from the plaintiff bank. In the absence of such efforts being made by the plaintiff bank, this court is of the opinion that the plaintiff bank had failed to prove that the defendant number 1 and 2 in collusion with each other created documents and made wrongful gain. Further, the plaintiff bank had failed to prove that the defendant number 2, without printing and supplying the petition, is submitted false bills as contained by the plaintiff. For the reasons discussed above, the plaintiff 1 and 2 are answered in negative. The learned advocate for the plaintiff bank had argued that the suit of the plaintiff is not barred by
the document admitting the without material, without order, supply was made and the defendant number 2 ಏನು ಹೇಳಿದಿರಿ ನೋಡಿ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಇಸ್ ಆಫ್ ದ ಒಪಿನಿಯನ್ ದಟ್ ಬ್ಲಾಂಕಿಫೈಡ್ ಹೆಡ್ ಪ್ರೂವ್ ಟು ಕೊಲ್ಯೂಷನ್ ವಿತ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 1. ಇಲ್ಲೇನ ಸಮ್ವೇರ್ he has admitted defend number 2 admission only ಇಲ್ಲಿದೆ ನೋಡಿ para 36 ಅಲ್ಲಿ letter said to have been submitted by the defend number 2 admitting their liability regarding furnishing false vouchers and bills to make lawful gain ಅಂತ ಏನು admitting ಅಂತ ಇದೆಯಲ್ಲ ಅದೇ ಅದು
document number
DW2 has admitted ಅಂತ
ಅದೇ DW2
ಯಾವುದು ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ನಮ್ಮ ಡಿಸ್ಕಷನ್ ಎಲ್ಲ ಮಾರ್ಕ್ ಮಾಡಿದ್ದು
ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕ್ ಮಾಡಿದೆ ಸರ್.
ಅದೇ ವಾಟ್ ಇಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್
ನಂಬರ್
ಎಕ್ಸಿಬಿಟ್ ಯಾವುದು ಅದು
ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ ಎಕ್ಸಿಬಿಟ್ P1083 letter dated 16/10/97.
ಅದು ಒರಿಜಿನಲ್ 1083 ಇರೋದೇ 1082 ಡಾಕ್ಯುಮೆಂಟ್. ಲೆಟರ್ ಡೇಟೆಡ್ 16/10/97
ಹೌದು.
ಇದು OS 171 of 98. ಕೊಡಿ ಮೇಡಮ್ ನೋಡೋಣ. ಎಕ್ಸಿಬಿಟ್ 1083 ಎಲ್ಲ ಕಾಮನ್ ಎವಿಡೆನ್ಸ್.
ಎಲ್ಲ ಕಾಮನ್ ಎವಿಡೆನ್ಸ್, ಎಲ್ಲದರಲ್ಲಿ ಕಾಮನ್ ಎವಿಡೆನ್ಸ್. The 4 cases, they have paid the amount, and these 3 cases, these people have come.
Parties are also common.
All parties are different. Stationers, suppliers are different, but they are all close relatives of the PW1. It has come on record.
PW1.
Sorry, they're
DW1.
DW1, they're in OA, OS.
One is a bank employee.
Bank employee.
Ah.
Bank employee means why he is a bank employee, but these all forgery aspect are in the department inquiry is proved, my lord.
Huh?
Forgery ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Not the forgery, but creation of fake bills.
ಅದು ಎಲ್ಲ inflation, creation, bogus bill, ಎಲ್ಲದಕ್ಕೂ he is responsible. And without supplying stationery, he has passed the bill.
ಸಪ್ಲೈ ಇಲ್ಲ ಅಂತ ತೋರ್ಸಕ್ ಏನ್ ತೋರ್ಸಿದ್ರಿ ನೀವು ಡಾಕ್ಯುಮೆಂಟ್? ಅವೇನು ತೋರ್ಸೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಫಸ್ಟ್ ಅಪ್ಲೈಡ್ ಕೊಟ್ಟು.
ಅಲ್ಲ, ಆ ಲೆಟರ್ ರಿಜಿಸ್ಟರ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಬಟ್ ದೇರ್ ವಿ ಹಾವ್ ಪ್ರೊಡ್ಯೂಸ್ 1087 ಆಲ್ ವೋಚರ್ಸ್.
ಇವೆಲ್ಲ ಬಿಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವ್ರು ಕೊಟ್ಟರ ಬಿಲ್ಸ್.
ಅದು ವೋಚರ್
ನಿಮ್ ಸ್ಟಾಕ್ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಲ್ಲ, ಯಾವ್ದಾದ್ರು ಸಪ್ಲೈ ಆಗಿದೆ ಯಾವ್ದಾದ್ರು ಸಪ್ಲೈ ಆಗಿಲ್ಲ ಸ್ಟೇಷನರೀಸ್ ಅಂತ.
ಅಲ್ಲ, ಇದ್ ಮಾಡಿದವರು ಸ್ಟಾಕ್ ರಿಜಿಸ್ಟರ್ ಅವ್ರು ಬಂದು ಬಿಡ್ತಾರೆ. ಅದು ಸ್ಟಾಕ್ ರಿಜಿಸ್ಟರ್ ಮೇಲೆ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ, ಬಟ್ ಫ್ಯಾಕ್ಟ್ ಈಸ್
ನಿಮಗೆ ಬ್ಯಾಂಕಿಗೆ ರಿಸೀವ್ ಮಾಡಿದ್ಕೆ ಒಂದು ಎಂಟ್ರಿ ಇರ್ತದೆ,
ಅದು ಇರುತ್ತೆ.
ಸ್ಟೇಷನರಿ ನೀವು ರಿಸೀವ್ ಮಾಡಿದ್ರಿ ಮಾಡಿಲ್ಲ ಅಂತ ಆ ರಿಜಿಸ್ಟರ್ ಹಾಕ್ಬೇಕಿತ್ತು.
ಅಲ್ಲ, ಅದನ್ನು ಬರೆಯೋರು ಇವರೇ ಅಲ್ವಾ, SRD ಪೈ ದಿಸ್ ಪರ್ಸನ್ ಓನ್ಲಿ, ಹಿ ಇಸ್ ಇನ್ ಚಾರ್ಜ್ ಆಫ್ ದ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಆಯ್ತು, ಅವರೇ ಆಗ್ಲಿ, ಬಟ್ ಬೇಕಲ್ಲ ಎಂಟ್ರಿ.
ಅದನ್ನ ಬೇಕು, ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ, ಇದಲ್ಲ
ಮಾಡ್ಬೇಕಿತ್ತಲ್ವ, ಅದು
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಇಲ್ಲಿ ಓನ್ಲಿ ನೀವು ಬಿಲ್ಲು ಬರೀ ಕಾರ್ಬನ್ ಕಾಪಿ ಆಫ್ ಬಿಲ್ ಹಾಕೊಂಡು ಮಾರ್ಕ್ ಮಾಡಿಸಿದ್ರಿ ಅಷ್ಟೇ, ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ರಿಸೀವ್ಡ್ ದಿ ಅಮೌಂಟ್.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಮಾಡಿದಾರಲ್ಲ, ಇದರಲ್ಲೂ ಅಷ್ಟೇ 2 ಕೇಸಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ, ವಿ ಹಾವ್ ಡನ್ ಅಂತ ಹೇಳಿ.
ಇದ್ರಲ್ಲಿ ಏನಿದೆ ಅಡ್ಮಿಷನ್, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. 1083 ಎಕ್ಸಿಬಿಟ್. Regional Manager, SRD HO. We are in receipt of your letter dated 6/10/1997. I would like to inform you that I am going to pay rupees 33,886.
That is another case, my lord.
On or before 22/10/1997.
That's second case.
Adjust my
first case.
Printing bill for the above amount. ಯಾವ್ದಕ್ಕೆ ಇದು 33,000?
ಅದು second case. Second, that is Vasant Prabhu, that is
second case ಆಯ್ತು. ಇದರಲ್ಲಿ where is that admission that the without the supply of stationery bill was placed on record ಅಂತ ಹೇಳಿದೆ ಇಲ್ಲಲ್ಲ. ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇಲೆ ಹೆಂಗೆ ಡಿಗ್ರಿ ಕೊಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ, ಅದು
this is only with regard to
payment has not been made, I am due to pay. Supply that
the Shankar Printers.
That is second case, my lord. That is second, that another appeal.
ಆಯ್ತು, ಇದ್ರಲ್ಲಿ ಏನು ಯಾರಿಗೆ ಇವರು ಡಿವಿಷನಲ್ ಮ್ಯಾನೇಜರ್ SRD HO ಅಂತ ಇದೆ.
ಅದೇ ಬ್ಯಾಂಕ್ನವರಿಗೆ,
ಅವ್ರಿಗೆ
ಬ್ಯಾಂಕಿಗೆ ಬರ್ದಿರೋದು
33,886 ರೂಪಾಯಿ ನಾನು ಕೊಡ್ಬೇಕು ಅಂತಾನ?
ಹೌದೌದು.
ಅದೇನದು ರಿಗಾರ್ಡಿಂಗ್ ಎಕ್ಸೆಸ್ ಕ್ಲೈಮ್ ಏನಕ್ಕೆ ಅಂತ?
ಅಲ್ಲ, that because he has not, that letter is that you are not supplied and bogus bill ಅಂತ ಹೇಳಿ, ಅದಕ್ಕೆ that I have to give so much money ಅಂತ ಬರೆದಿದ್ದಾರೆ ಅವರು ಅಷ್ಟೇ ಆ ಕೇಸಲ್ಲಿ. ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ
ಸರಿ, ನಿಮ್ ಲೆಟರ್ ಅಲ್ಲಿ ಇದೆ, ನೀವು ಅದಕ್ಕೆ
ಅದೊಂದು ಲೆಟರ್
ಇದ್ರಲ್ಲಿ ನೋ ರೆಫರೆನ್ಸ್ ಅಟ್ ಆಲ್ ಯುವರ್ ಲೆಟರ್. ವಸಂತ ಪ್ರಭು ಇದು ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ನಾ?
ವಸಂತ ಪ್ರಭು is another case, defend number 2.
Another case,
not this case. This case ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ.
ಈ ಕೇಸಿಗೆ ಮತ್ತೆ ಯಾವುದು ಡಾಕ್ಯುಮೆಂಟ್?
ಅದೇ ಲೆಟರ್. ಒಂದು ನಿಮಿಷ ನಾನು ಹೇಳ್ತೀನಿ. ಲೆಟರ್ ಎಕ್ಸಿಬಿಟ್, ಅದೇ ಲೆಟರ್ ಅಲ್ಲ, ಎಕ್ಸಿಬಿಟ್ ದ ಸಪರೇಟ್ ಲೆಟರ್ ಇಸ್ ದೇರ್.
ಯಾವುದು? ಅಡ್ಮಿಟಿಂಗ್ ದಿ ಲಯಬಿಲಿಟಿ. ಆಯ್ತು, ಪಾಯಿಂಟ್ ನಂಬರ್ 3 ಹೋಗಿ ನೋಡು ಈ ಅಪೀಲ್ ಅಲ್ಲಿ. That is regarding limitation.
ಅದಕ್ಕೆ ಅವರು they said there is limitation, it is not barred by limitation. As per section 71 limitation and the case of fraud cases, mistakes.
I have read the
Right.
point number 3. Point number 4 and 5.
The court is of the opinion that the perusal of the impugned judgment of the trial court goes to show that the trial court had failed to appreciate the evidence in a proper perspective. The trial court had failed to consider the fact that the plaintiff bank had failed to prove its case by leading cogent and corroborative evidence. This court had considered the fact that the plaintiff bank had failed to make any grounds regarding the proof of fraud and forgery and falsification of documents by leading cogent and corroborative evidence. The trial court had failed to consider these aspects and wrongly declared the suit. The trial court had failed to appreciate the fact that the plaintiff bank has failed to produce stock register evidencing the printed stationery supplied by the defendant number 2 and it is issued to other sections of the bank. Further, the trial court has also failed to consider the fact that through the plaintiff bank though the plaintiff bank is conducting audit of its SRD section periodically, but none of the audit reports are produced before the court to prove that defendant number 2 in collusion with the defendant number 1 without printing and supplying the stationery have raised bogus bills and obtained monetary and made wrongful gain. The reasons assigned by the trial court in decreeing the suit are not proper. Further, the court is of the opinion that the trial court had failed to discuss regarding the bar of the suit against the defendant number 1 in OS number 61/2002. But this court has the opinion that suit is against the defendant number 1 in OS number 61/2002 is not barred by time. As such, the court is of the opinion that impugned judgment of the trial court is perverse, capricious, and unsustainable under the law, and there is necessity to intervene in the impugned judgment of the trial court. For the reasons discussed above, the point number 4 and 5 are answered in the affirmative. For the reasons discussed above, the following order is passed. RA number 25, 26, 27 are allowed with costs. RA number 28, 2017 is allowed with costs to the respondent number 1. The suit filed against the defendant number 2 in OS number 61, 7 and 171 are hereby dismissed with costs. The suit OS number 61/2000 is against the defendant number 1 is decreed and cost to plaintiff bank, and the suit is against the defendant number 2 is dismissed with cost defendant number 2. Send back the trial court records along with the copy of the judgment of forthwith.
But here suit is decreed against defendant number 1. Suit of OS 61/2002.
Yes, my lord.
As against the defendant number 1 is decreed with cost to plaintiff bank.
Plaintiff bank.
And suit as against the defendant number 2 is dismissed with cost of defendant number 2.
Yes, my lord.
But appeal filed by whom?
Appeal filed by bank, defendant number 1.
He appeal bank appeal.
Bank appeal. Bank has filed this appeal. All the 3.
That is in respect of dismissal of the suit against defendant number 1.
Yes.
Only one appeal by bank.
ಇಲ್ಲ 3 appeals ಅಲ್ಲ, one appeal. This appeal.
ಇಲ್ಲಿ RA ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
RA ಹೌದು.
RA ನಲ್ಲಿ ಸಿಂಡಿಕೇಟ್ ಬ್ಯಾಂಕ್.
ಹೌದು.
ಓನ್ಲಿ ಅಪಲೆಂಟ್ ಇನ್ ಅಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದು. ಈ ಅಪೀಲ್ಸ್ ಎಲ್ಲ ಫೈಲ್ ಮಾಡಿದೆಲ್ಲ ಡಿಫೆಂಡೆಂಟ್ಸ್ ತಾನೆ. ಈ ಅಪೀಲ್ RA appellate court. ಎಲ್ಲ by defendants. How can appellate court can modify the judgment when there was no appeal by the bank? The suit in OS number 61/2002 as against the defendant number 1 is decreed with cost.
61 decreed with cost.
Bank nor suit appeal hakilvalla. When the suit was dismissed against the defendant number 1, no appeal was filed by the bank.
Defendant number 1 as original suit ಅಲ್ಲಿ that employee.
ಹೌದು. ಅವನ ಮೇಲೆ ಏನಾಯ್ತು ಸೂಟ್?
ಅವನ ಸೂಟ್ ಎಲ್ಲ ಅದೇ ಅವನ ಸೂಟ್ ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗೋಯ್ತು.
ಅದ್ರ ಮೇಲೆ ನೀವು ಅಪೀಲ್ ಹಾಕಿದೀರಾ ಅಂತ ಕೇಳಿದ್ವಿ.
ಇಲ್ಲ ಅದೆಲ್ಲ ಹಾಕ್ಲಿಲ್ಲ.
ಮತ್ತೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ವಿತೌಟ್ ದಿ ಬ್ಯಾಂಕ್ ಅಪೀಲ್ ಹೌ ಕ್ಯಾನ್ ದಿ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಗ್ರಾಂಟ್ ದಿ ಡಿಕ್ರಿ ಅಗೇನ್ಸ್ಟ್ ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 1? Suit in OS number 61/2002 as against the defendant number 1 is decreed with cost.
Yes, ma'am.
To plaintiff bank ಅಂತಿದೆ. ಅದೇ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಇದರಲ್ಲಿ 3 ಜನರು ಇದ್ದಾರೆ. ಇದರಲ್ಲಿ ಡಿಪೆಂಡ್ ನಂಬರ್ 1 is that ಇದು ಸ್ಟೇಷನರಿ ಓನರ್ ಸತೀಶ್ ನಾಯ್ಕ್.
OS 61 ಅಲ್ಲಿ ಯಾರ್ರಿ?
OS 61 ಅಲ್ಲಿ ಹೇಳ್ತೀರಾ ಸ್ವಾಮಿ?
ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಯಾರು?
ಸತೀಶ್ ನಾಯ್ಕ್. he is supplier. Number 2 is that Umesh Pai, that is employee
of the bank.
Employee of the bank.
ಎಂಪ್ಲಾಯ್ ಆಫ್ ದಿ ಬ್ಯಾಂಕ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಇದರಲ್ಲಿ ಡಿಕ್ರಿ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಅದೊಂದು ಕೇಸಲ್ಲಿ ಮಾತ್ರ.
ಒಂದು ಕೇಸಲ್ಲಿ ಮಾತ್ರ, ಇನ್ನೆರಡು ಕೇಸಲ್ಲಿ ಇಲ್ಲ.
ಬಟ್ ಆ ಕೇಸಲ್ಲಿ ಏನಾಗಿತ್ತು? OS ಒರಿಜಿನಲ್ ಡಿಕ್ರಿನಲ್ಲಿ
Original decree,
61 ಅಲ್ಲಿ.
original decree ಅಲ್ಲಿ it is against only that your stationery.
ಸರಿ ರೀ, ಅವನಿಗೆ ಆಗಿತ್ತು, ಮತ್ತೆ ಯಾಕೆ ಇಲ್ಲಿ ಮತ್ತೊಂದ್ಸರಿ ಡಿಕ್ರಿ ಮಾಡ್ಬೇಕು ಅಂತ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಗೋ ಟು ದಿ ಒರಿಜಿನಲ್ ಜಡ್ಜ್ಮೆಂಟ್.
Original judgment is in.
OS 61 of 2000 is decreed in part ಅಂತ ಇದೆ. All are decreed. 1, 2, 3, 4, 5, 6, 7. ಏನದು in OS number 137 of 98, defend number 1 personally and defend number 3 to 9. To the extent of assets of deceased Haridas Bhatt in their hands. Defend number 2 in OS number 60 liable to pay sum of rupees 1 lakh.
Same my lord.
Defend number 2 ಅಂದ್ರೆ ಅವನ್ ಬ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯ್ ನಾ?
Defend number, ಅಲ್ಲಿ defend number 1 is bank employee. Defend number 2 is this station, that person who has separated stationery.
Original suit ಅಲ್ಲಿ OS 61. ಹಾ. Decree was passed against defend number 2. ಹೌದಲ್ಲ?
ಹೌದು.
How can the appellate court can reverse the same in an appeal filed by the appellant? ಇಲ್ಲಿ ನೋಡಿ. OS 61 of 2 ಅದರಲ್ಲಿ defend number 1 is decreed with cast ಅಂತ ಮಾಡವ್ರೆ. ಡೈವರ್ಜೆಂಟ್ ಆಯ್ತಲ್ಲ ಅದು. ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ decreed against defend number 2.
ಹೌದು.
That is modified in the appeal against defend number 1 and exonerated the defend number 2. But this appeal was filed by the defend number 2 alva.
Appeal is filed by defend number
2.
2.
Dishonor of dismissal of the suit. You are not challenged. Suit was granted, decree was granted against defend number 2. He had filed the appeal. But you have not filed any appeal against defend number 1 in dismissing the suit. How can the appellate court can modify and fix the liability on the defend number 1 without your appeal? ಸ್ವಲ್ಪ ಎಲ್ಲ ಕನ್ಫ್ಯೂಷನ್ಸ್ ಇದೆ ನೋಡಿ, ಮಾಡಕ್ ಬರಲ್ಲ. You have not filed any appeal against defend number 1. How can they fix the appellate court liability on the defend number 1, exonerating the defend number 2 by allowing the defend number 2 appeal? You are not challenged. Dismissal of suit against defend number 1.
ಆಯ್ತು.
ಅಲ್ವಾ?
ನೋಡ್ಕೊಂಡು ಬರ್ತೀನಿ.
ನೋಡಿ OS 61.
61 ನೋಡಿ.
That's the reason I am asking repeatedly questions to you.
ನಾಳೆ.
Day after tomorrow. Totally. Heard in part. This matter day after tomorrow.
One passover ಇದೆ.
ಇನ್ನೊಂದು ಪಾಸ್ ಓವರ್ ಇದೆಯಾ? ತೋಳಿ ಯಾವ್ದು?
6.
ಸರಿ, ನಂಬರ್ ಎಷ್ಟು? 60.
66.
Connected matters. Reply ಅಲ್ಲ? Reply. Yes.
My case is declaration, declare that the sale deed dated 26/2/2004 is null and void and for injunction. On the ground that your lordship can say the original owner in respect of survey number 38, that is total extent is 1 acre 10 guntas, belongs to Chikamuniappa. There is no dispute for that. Then thereafter your lordship may formed a layout and consisting of several sites. He sold the sites to several persons. Here your lordship can see the page 7 of the plaint. wherein the property number is mentioned, site number 1, formed in survey number 8, and the specific schedule is
Number
mentioned.
38 ಇರ್ಬೇಕು ನೋಡಿ. Survey number 38.
Survey number 38, that is ಖಾತಾ number 38, survey number 38 ಅಂತ ಮಾಡಿದ್ದಾರೆ. Property number 1, that is site number 1, measuring 40 by 40. Then schedule your lordship can see east by property bearing number 2, then private property west, north by road, and south by private property. There are lordship can see admitted.
There was a sale agreement, exhibit P1.
Yes, exhibit P1, that is the sale agreement. Exhibit P1 is the sale agreement. Exhibit P2 is the power of attorney executed on 19/5/86. Then exhibit P3, the affidavit stating that they have received the entire sale consideration on 19/5/86. Then thereafter, your lordship can see that the Narayanappa, who has obtained the sale agreement and the power of attorney, who is the husband of this plaintiff, has constructed the buildings. While exhibit P17 and 18, the photographs to show that I have constructed the building. Then thereafter, your lordship can see he executed in a registered sale deed dated 19/8/2006 in favor of his wife. And immediately, that is on 22/8/2006, a rectification is made, rectifying that in the schedule that the constructions was there.
Including the structure.
Please, then your lordship can see, my learned friend argued that he has filed several suits and several defenses taken, and your lordship can see that like that he is argued. That your lordship can kindly see the exhibit D1, OS number 6075 of 2005, wherein the property is entirely different and the parties are entirely different. Exhibit D1, my lord. Sorry.
In OS?
OS 675 of 2005. Here our lordship can say the plaintiff's husband, Narayanappa filed, claiming that he is the owner of site number 38, formed in survey number 38, not site number 1. And your lordship will see the boundaries. Here measurement is also different. Site measuring 35 by 37. Here east by land belongs to Lakshmamma, west by road and Ramakrishna factory, and north by remaining land of same survey number, and south by remaining land of same survey number. This schedule and that schedule is entirely different. It clearly shows that they are two different properties. Here my learned friend argued that he is claiming that this property and that the property in the original present suit also one and the same. Absolutely, it is false. That is the entirely different property. Here he has stated that he.
OS 675 of 2005 filed by whom?
Narayanappa, my husband.
Your husband?
Yes. He said that the Munivenkatappa is the owner of survey number 38. He formed a layout. And one such site is executed sale deed in favor of one Sinappa under the registered sale deed dated 21/3/86. Then in turn Sinappa is executed a power of attorney and sale agreement in favor of him. That is his case on that case. But your lordship can see in that case that is not decided on merits, that the dismiss for default. Then your lordship, if one more suit was referred by my friend is 31/36 of 2006, that is exhibit D4. One Durvas filed a suit against the original owner Chikkamuniappa, including this Narayanappa. Wherein also, my lord, the property which was claimed in OS number 676, 675 of 2005, the same property was included. Here your lordship kindly the schedule, it is a suit for specific performance. He claims that Narayanappa is the owner. Nowhere he has stated that the defendants are the owner. In all suits, my lord, Narayanappa is the owner.
What is that suit number?
Suit number is 31/36 of 2006.
30?
136 of 2006, filed by one Durvas for a specific performance. That is site number 38. Then the schedule is, the measurement is 35 by 37. Then east by land belongs to Lakshmamma, west by land belongs to Ramakrishnappa, north by road, south by remaining land. These properties are entirely different from the property mentioned in the source, the present source. Now, Your Lordship, these source will not come into a way to decide the case on merits. Then Your Lordship may kindly see, that is Exhibit D15. That is the sale deed which was executed by Bunivengtappa, Chikkamaniyappa, in favor of Dhanalakshmi. What is the property was executed, Your Lordship? See, that is also a different property. Sale deed. Wherein also Your Lordship can see the boundaries and measurement is entirely different. All these documents was not considered only on the ground that he has filed a different source and different contention has been taken. Because of that reason, suit kept to be dismissed. All these properties are entirely different because survey number 30, it consisting of 1 acre and 10 guntas, several sites formed by him. It is admitted fact, and one of such sites are purchased. Then most important thing is Your Lordship can say that the original owner has denied the execution of the agreement of sale, affidavit and the power of attorney. For that Your Lordship can say handwriting, the matter was, the documents were referred to the handwriting expert, and the handwriting expert was given an opinion that the signatures and admitted signatures and disputed signatures are one and the same. Then in one more thing, my learned friend argued that the affidavit which is executed, according to my learned friend, it is executed before the Additional Judge Court of Small Cases, Bangalore, and the seal is mentioned as a magistrate court, Metropolitan Magistrate Court. Your Lordship can say wherein a small causes court seal is also available. How this magistrate court seal is came forward, I don't know. Your Lordship may kindly say the small causes court seal is also available. In view of this, my Lord, all these documents were sent to the forensic, and comes to the conclusion that all the signatures are made by these vendors of the defective owner, original one. That's all.
My reply to this, Your Lordship may kindly see the plaint schedule, plaint filed by the, for this 9741, para 9 of the plaint. May I read to Your Lordship what my learned friend is entirely different and other things. It is submitted that one portion of the ground floor was let out to 4/3/2000 for the father of the first defendant, Sinappa. Now the said Sinappa was residing in somewhere else now. The family members of the first defendant are residing there. The defendant number 1 somehow obtained all the details of the scheduled property and within an intention to defraud and grab the property of the plaintiff's husband has contacted the second defendant, politely speaking with his feet work with the said Chikkamaniyappa and requested him and signed as a witness some document before the registrar. Accordingly, with the modified intention, grabbed the scheduled property on 26/2004 without intimating anything to second defendant, fraudulently obtained signature on the original sale date 26/2003. My learned friend says that it's entirely different property. They themselves admitted. They themselves admitted. I'm not, it is not my client. It is their client. If that is the case, my lord, the question of different property does not arise under law. They have in a plaint filed by him, exhibit P50, P50, D1, D2, D3, their own plaint, the dimensions and numbers are one and the same. For that, this is an admission. I recite the judgment and other things. It is not a different scheduled property. They themselves admitted in their own plaint. I'm not disputing. Their own plaint earlier filed. Their own kith and kin files for specific performance. Same scheduled property. If that is the case, then it's not a different schedule.
Yes,
It's the same schedule.
reserved. ಆಯ್ತಲ್ಲ ಮೇಡಮ್ ಎಲ್ಲ?
The original exhibit P20 and 23 regarding
ಎಲ್ಲ ಒಟ್ಟಿಗೆನೆ
general purpose attorney and
HRRP ನ ಸೇಮ್ ಇದ್ರಲ್ಲಿ ಏನ್ ರಿಸಲ್ಟ್ ಬರುತ್ತೋ ಅದು HRRP ಅಷ್ಟೇ. ನಾಳೆನಾ? ಅದಾ? ಹಾ.
ಯಾವ್ದು ಹಾಕ್ತಾರೋ ಇದು ಇದೆಲ್ಲ ಇದು ಇದೆ ಅದು ಇದೆ ಯಾವ್ದು ಹಾಕ್ತೀರಿ?
ಕೊಟ್ಟೆ.
ಮೇಡಮ್ ನಾಳೆ ಬರೋದು. ಹಾ